original testator and son.
Death certificates of two persons.
Person.
When did you apply?
I have applied on the last month.
Last month.
Thereafter, I filed the writ petition, my lord. It's urgent, my lord. 84 years aged person.
Is it appearing in the list?
Yes, my lord. In the monthly list. I mentioned. I have indicated.
Put it as upgraded motion, not upgraded, urgent motion. Which is the item number?
Item number 923 and 924.
923, 924.
My lord, I am handing over the slip.
No, don't hand over.
My lord, under
The number
compelling
is enough.
circumstances, my lord, under compelling circumstances, my lord, mentioning, my lord, for unauthorized construction, my lord, the Bonga municipality itself making unauthorized construction, encroaching my property, my lord. And after service of notice, they have speed up their progress, my lord. So, my lord, kindly take up the matter. Is today's list, my lord, item number 90, my lord.
এই বিশুবাবু রয়েছে না? এই না বিশুবাবুকে ডাকুন তো। এই কি বলে স্ক্রিনটা একটু এদিকে সরানো যাবে?
In unauthorized my construction, encroaching my property, my lord. And after service of notice, they have speed up their progress, my lord. My kindly take up this matter.
What is the construction that is being made?
My lord, I don't know, maybe some beautification, my lord.
Beautification?
Yes, my lord. In front of my entire and my ingress egress has been blocked, my lord. And also encroaching my property, my land.
Why don't you approach the civil court? Why over here? What will this court do?
My lord, without any, my lord, Bonga municipality is taking itself, my lord, illegal construction.
So against a municipality, a suit won't lie.
My lord, but my lord, the speedy disposal, my lord, before lordship. Otherwise, my lord, they'll complete the construction, and I have, my lord, my ingress egress totally blocked, my lord.
Where is the matter?
Item number 90 of today's list, my lord.
90?
90.
Urgent motion top.
Lordship.
May I take your lordship's kindly to mention item number 125 of your lordship's list, my lord. My lord, unauthorized construction is going on.
Please come next month.
My lord, I am mentioning this matter to kind leave of your honor. I have challenged a self-demolition order from the Howrah Municipal Corporation. 17th is the date fixed for demolition, my lord.
Self-demolition order.
Self-demolition order dated 17th April 2023. But personnel of Howrah Municipal Corporation came in the property suit local and informed us to vacate the premises, and they will come on
Because
17th.
it is self-demolition, why will they come to vacate your premises?
I am challenging this. I don't have this order with me. Only on the last Friday, I have received this order.
Which order? Self-demolition.
Self-demolition order.
Self-demolition, they will not come to demolish.
But they asked me to vacate the premises, and they will come on 17th, my lord, to demolish the premises.
Then how can it be self-demolition?
Self-demolition notice is dated 17th April, my lord.
No, you are going wrong somewhere. Please check up and then come.
My lord, 17th is the date fixed, my lord, for demolition. Kindly
Then
take
it's self-demolition.
They have come and came and informed us that they will.
But two things are absolutely opposite to each other. One is you demolish, the other is corporation demolish.
Demolition notice was there, but as I have not self-demolished the property, they will come.
Yes.
This is.
So it is not self-demolition, you
no.
failed to demolish.
My lord,
Yes.
and I have challenged this order,
When was
self-demolition
the
order.
original order of demolition passed?
17th April.
No.
My lord, I was not able of this order, my lord.
Very well. Serve notice upon other side.
My lord.
Leave. Urgent motion day after tomorrow.
My lord, may I permit to mention my contempt application, my lord?
For?
Contempt application
For what?
for inclusion in the list.
Come next month.
I request the item number 451 is running in the list, my lord. My lord, they are after receiving the notice, my lord, they have stopped their functioning, my lord. But just last 2 days before, my lord, they are starting construction. So for this reason, my lord, this is urgent matter.
Please
So,
come next month.
Just fix the matter. Otherwise,
Next month. Come next month, we will fix it.
kindly see-
Yes, let the list be published for the next month. We will arrange. What is the error?
19th
Lordship passed this order for correction, my lord. Lordship, my lord, the father of the petitioner, the petitioner retired from service. You know, I corrected this order with 3 matters, my lord, same. I also correct this order.
Give correction. Give the
Item,
correction that is to be made.
my lord, item number 137, it is matter relates to the unauthorized construction, my lord. My lord, private respondent taking advantage of the situation that I inducted her as a tenant, and taking advantage of that situation, he
Please come next month. Yes,
My lord, may I be permitted one contempt application, very old, my lord.
very well.
1990,
You want inclusion?
No, for inclusion.
Come next month.
Inclusion in the list, my lord.
Come
Very
next
old,
month.
very old matter, my lord.
Very old, how old?
1990 matter,
Does this bench have determination?
lordship.
Up to 1997. Come next month. This week we do not have time.
Maybe Lordship, time this to mention one matter, Lordship. Item number 136 is today's monthly list, Lordship.
Today's monthly list.
Today's list, Lordship. And they have continuing their construction, Lordship. After filing the writ petition, they have constructed the second story building.
Oh, we will bring it down. Come next month. Yes.
My lord, in last occasion, my lord, in Somen on this matter, my lord, there is inadvertent error, my lord, because of the name of the advocates, because in the order sheet, it is recorded, the learned advocate appearing for the respondent submits that copy of the application was served upon them yesterday. And Somen is my chamber's matter, my lord. So that was my submission when, my lord, the advocate's name is wrongly recorded, my lord.
Let me see once.
Because now everything is
One
gone.
minute, 1 minute. It is the respondents who submitted that the application was received later on. So where is the error?
Yes, the advocate's name, because the set of advocates is Ramesh Malik's advocate, and that was the submission of mine, my lord. That's why, my lord. That is Somen Nondi matter is from my chamber, my lord, and that was the
No, no. The set of advocates mentioned for the petitioner will change.
Yes, my lord. Yes, my lord.
Starting from Mr. Bhattacharya.
Mr. Bhattacharya is my senior. That is all right, and
But thereafter, everybody will go.
yes.
Whose name will come?
I handed over the copy. I handed over because that's not my submission, and nowadays, my lord, everything in streaming, my lord. That's why, my lord, that's the problem. These sets of advocate for Ramesh Malik, my lord.
It is up to you whose set. I know the matter. I do not know.
Yes,
whose
because,
set.
my lord, everything is YouTube in the. It was my submission, my lord, and that is recorded, my lord. That's why.
Nothing to be changed in the order of
No.
the appearance. will
Yes.
change.
Because that was my submission. It is
I
served
got
upon
it.
my office. That's why, my lord.
এটা clip করে রাখুন, tomorrow is to be made. No, we can do it today itself. Keep it
Yes,
with you. We have the matter.
Yes. Item number 2 in today's.
Yes, today we'll correct it.
Yes.
Yes,
My
call
lord,
the list.
Great.
I beg to appeal for the respondent number 8.
Yes.
Not a small error, my lord.
Where this is for correction of the error. Where is the petitioner? What is the error?
Lord, the error is on the first paragraph in the last line. In the date 17/2/2007. Only that.
The matter has appeared in the list for correction of a typographical error, which cropped up in the order dated 25th April 2023. Stop.
Lord, the second page also.
The date mentioned in the last line of the first paragraph
And third page,
and the
fourth.
second line in the last paragraph. Last line, first paragraph, page 1, and second line, last paragraph. Second line, last paragraph, and last line, last paragraph. No, it's only in the first page it will be changed. The others are all right.
That's all right. Others all right.
Only one.
Those.
Only
Other-
one. The last line in the first paragraph of page 1, the date should read as 17th February 2007. in place and instead of 17th February 2017. Rest of the order remains unaltered. Department to carry out the necessary correction at once.
Malad, the petitioners purchased Malad 7 small plot. Then Malad he applied for the amalgamation. But it was found that it was under the consideration of the Malad Heritage Committee. With the permission of the Heritage Committee, amalgamation has been given. Now, Malad, on our we approach your lordship directed on earlier occasion, lordship directed the authorities to take a decision. They have taken the decision that this is a Malad grade 3 heritage. But in grade 3 heritage, according to the corporation, Malad, the construction is permissible with some condition. We have applied for the Malad sanction of building plan. Our grievance is that is not being considered.
When did you apply?
Malad, we have applied, Malad Lordship, kindly come to my representation. There the dates are there. That 38. 33 application for necessary permission for developing the permission is of April 2022.
Where is the receipt showing submission of the proposed plan?
Malad, submission, it is Malad online application. Unless they decide to accept, they will not give anything. That is the system, Malad, my landlord senior knows.
Unless they
They
decide
will not
to,
open, they will not allow my application.
no, unless they decide to accept means it has not been filed as yet.
No, I have prepared, I have sent them manually, but I have to file Malad online application. Unless Malad, we are allowed by their portal, we cannot make application. That is the system.
You have filed it manually,
Malad,
physically
with this forwarding letter,
on?
Malad 18/4/2022,
Where do I get that?
Lordship page 38. হচ্ছে permissible কোন জায়গায় আছে উনি যে ঠিক আছে কি
Yes, corporation, any instruction?
Yes, my lord. But as far as I have got, my lord, Heritage Conservation Committee has cleared the matter.
Has?
Cleared the matter.
All right. How will the
My lord, your
petitioner
lordship.
get to know?
Yes.
How will the petitioner get to know?
No, petitioner has the knowledge of that. The Heritage Conservation Committee has passed the matter. Now that your lordship, since my lord, even thereafter, my lord, it has not been done, kindly direct, my lord, the respondents, my client, my lord, to consider the representation at P5, my lord, within a
Please come.
reasonable time.
The matter relates to sanction of building plan in respect of the premises numbered 32A, Elliott Road, Ward number 61, Borough 6, under jurisdiction of the Kolkata Municipal Corporation. Stop. The premises in question, no, not the premises, the structure standing at the aforesaid premises has been declared as heritage - grade 3. Stop. Next. The petitioner submits that the plan proposal was submitted physically in April 2022, but thereafter the corporation has not taken any steps for sanction of the plan submitted. Stop. Representation was filed by the petitioner in March 2023. Stop. The same is yet to be considered. Stop. Learned advocate representing Kolkata Municipal Corporation submits upon instruction that the Heritage Conservation Committee has already accepted the proposal of the petitioner and necessary consequential steps will be taken in the matter shortly. Stop. Next. As it appears that a final decision is yet to be taken by the
building department,
Kolkata Municipal Corporation,
building department.
accordingly, The instant writ petition is disposed of by directing the municipal commissioner to take a decision with regard to the plan proposal submitted by the petitioner for sanction in accordance with law, after giving reasonable opportunity of hearing to all the necessary parties, and pass a reasoned order and communicate the same to the parties immediately thereafter. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Writ
My lord,
petition
only
disposed
one
of.
thing, my lord. Instead of municipal commissioner, my lord may kindly direct the Director General of Building, my lord.
The municipal commissioner is the ex officio chairman.
Yes, yes, my lord, right,
As is
Then-
relates to Malad.
right, my lord. Still then, my lord, in so far as.
As it relates to heritage, I believe Malad MIC is the appropriate authority who will take final decision.
Yes,
are in
so let
council.
it go through the commissioner to
We
whoever
are in council.
authority.
As my lord.
Grateful to your lordship.
My lord, I am appearing for petitioner, my lord, with Mr. Chakravarti. In this matter, my lord, the petitioner before your lordship is a 75-year-old widow. And my lord, corporation people told her that there are dues of rupees 6 lakhs. And if she pays 1,51,000 during waiver period, she will get the benefit of penalty and interest. My client deposited 1,51,000, but unfortunately, it was deposited in the name of respondent number 6, who lives just opposite to her in the same building. The corporation people said that if respondent number 6 gives no objection, we will refund the money, or let there be a court's order. So your lordship kindly come to last annexure.
Respondent number 6, you are appearing.
I am appearing.
Yes,
Your lordship
This is
directed.
our report
yes, please give.
on the last occasion.
In our account also dues are showing, my lord. Now, my lord, how would I know that that amount has been deposited
My lord,
in my account? Because, my
Wait,
lord,
wait, 1 minute. Hearing access in our-
The SSC number is there.
we have confirmed it is deposited.
Yes.
We wrote him 2 letters. No response has been given.
Right.
In that circumstances, lordship, without the objection of the my lord SSC, in whose account it has been transferred, or my lord's order is required.
Has the amount direction of what is the value in scope for transfer?
It was deposited by bank draft.
We have said
151 has been credited to your account.
Yes.
Say you don't know it.
my lord, kindly see, my lord, bills are raised,
Bills are raised, you have got dues.
still it is showing that.
there might be higher dues also.
Yes,
Then
But
your dues must be higher than this.
let the corporation give a statement, because my lord, I don't know whether it has been credited to my account or not, because
The
that
corporation says it has.
now they are saying they have never said that earlier, my lord.
Very well, I'll record this. Please
They have
come.
they have only asked us. to
and my
come,
lord, we have written
Lordship-
official letter, my lord, this 5th item.
Did you not receive a letter from the corporation?
14/6
Letter, my lord, received, my lord, to come and meet the concerned department. My client is also 65 years old person, my lord. Now, my lord, they has to confirm by some writing that it has been deposited to my account.
Kindly, my lord, do it in this way. If it is deposited, it is confirmed, it should be, my lord.
Should be refunded.
Reported.
Yes. The petitioner is the person liable to pay tax in respect of the premises number 85/7/9 Minapara Road, bearing SSC number 21-005-1435-8. Stop. Due to inadvertence, the petitioner deposited a sum of rupees 1,51,000 rupees through 3 bank drafts in the SSC number 21-05-05-1356-1. Stop. After realization of the error, the petitioner applied before the Kolkata Municipal Corporation for adjustment of the money paid by her to liquidate the property tax dues on 12th August 2021. Stop. The corporation requested the petitioner to arrange for a no objection certificate from the owner of the
Official letter.
SSE in whose favor, no, not from the owner, from the SSE, from the SSE, in whose favor the money was credited. Stop. The corporation also issued a letter to the owner of the other property in whose favor the petitioner wrongly deposited the aforesaid amount. Stop. No response was received from the private respondent. Stop. The petitioner again applied before the corporation. Stop. An official proposal was initiated by the tax collector department. Now, by the Department of Assessor Collector, Tolly tax, seeking permission for transfer of the sum of rupees 1,50,000 rupees in favor of the petitioner. Stop. The Chief Municipal Law Officer opined that there is no scope for transfer of the said amount from one SSE to the other without the direction of the court. Stop. Next.
Or no objection should be received.
The corporation insists on a no objection to be issued by the private respondent. Stop. Learned advocate representing the private respondent submits that his client is not aware of any amount that was wrongly deposited in favor of the private respondent. Stop. Next. The private respondent claims that there is property tax due in respect of his premises, and accordingly it is not possible for him to ascertain as to whether any money was erroneously paid, erroneously credited in favor of the private respondent. Stop. Next. It appears from the submission made on behalf of the private respondent that he is not interested to issue any no objection certificate in favor of the petitioner. Stop. That being the situation, the Assessor Collector Tolly Tax Department is directed to adjust the amount which was wrongly credited in favor of the private respondent after proper ascertainment as to whether the bank drafts were actually issued by the petitioner for the purpose of clearing the property tax dues in respect of her own premises. Stop. Next. If required, the assessor collector shall arrange an opportunity of hearing, not arrange, shall afford an opportunity of hearing to the petitioner and the private respondent prior to effecting the adjustment. Stop. In the event the private respondent does not participate in the hearing, comma, it will be open for the assessor collector to proceed in the matter by deducting the amount of rupees 1,51,000 from the credit of the private respondent to the credit of the petitioner. Steps shall be taken in the matter at the earliest, but positively within a period of 12 weeks from the date of communication of this order. Stop.
May I pray for one?
The instruction forwarded by the assistant assessor collector, Tolly Tax Department, signed on 13th May 2023, be retained with the records.
The opportunity of hearing, my lord, will finally not leave it at the discretion of the, my lord.
I cannot hear you.
The opportunity of hearing, my lord, which your lordship is giving, my lord. Your lordship will kindly not leave it at the discretion of the tax collector, my lord. Let there be an opportunity of hearing, my lord.
It was mentioned if required. Delete if required.
After adjustment যদি বেশি টাকা হয় তাহলে রিফান্ড করতে
আরে আমাদের ডিউজ আছে, আপনি নিজে বলেছেন 6 lakhs।
এটা তো ওরা বলেছে,
ওরা বলেছে।
ইন্সপেক্টর এসে বলেছে।
হিয়ারিং হবে তো, হিয়ারিং হবে।
Anything else?
Yes,
Grateful lordship. We are for. May it please your lordship, no, this is my application. I am the owner of, my lord, a premises which is 6 bighas and odd.
Who is appearing
Mr.
for
Bishoy
the?
Pukati.
Yes.
I am the owner, my lord, of a premises which is 6 bighas and odd, out of which the lion's share of the premises has been leased out, my lord, to the private respondent against a declared amount of lease rent, which increases with the increase of certain periods. Now, my lord, this was allegedly not known to the Kolkata Municipal Corporation, and then they apparently made retrospective assessments of annual valuation, charging annual values on the basis of those increments of rents. But in doing so, my lord, they did one thing which was not warranted. The entire premises number, my lord, is one and the same. The unit of assessment is one and the same. What they did was, they took the leasehold premises which was granted under the lease, 5 bighas and odd, separately. They took its portion, took its annual value as into 12 of the monthly rent. Thereafter added a fresh component of 174.2 to arrive at the balance portion of the land. In effect, thereby making 2 assessments inside one premises, which is not permissible in law. 178.1 says that every land and building combined has to be treated as a single unit. Now, this cleavage of assessments is impermissible in law. That was the basic point that was urged in round 1 of the litigation before your lordship. Lordship found that while hearing, the hearing officer had not heard the lessee, had only heard me. Therefore, my lord was pleased, my lord, to pass an order date of your lordship, my lord, page 63, 7 November 2022, annexure P3,
Yes.
directing that because both the parties have not been heard, the occupier as well as the owner, the corporation should do this issue afresh. Now, my lord, and sent it back on remand with an order at page 65. In view of the above, the entire issue is remanded back to the respondent numbers 3 and 5, assessor collector and hearing officer respectively, to decide the issue afresh after giving a reasonable opportunity of hearing to the petitioners and the respondent number 6. Decision shall be taken at in the matter at the earliest, positively within a period of 8 weeks from the date of communication. Respondent shall pass a reasoned order, communicate the same to the parties immediately thereafter. A hearing was held, but only before the hearing officer and not before the assessor collector. Subsequently, my lord, we put in our objections similar to that with what I've stated before your lordship. Not thereafter, only the hearing officer, my lord, has dealt with this issue at page 78, annexure P7, the last annexure of my lord's brief. He has not gone into the aspect of the assessments at all. Kindly come to page 79, the last part.
What is to be done Affidavits has to be called
Has to
for.
be, someone has to decide it as an independent arbiter. My lord directed the assessor collector and the hearing officer to do it as a combined exercise. I gather that Mr. Bishoyit Mukherjee will naturally take the point that the hearing officer under section 187 is the person concerned. His jurisdiction cannot be shared by the assessor collector. There, my lord, I have no axe to grind with him. My humble submission was, as an independent arbiter of the corporation, someone should decide this issue as to whether there can be cleavage or not. This has been remitted back to them for their considered opinion. It has gone back to the hearing officer. He, by a single paragraph, says, my earlier orders are all sacrosanct and therefore all the orders are confirmed. That's his page 79. Kindly see page 79.
Is it
puts in a table.
the same hearing officer?
It's his successor in office.
So not the same person.
Not the same person, but then someone else, maybe the assessor collector himself, maybe the chief manager revenue himself, gives us a hearing, decides this issue as a point of question.
But then prior to remanding, I have to apply my mind as to whether it is to be remanded or not.
In that case, my lord, kindly takes up the provisions of the Act once. 178(1) is absolutely clear. Every unit of assessment, kindly see, my lord, section 178(1). There is no question. There has already been, my lord, here, my lord can send it back straight away on remand only on this point, if it commends to your lordship. And if Mr. Mukherjee agrees, because I know Mr. Mukherjee is fair in these aspects. My lord had directed, no, he's very fair. He's very fair in these aspects, my lord.
What's in my mouth? What is to be argued before your
No, that's certainly not the thing. Lord, only immediate remand can perhaps be made if your lordship, not even without applying mind afresh, because my lords have been pleased to direct the assessor collector and the respondent and the hearing officer to enter into a conjoint exercise. Would your lordship kindly see, as statutory persona as court's persona designata, they could have done that. They have not done it. Your lordship's order says both of them are to be there together. So please see page 65. Second paragraph from the top. In view of the above, the entire issue is remanded back to the respondent numbers 3 and 5, assessor collector and hearing officer respectively, to decide the issue afresh after giving a reasonable opportunity of hearing. Thenceforth, it has only been the hearing officer. It has not been the assessor collector at all.
Only to this extent. What will be your submission?
My submission is, your lordship has seen section 187.
Whatever, if there is one officer to hear, the court directed two to take a decision. Why one will
Now,
take?
187 clearly says that the hearing officer has to hear and pass his order. Now, my lord, by interpreting your lordship's order, that assessor collector and the hearing officer, he says that and has to be read as conjunctive. I say that and has to be read as disjunctive.
Why?
Yes. My lord, it is not something alien in law that and can be also read as disjunctive. My lord, I have got a decision.
No,
in
you
my
tell
favor.
me why do you want
Why
to
I want to say this? Now, because I started my arguments based on section 187, it says that the corporation shall, with the approval of the state government, appoint an officer who is going to be the hearing officer. Then 2, the officer appointed under subsection 1 shall be.
Mr. Mukherjee, the court wants two to take a decision. In fact, on the earlier occasion also, this was the point.
And this is
No, earlier that was not the point.
No, earlier the issue
point
was the same. Issue
That
was
section,
Is
that
it?
respondent number
I have
6
followed.
was not given a hearing. That was the point, limited point, based on which your lordship remanded the matter. Now we have given notice.
There
And-
is a proposal from the petitioner to appoint an independent arbiter. Is that possible? Do you all have arbiters who decide all these
No
things?
arbiter, it can go before the
Chief
chief
manager
manager revenue.
let him
But
consider.
that, there has already an order has been passed by the hearing officer. Now, the second aspect of the matter is, if your
The
lordship-
earlier order was also passed by the hearing
Hearing
officer.
officer.
The court remanded it back
To twin people.
for taking a decision
But your
together.
lordship, before remanding, your lordship has to satisfy why this has to be remanded,
But you
because
can't
an
On the
authority under the law
earlier
who
order.
has jurisdiction. তুই বলে শেষ
আচ্ছা,
করে নে, তারপরে আমি
I'm sorry.
Malad, the authority under the law has gone into his objection, rightly, wrongly, incorrectly, and the most of his submission is based on merit and has decided, and it has passed an order. Might be a wrong order, For that, an appeal is there. Now, my lord, here, the order was passed. Your lordship sees on 22nd of February 23, paragraph 17. Then, my lord, paragraph 17, it was served upon the person concerned. My lord, there are two ways, my lord, two options were there as on that time. My lord, either to file a writ petition or to file an appeal before the tribunal. Now that 45 days time limit has already gone. Now today that expired on 10th of April. Now the writ petition has been affirmed on 26th of April 23. The next point is, my lord, by filing a writ petition, can a time-barred remedy be revived? My lord, I ask a question to myself. My lord, the division bench of this court has already answered that question.
What is the due right now of the petitioner?
Petitioner?
Due.
No, the dues are cleared.
There is no due.
They had been cleared. Dues are cleared.
It's the annual valuation,
The
assessment of annual valuation.
The spate of annual valuations, dues are cleared.
Your lordship wants to hear, your lordship hears this
Lordship,
matter.
if your lordship wants to hear, lordship may hear, but I was only requesting, since the earlier order is not under appeal, earlier order has been accepted by all the parties. Everyone concerned is bound by the earlier order. Why then deviate from that order? There was a joint exercise. Court can always direct, my lord. Court directed personal designata.
I ask a
Then
question to
the
myself,
hearing
can
was
the court
continuing from February. You
Yes.
did not raise any objection. Did you ever raise any
Yes,
objection?
I went
before
and I
the
said that
order?
both should be heard together.
Where is that?
Preliminary objection was raised. That I shall show you, lordship. Preliminary objection was
prior to
raised.
the passing of the order?
Not prior to the passing of the order. Immediately as we went, we said that it should be heard out and disposed of by both. But that objection, my lord, was not given any heed to. Show me, lord.
Page 73, I see one objection.
There's an
is
objection
there.
at 73.
Whether this point has been taken or not, I don't know, but I see an objection captioned as preliminary objection.
Yes, one is 69. It's been directed, my lord, given to the corporation. '77, kindly see the prayers. D. Drucker asked for 2 prayers. That's before the, naturally before the joint personal designata of the corporation. He addresses it to the Kolkata Municipal Corporation personal designata. His
No, that
prayers
is
are,
all
kindly
right.
see,
Yes, which page?
page 77.
77.
To examine the ground reality, my lord, I hope, my lord, we are on the same page literally, because my advocate on record sometimes says that maybe there might be a pagination here or two.
The
Page
prayers.
77 has a prayer portion.
Yes, prayer.
Yes. To examine the ground reality, whether the balance land of 14 kathas is separately assessed or bearing separate premises number, and can take on record the
No,
declaration
no,
made
the
by
two
LSE.
to hear it together. Where is that
He
issue?
addresses it to the Kolkata Municipal Corporation Assessment
Not the
Collection Department.
addressee, not the addressee. The point that the matter is to be decided conjointly. Where did you raise this issue?
Here, my lord, I do not find it in this objection. But
Prior
my lord,
to that
it's not
also.
waivable. It's not waivable. It's an order of court. My lord, parties by their conduct cannot waive an order of court.
I'm not waiving, my lord. He is reading
My lord, there is
it
no.
as conjunctive. I am reading it as disjunctive.
How can it be disjunctive? Will
Yes,
two parties pass 2 orders? Will
Please,
2 parties pass
is the
2
private
orders?
respondent here?
Please serve.
What will be your submission?
My submission, also kind of it's in section 188(2). But here also it says that on a date and time, in the date, time and case specified under section 184, and after giving the person filing the objections and opportunity to be heard, either in person or through an authorization, the officer appointed under 187 shall determine the.
Oh, I get it. Please come.
whichever-
Please come. No, let it be hard. Either the assessor collector, hearing officer together, or you want third person, the revenue.
Chief manager,
Revenue.
revenue, South can hear it. South.
The reason why your lordship
Not the South matter, TD.
is because
Polygon Tax Department. My lord, chief,
whether the entire land was there or whether it was a part of that.
the entire issues, no. I'll tell Mr. Mukherjee why. No. The proposal
Part
itself,
of the argument is on the merit, whether
Chief-
it
So
is
the
no, no,
court
no.
is
done-
not going into the merits.
merits at all, সেটাই।
It's only the jurisdiction of the hearing officer
Obliged,
to decide the
obliged.
matter.
187 clearly
No, no,
gives the
no.
jurisdiction to the hearing officer.
187 was there on the earlier.
Earlier occasion also,
when
there's an
the
order
was
made
passed.
by court.
187 was there, but the point was whether it is to be
Mis-
heard or
Mr.
not.
Mukherjee says,
Only point was hearing to the private respondent.
Chief Manager Revenue, Toligans Tax Department.
The order dated 7th February 2023 passed by the hearing officer, allegedly in compliance of the direction passed by this court on 7th November 2022 in WPO 2709/2022 is impugned in the present writ petition. Stop. It appears that on 7th November 2022, the court remanded the matter back to the assessor collector and the hearing officer for deciding the issue afresh after giving reasonable opportunity of hearing to the parties. Stop. The hearing officer, it seems that the hearing officer took up the issue and decided the same independently. Stop. As the court specifically directed the hearing to be conducted conjointly by both the assessor collector and the hearing officer. Accordingly, the order passed by the hearing officer independently is certainly not in compliance of the direction passed by the court. Stop. Next. The court at this stage do not wish to enter into the merits of the matter and is minded to remand the matter back to the officers in terms of the direction passed by.
Pardons me, instead of the officers, your lordship, because that, my lord, with the deepest of respect.
It
utmost
won't help.
No, but that can help.
That is
Wait.
beyond the scope of section 187. My lord, would pardon me.
You
Your
did
lordship
not.
No, the
appoints the chief manager revenue.
okay, very well. Why?
Is the chief manager revenue a party? No.
No, KMC is a party, my lord can always. Under order 30 rule. No, order 30 rule 3 সব সময় permissible. কেন add করতে?
The
Corporation মানে all its
please
officers.
read out the last line. Back to the chief manager revenue
Trolley tax.
within bracket tolly tax to take an independent decision in accordance with law after giving reasonable opportunity of hearing to all the to the petitioner and the private respondent.
Obliged.
Stop. Next. The chief manager revenue shall decide the issue at the earliest, but positively within a period of 8 weeks from the date of communication of this order. A reasoned order shall be passed and communicated to all the parties. Stop. Next. Leave is granted to the learned advocate on record of the petitioner to implead the chief manager within bracket revenue, tolly tax as party respondent. Stop. The formality of serving a copy of the writ petition upon the added respondent stands dispensed with, as the learned advocate has already entered appearance on behalf of the Kolkata Municipal Corporation. Stop. The petitioner will, however, be obliged to forward a copy of the writ petition along with all connected documents to the chief manager within bracket revenue, tolly tax at the time of communicating the order of the court. Writ petition disposed.
My lord, please set aside, my lord, the order of
The impugned order dated 7th February 2023 stands set aside.
Obliged, your
Affidavit of
lordship.
service,
Affidavit service.
Naini,
My lord, will be kept in the record. Kindly give me half an hour. Half an hour,
and make the necessary correction.
my lord, immediately.
Leave granted to
That
file
would
the
be good.
affidavit of service in the course of the day.
Obliged, your lordship.
Record appearances of all the parties. Please give in your appearance, private respondent.
My lord, this matter, my lord, pursuant to your lordship order, they have, my lord, sent the, my lord, demand notice for giving hearing after depositing the security deposit. What happened in this case, my lord, this is a Thika tenancy. So they are calculating the, my lord, amount, considering the, my lord, IGR rates, that is, my lord, Inspector General rates, which is assessed considering the land as well as construction. And my lord, in Thika tenancy, my lord, we are the tenant. We neither we possess, neither we own, neither we can transfer the land.
So you are not the Thika tenant, you are the Bharatiya possibly.
No, Thika tenant.
You are the Thika
Yes,
tenant.
your lordship, the
So you must be
premises
the-
with H shows Thika tenancy. Premises number,
No. Show me the receipt issued by the Thika.
no, that is not available. That is not available with the lead petition, my lord, that I inquired, but I am told that, my lord, they are the Thika tenant.
Thika tenant is separate and a Bharatiya is separate.
Yes.
So are you the
Correct.
tenant or the Bharatiya?
My lord, it is the pleading, we are the Thika tenant.
You are the Thika
I am
tenants.
going
Very
with the
well.
pleading, lordship.
Yes.
So my point is that the application of mine is not there. They are using these IGR rate for the normal premises as well as for the Thika premises. So when a Thika premises land cannot be, the valuation of the land cannot be taken into consideration. That is my point. Let that be decided by them first by any authority.
Where is the property tax bill?
Property tax, not property tax bill, that demand notice.
Why have you annexed the office circular number 16? Is there any unauthorized construction going on?
Lordship, that's why your lordship directed them to give me an opportunity of hearing. But considering that circular, they are granting hearing for taking steps regarding that unauthorized construction after depositing the security deposits. For assessing that amount of the
Security deposit.
they are also taking consideration of the land value. That is my difference. Does it kindly come to demand? That is at page
19.
19.
Charges for regularization.
This is 50% of charge. The 23,75,000.
But then where is the valuation of the land taken into
Lordship,
consideration?
kindly come to middle portion, lordship, this portion. There is a code. That first line,
Yes, code.
that code is budget code, indicates the IGR. The valuation is by the IGR, Inspector General of Register.
And is it the valuation of the land or the valuation
Yes,
of the
valuation of
structure?
the land and structure. That is the, they are not making any difference for the general premises and the Thika premises. So admittedly, under section 5 of the Thika Tenancy Act, land I can possess, I can own, I can transfer, I can deal with. This is the,
We have asked for a security deposit.
Yes.
Now, my learned friend has made a representation which your lordship
Lordship.
takes at page 20.
lordship.
My learned friends, your lordship has seen what your
Yes.
lordship was asking.
Yes.
He says this in the last paragraph. It is pertinent to say that Thika Bharatiyas are belong.
So he is a Bharatiya, he is not the tenant. This I was wondering.
Now, he only prays that it should be reduced because weaker section cannot pay that much. The lordship sent it for consideration.
Lordship, my prayer is that let this be decided by.
Where is the Thika tenant?
Only that decision will, my lord, my ultimate decision relating to consideration of illegal construction will be delayed.
Support document dibi na.
This will take 3 months.
Where is the Thika tenant?
That is a
Possibly
question.
the Thika tenant doesn't even know that you are raising construction.
No. That is not.
Where is the Thika tenant?
Yes, that I have to satisfy. I will satisfy before them, my lord. Let them take a decision, my lord. I have to satisfy that whether I can claim that.
Please come.
That municipal commissioner.
The petitioner is guilty of raising unauthorized construction. Stop. A demand notice has been issued on 20th
March, 22nd March, it appears, my lord. Yes, 22nd March, lordship, date. 22nd March, 23. Mala hand it in and type.
22nd March 2023, wherein the security deposit under section 400 within bracket 1, 416.
The amount directed to pay is 25,000.
No, 23 lakhs 75,000.
Payment to be made by cash.
At the bottom, 23 lakh.
Yes, yes, 23,000.
23 lakh 75,000.
25,000 is the maximum limit of cash payment.
The under section 401 and 400 within bracket 1 and 416 of the KMC Act 1980, read with the KMC Building Rules 2009 and the Office Circular number 16 of 2021-2022, dated 2nd March 2022, intimating the petitioner that she has to deposit a sum of rupees 23 lakh 75,258 only. Stop. Paragraph. The petitioner claims that she is a Thika Bharatiya and belongs to the economically weaker section of the society. Stop. Next. The property in question, the property standing at B-3, not hyphen, /3/H/1, Durga Charan Banerjee Street, Ward number 8, Borough 1 of the Kolkata Municipal Corporation, is a Thika property. Stop. The petitioner claims to be the Bharatiya. Stop. Paragraph. Specific submission of the petitioner is that since the property in question is a Thika property, she is not the owner of the land. Stop. She is merely responsible for making the construction at the subject premises. And stop. The corporation, at the time of assessing the security deposit, has taken into consideration the valuation of the land in question. Stop. The petitioner submits that the same is incorrect. Stop. A representation has been filed before the municipal commissioner on 30th of March 2023. Stop. The petitioner alleges the same is pending consideration till date. Stop. Next. After hearing the submissions made on behalf of the petitioner as well as the Kolkata Municipal Corporation, the court directs the
Respondent number 3.
Director General within bracket building Kolkata Municipal Corporation to take a decision apropos the representation filed by the petitioner in a March 2023, comma, the demand notice dated 22nd March 2023, the office circular number 16 2021-2022, and all other necessary documents at the time of communicating the order of the court. Writ petition disposed.
Presentation is not detailed.
I want to add something.
Otherwise, if I cannot make out the.
He cannot develop.
I have jotted down your points. I have seen it
He cannot
and
develop.
mentioned in the order.
He cannot
So I
develop
don't
now.
think anything else will be required.
Grateful to your lordship.
Much obliged.
To cover up your lacuna, the court had to
Grateful
do
to
the
your
work.
lordship.
Much obliged, my lord.
One lordship, I beg to appear on behalf of the petitioner. My lord, the fact of the case is, my lord, there is
I was wondering the name.
no respondent number 4. My lord. Sorry,
I've seen
I'm sorry.
in the
I'm-
list
I'm sorry.
somebody else's
I'm
name.
sorry.
I got confused.
I'm sorry. Last occasion, lordship was kind enough to direct us to bring, my lord, the stay order, which was issued in the year 2005. My lord, I brought this. That is why. বলে বলে অভ্যাস হয়ে গেছে, কি করবো বলো?
You mentioned it.
এটা পাঠিয়েছি তোমাদের এইটা স্টে ছিল কিনা যাচ্ছে আমি জানতে চেয়েছিলাম।
Demolition is already over.
No, my lord, what happened?
The asbestos shades had been removed and the doors and windows have.
My lord, what happened, I may be allowed, my lord, to narrate the whole story. My lord, the compounding of, my lord, the building rules are there. And my lord, it was before the special officer building, there was a direction subject to demolition of the first floors. Ground floor will be regularized. And certain amount is required to be deposited, that we have deposited. Being agreed by, we prefer appeal before the appellate tribunal. Appellate tribunal upheld the order of the special officer building. At that point of time, interim order rejected. We moved this Honorable High Court. Honorable High Court was kind enough to direct the tribunal to grant stay and to wait till the disposal of the appeal. Finally, appeal disposed of. Appeal, my lord, the special officer building order is upheld. Meaning thereby the ground floor will be there, first floor will be demolished. Then, my lord, I have preferred one application before this Honorable Court and stay order was granted. Lordship was kind enough to direct me to bring that stay order. My lord, that stay order is here, my lord.
What is to be done now?
Now, my lord, what happened pursuant to the order passed by the Municipal Building Tribunal and Special Officer Building, my lord, there are 2 rounds of demolition, lastly in the month of March, possibly. My lord. Here now, my lord, what happened? The stay order granted by the High Court against the order of the, my lord, the Building Tribunal, dismissed for default in the year 2015. My lord, we have filed our application for restoration. Restoration application is at present pending. We have mentioned it, my lord. by sending them an advance letter that we are going to mention it before the appropriate court. My lord, this matter will be appeared at any point of time. This was the submission on the last occasion. Lordship was kind enough to direct me to see and to, my lord, direct me to show that there was stay order. My lord, kindly see, this is the stay order.
Give a copy to your learned friend.
I have sent him all the copies, application which I have tendered. File, যেগুলো তোমাকে দিয়েছি, আপনারা তো দিয়ে দেবো তাহলে আবার। এতে পাঠিয়েছি, পোস্টে পাঠিয়ে দিয়েছি, দেয়নি তো নাকি? দেখাচ্ছি। আসুন।
Status quo as on date as regards the construction shall be maintained.
It was, my lord, dismissed
There
for
is no
default.
stay. Status quo as on date.
Lordship.
Stay and status quo are two
My lord,
completely different things.
different. My lord, what
Then-
happened on the basis of that particular order? My lord, the corporation, my lord.
Status quo, in fact, is a restraint upon order upon you not to make any further construction.
Yes, my lord. Yes, that is the position also, my lord. What happened, the first floor still remain, and as a result of which, after the dismissal of this particular matter, my lord, there is in scope and opportunity of the Kolkata Municipal Corporation to undertake further demolition work. Our humble submission, my lord, this comes to our knowledge later on, and my lord, we have changed our lawyer and we have filed our restoration application, which is pending before this honorable court. Let the propriety of the order passed by the special officer building and as well as, my lord, the building tribunal be adjudicated. We have mentioned this matter, and my lord, at any point of time, the matter of restoration may be listed before the honorable court, my lord. That being the situation. Here, my lord, considering that aspect, we are asking for some breathing space so as to enable us to face, my lord, the honorable writ court for restoration of this case. In the event of, my lord, no restoration, my lord, the corporation is free to undertake each and every work, my lord, to demolition work or all other things. But they have accepted the money, so far the ground floor is concerned.
So
That-
let the ground floor be regularized and you demolish your first
No,
floor.
my lord, since we have preferred, my lord, lordship knows, my lord, I was really, my lord, for sufficient reason, I was prevented to prefer, my lord, the restoration appeal during this period. That that
Authority to see whether you filed it within time or not. As on date, there is no order restraining the corporation to proceed with the
true, my lord,
demolition order.
only, my lord, judicial propriety demand, my lord.
You
Our
approach-
humble submission, my lord, later, my lord, some time may kindly be given to, my lord, move my application. To move my application, my lord.
No, that is gone. From 15, it is not there.
Point of regularization. Now that the ground floor has to be also taken.
That the authority will take a decision.
I will satisfy your lordship here and now. Kindly take some affidavit in opposition on behalf of the respondent number 2.
What is the prayer in your writ
Demolition.
of the
Entire
entire building?
He's my neighbor, my lord.
The defense will not kindly see will not the affidavit in opposition affirmed by the respondent number 4.
Has it been filed?
They have been argued for some with a copy below.
That we have filed that.
Wait, let me see. Yes. Right. What is there?
Kindly see, will not, we were not at all aware of this will not regularization. Kindly see page 7. And this is the amount they have taken. Kindly see.
Charges for regularization.
Kindly see on the right hand side, date 19 December 2002.
Yes.
The power of the Kolkata Municipal Corporation for regularization was incorporated in the statute in 2015. Now, the entire ground floor is also below to that. That act is also bad against this statute. Here's the statute. They can't be permitted to regularize the ground floor. Whether their lordship will kindly consider whether there was the power under the statute in 2002 for the Kolkata Corporation to regularize.
And the date is 2002.
Kindly see at the
Yes,
date,
yes, the bottom also it is written 2002.
19 December 2.
Yes, 19 December 2002.
And this we came to know first time in the.
What is
affidavit of
the date of the special officer's order?
Special officer's order, my lord.
Page 29.
25th October 2002.
25th October.
My lord, my opposition, my lord.
Yes,
File,
your
my lord,
opposition.
opposition page number, my lord, page 7. Sorry, my lord. Start from page 6. This
Also
is the
there
order
in
of
my
the
petition
special officer.
also.
Yes.
Page 27 in my petition also.
Now, is this order under challenge in the writ petition?
No.
The order of the special officer? No.
This order has been affirmed by the my lord, municipal building tribunal.
No, but the question of my lord, regularization power, whether lies with the corporation or not, that is the question raised by my learned friend. There are number of judgment, including division bench judgment of this honorable court. It is up to the municipal commissioner. It
But
is the
then there has to be a supporting law.
No, my lord,
You
at that
cannot
point
take
of time on the,
decision on
my lord,
it.
this honorable court, even in the division bench judgment, is of the, was of the opinion, this can be done, my lord. If this honorable court kindly allow me, my lord, to come back with those judgment, I can show, my lord.
You can show everything before
lord,
the tribunal. The court is not interfering.
Even, my lord, the tribunal, even the tribunal is before the tribunal, this question was never raised. No power is there. No, so far the tribunal proceedings, are there. They should raise this question before the tribunal also. There no power. No power, my lord. Kindly see page 31. This is a tribunal proceedings.
We are coming to know for the first time.
Here, my lord, the complainant writ petitioner Srimati Anjali Dhar fails to turn up in spite of service of notice. Page 31 of the writ petition.
Still, its order was in my favor.
Please.
No.
The petitioner seeks implementation of the order of the special officer dated 25th October 2002, affirmed by the Municipal Building Tribunal in order dated 4th June 2005 in BT appeal number 107 of 2002. Stop. It appears that challenging the order passed by the Municipal Building Tribunal, the private respondent preferred a writ petition before this court, being WP number 13153 W of 2005. Stop. Initially, an order was passed by the court on 15th July 2005, directing the petitioner to maintain status quo as on date as regards the construction in question. Stop. Next. Subsequently, the said writ petition stood dismissed for default on 25th June 2015, and the interim order stood vacated. Stop. Next. Learned advocate representing the private respondent who is suffering the order of demolition submits before this court that steps have been taken for restoration of the writ petition. Stop. Next. Time has been sought. Stop. Next. What is the number?
My lord, 2 of my lord, 23.
Can 2 of
2023.
For data filing?
My lord, just a minute.
May
My lord,
2020.
my lord,
After your lordship's last order.
no, certainly not. My lord, this was on 14/3/2023.
Your lordship was hearing.
Hearing, didn't see.
No copy.
My lord,
has been served to us.
দিয়ে দিয়েছি সবাই দেখো তোমাকে দিয়েছি
The petitioner has preferred a restoration application being CAN 2 of 2023 on 14th March 2023. Stop.
দিচ্ছি আমি তোমাকে, এক্ষুনি দিয়ে দিচ্ছি, আরেকটা।
Admittedly, as on date, there is no order staying the operation of the order passed by the Municipal Building Tribunal directing demolition of the first floor of the subject premises. Step next. In the absence of an order of stay, it will not be proper for this court to restrain the Kolkata Municipal Corporation to take steps for compliance of the direction passed by the learned tribunal. Stop. Next. For ends of justice, the court directs the Kolkata Municipal Corporation to act in accordance with the order passed by the Special Officer Building formed by the Municipal Building Tribunal on and after 1st of July 2023. Stop. In the event the person responsible for making construction, that is the private respondent herein, is unable to obtain any order of stay of the order passed by the Municipal Building Tribunal, then the corporation shall implement the order of the tribunal at the earliest, but positively within a period of 12 weeks from positively within 30th of September 2023. The writ petition stands disposed of. One leverage.
For 7 years, they are getting leverage.
Yes.
I am for the petition, your lordship, item number 2. I am led by your Mr. Sudipto Dasgupta. He is appearing in another courtroom, your lordship. Kindly grant me a short password.
Let the are the others here? I want to hear the submission of the ED.
That is in respect of three.
This is 3. What is to be done in 2?
Who is, these two matter is similar and analogously came, my lord. The issue is similar at the first instance, because in the writ, my lord, that's why, my lord, analogously came.
Can 7 was being placed on the last occasion. Mr.
occasion,
Bhattacharya was there.
Can 2, my lord, can 7, my lord, in item number 2, Papa, that is filed by my learned friend, my lord, Sudipto Dasgupta.
Yes.
For recording bring the report of the CBI, my lord.
Yes. Where is the report of the CBI? No, but then I want to see how the CBI is progressing.
Honorable, kindly direct us, my lord, we'll come up with a report, my lord. My lord was actually hearing, my lord, the next matter.
Item number
That
3.
intervention application and the recalling application. And my lord may direct me, my lord, to file a report.
Well, we in that case, we start with 3.
Yes, please. I was beseeching my lord, my lord, to take up 3 first, my lord.
Yes.
And my lord may direct me, my lord, to file a report, my lord, I'll come up with a report.
That's why, one of the last occasion that confusion, the Ramesh Malik, my lord, filed by Mr. Dasgupta and Somen Nandi filed from my chamber. That's the last occasion.
3.
My lord, this is my application.
I can see Mr. Dotto online.
Yes, he's online. He is not here.
Very well.
Other day I was relieved.
কোন ইয়ারটা ভুল আছে? কত হবে? Yes.
Well, another day I was relieved because Mr. Dotto was here. Now, my lord, I will not certainly repeat. But I will submit, my lord is hearing an application for recalling of the order dated 13th April 2022. Point has been raised that
Bias.
One is bias, another is, my lord,
Jurisdiction.
No pleading.
No pleading.
So far as, my lord, jurisdiction point is concerned, Mr. Dotto argued, my lord, at length. I will not repeat. That is up to my lord to decide that. But I submit before my lord. So far as bias is concerned, I need not make any submission.
Very well.
It is admitted on record.
Very well.
Why, my lord? Can you take trouble to just to refresh your lordship memory?
No, it is refreshed.
No, civil
Only
procedure
from
code.
Friday and Monday.
Civil procedure code.
Oh, CP.
Long detached. That's
Ah.
why.
Yes. No, I have the book here.
No, then. But kindly refresh your lordship memory, section 24 and 25. Just kindly read it.
Hmm. Yes.
Two need not be. Now kindly look to 25.
25.
25 is more or less akin to, but power conferred under the court to Supreme Court. My lord has read that. Here, my lord, 25 speaks of state to state. But here, my lord, admitted fact is this, that one application has been filed by my client before the apex court. And apex court, my lord, exercises jurisdiction. Presumably, my lord, to decide under which provision? Under 25. Because the court has transferred the proceeding. 24 speaks of court to court. Even my lord knows when I can move it.
Intrastate.
No, I am try to, my lord, reconcile this. In a district judge, I can file a petition under 24 for transferring that court from 4th junior division to 5th junior division. On the grounds, I am coming to the grounds. And here, the section 25 says the Supreme Court can transfer it from state to state. If your lordships harmoniously consider section 24 and 25, my lord will find that the power of transfer a proceedings from one court to another has been given by the court to a court. By the court to a court. It may be Supreme Court, it may be High Court, it may be district judge. Now here, my client has filed an application before the apex court alleging ABCD, I'm not repeating, whatever. Supreme Court
accepts it.
Accept it and assume jurisdiction under the court, because my lord knows this code is our Gita. So far as Calcutta High Court is concerned, my lord, though civil procedure court expressly ousted writ proceedings, but your lordship's court had adopted it. And mutandis mutandis applies. Now I will show to your lordship what are the grounds, my lord, why I request your lordship to read it. What are the grounds of transfer? Grounds of transfer are inconvenience, my lord, in everyday while civil jurisdiction, matrimonial proceedings, wife, Murshidabad, husband, Alipur. This is one ground. Another ground is the proper justice has to be done. No, my lord, there's maxim, my lord, it not only to be done, it seems to have been done. Bias is also incorporated there. If these three things, my lord, are taken into consideration, vis-a-vis the section 24 and 25, and when the court, the Supreme Court, exercises jurisdiction and transfer it, in my humble submission, bias need not be argued before my lord. To that, my lord, I want to show to see one judgment for your consideration. 2008, Volume 3, Supreme Court Cases 659. 2008, Volume 3, Supreme Court Cases. আমার নিজেরটা না পড়লে হবে। 659. I will not trouble to your lordship the entirety. Supreme Court in a paragraph crystallized it. Paragraph 23. May I read with your lordship?
Yes.
Reading section 24 and 25 of the code together and keeping in view various judicial pronouncements, certain broad propositions as to what may constitute a ground for transfer have been laid down by courts. They are balance of convenience or inconvenience to the plaintiff or the defendant or witnesses, convenience or inconvenience of a particular place of trial, having regard to the nature of evidence on the points involved in the suit, issues raised by the parties, reasonable apprehension in the mind of the litigant that he might not get justice in the court which the suit is pending. Can you pause there for a moment? This is, my lord, in my humble reading is bias. Then let us proceed. Important question of law involved or a considerable section of public interest in the litigation, interest of justice demanding or transfer of a suit, appeal or other proceedings, etc. Above are some of the instances which are germane in considering the question of transfer of a suit, appeal or other proceedings. They are, however, illustrative. There may be so other things also in nature and by no means be treated as exhaustive. If on the above or other relevant consideration, the court feels, well, kindly mark this, if the court feels that the plaintiff or the defendant is not likely to have a fair trial in the court from which he seeks to transfer a case, it is not only the power but the duty of the court to make such transfer. So here, admittedly, court has transferred it. Then, my lord, either of these grounds has to be satisfied or he must have satisfied. The court must have considered these grounds. Here, my lord, the case is not the convenience or inconvenience of witness, not the case of convenience and inconvenience of the plaintiff or the defendant. Only point is which urged and considered by the Supreme Court and accepted. That is, my lord, the other count whether it is fair trial. So it an element of biasness inbuilt in it. So according to us, we need not argue that Justice Gangabadhyay is biased.
Very
Or
well.
this is not before my lord.
Very well.
That has been decided by the court and transferred. My lord has seen, my lord, this judgment has been placed before my lord. The application for transfer there, the grounds was taken that the judge for ABCD reason was biased. I am not trying to illustrate that. Now, this is the first point. This is the first point your lordship has to consider. Now, when the court has considered that on a day, that is on 13th April 2023, parties, at least my client, will not get a fair trial. Am I clear to my son? Can you relegate this matter to on that day? Because when the transfer application is being considered or application is being considered by the Supreme Court, the relevant order was 13th April order. And it was canvassed with the Supreme Court that on that date, the grounds mentioned in 24 and 25 are available to me, court should not have heard this matter. And that has been accepted and transferred. Then in my humble submission, this order of 13th April should go along with this.
Should go along with this.
Along with this transfer. Because
Yes,
transfer was on the
that
ground.
is the recalling that you are saying.
That I'm saying, why? Supreme Court has says you file an application there. Supreme Court has, by of his own, not recalled it, said you file an application. So if on the facts available to the Supreme Court on the day, on 13th April, that the party will not get a fair trial and withdraw the suit, then, my lord, in my humble submission, there is no impediment. There cannot be any argument to suggest that this order will be there, but I am not getting a fair trial, suit has been withdrawn. Now, my lord, I am coming to the second point of my submission, that is the pleading. My lord's power, accepting a suo motu power, if your lordship says something, seen something in the newspaper, my lord has a power to suo motu give a cognizance to that. But here in this case, there is no suo motu power invoked by the court up till now. It has been filed in hearing a writ application. in the writ application. So parties are there and the whatever order, whatever issue which will be framed, it is based on pleading. Just I am, my lord, just for refreshing your lordship memory, kindly see order 14 rule 2. A party plead, other side denies. That creates an issue and the court has to decide the issue. So pleading is a sine qua non to frame a issue to be decided by a court. Now here, my lord, if your lordship kindly, probably I will be repeating to that extent only, kindly come to page 31, the application filed before the bench when this order was passed.
It is annexed in can
Yes,
5.
can annex, my lord, it is at page 30. It is 30, can 6.
Can 6.
Page 30.
Yes.
Well, kindly recall what was there on that date. One accused who was under the custody, he complained that CBI or ED authority are torturing him.
By the way, where is that complaint? Is it annexed anywhere?
We don't know, my lord. So far we are concerned, we have no access to those. Maybe ED has. And probably this is not our case. Because
Just to assist, my lord, it is the complaint of Kuntal, my lord.
Kuntal, not
Where
mine.
is that?
My lord, that was placed before the court when the court inquired from the state officers to place it, my lord. I have it with me, my lord. It was also placed before Justice.
But I am not for Kuntal.
Perhaps it.
No,
can
no, I
be-
get it. But then I just want to see where is it there somewhere in records?
Kisho, ঠিক আছে?
No, no, it's not possible for you to find out. It's a very voluminous
I
brief.
have copy, my lord.
Ready? Let me see once what is there.
Have made a compilation, but if they can later on when I'm submitting.
Very well. I'll see that. Let Mr. Basu continue.
But I am not for Kuntal. I am saying I have nowhere to be entangled. Now, my lord, this was the situation there. ED says that if this type of, according to the ED, if this type of formula baseless complaint as is made to the police, it hinders our investigation. So this is the complaint made and asks for intervention of the court. But Mr. Datta has argued whether court can monitor or interfere. That argument I will not make. Whether if court can monitor but not interfere, direct that you do this, you do that. That is one aspect. On this background, this application was made. My lord, kindly allow me to place it. The applicant has a few law enforcement agency and economic intelligence, page 33. Then, my lord, the applicant states that the prime object of the enforcement, that not necessary. Your application state that it come to the West Bengal several failed candidates and eligible, not necessary. Your applicant states that accordingly the director of enforcement is carrying out. By of repeating. Sorry, sir. The now name comes in. That Kuntal Ghosh is in judicial custody in connection with our such and such case is pending before the London Special Court. He was also taken into custody by CBI, RC case number such and such. It is pertinent to mention that the CBI is intervening in investigating the pending offences under the relevant sections of the IPC and PC Act, whereas the ED is investigating the money laundering angle under the PMLA. Both the cases are in connection with the investigation is primary teacher recruitment scam. Based on media reports and imputes, the ED has come to learn that on such and such day, the said Kuntal Ghosh had given a complaint before the learned ADJ 12 Court Alipur, wherein several false, frivolous and baseless allegations against the officers of the enforcement directorate had been made. No copy of the said complaint had, however, been given to the enforcement director or even filed before the special court, Bangsal court. Appraisals have been cast upon the investigation of the ED in media and elsewhere. This is nothing but a desperate attempt to thwart the investigation of the enforcement director. This was the pleading. Then, the further based on the imputes of applicant, ED had come to learn that the Kuntal Ghosh has lodged a complaint that the aforesaid facts had been brought to the knowledge of the Honorable Justice Gangopadhyay today morning, wherein liberty has been given to the applicant ED to bring the submission with such and such. Then, subsequently, it has come to the knowledge of the applicant ED that Kuntal Ghosh and or other politically exposed persons are trying to lodge similar complaints against the officer of the Enforcement Directorate together other police authorities as well. That the Honorable Justice Gangopadhyay had already passed an order today directing no action can be taken by the purported letter of complaint such and such. Here, my lord, will not be fined A of Abhishek Banerjee's name. There is no allegation. Based on this pleading, this order has been passed. And also the prayer, my lord, in the circumstances, your applicant humbly pray that your lordship may graciously please to pass appropriate order in this regard and to pass such order further an omnibus prayer is there. Now, on the basis of this, the order has been passed. Now, kindly come to the order once. It starts at page 38. I am not traveling to a lordship entity on the mentioning it has been done initially. Nothing worried me. I am not nowhere in the picture. Now, kindly come to page 42. What is that? Here I take note of one public meeting held by your Abhishek Banerjee on such and such date, where he urged some persons to support him by saying that when those persons were in custody, police or the interrogating agencies pressurized them to name said Abhishek Banerjee. The complaint of Kuntal Ghosh was made in close proximity with the said public speech of the said Abhishek Banerjee on 29th March. As Kuntal made the first complaint before the CBI court and on such and such day before the Hastings police station, it is a matter of to be inquired and investigated whether Kuntal Ghosh took the cue from the public speech of the said Abhishek Banerjee, for which both of them can be interrogated both by the ED and the CBI. And such interrogation should be made soon. Terrorizing the investigating officer of the investigating agency by complainant before the police authority is wholly unwarranted. I am not doubting one. Complaint, my lord will take care whether Kuntal's complaint is judgment to the issue, whether Kuntal complaint can at all be adhered to or thrown away. But now kindly see wherefrom, my lord, the honorable judge has taken a personal knowledge. Nobody argued. Your lordship will find from the, even in the argument, even on the argument, my lord, as recorded by his lordship, my lord, nowhere, my lord, the Abhishek Banerjee's name has been taken by anybody. So it is absolutely a personal knowledge of the honorable judge. With that, my lord, that can be a ground for passing an order like this. There is no pleading, no opposition, no issue frame. On this context, my lord, no prayer also. On this context, kindly consider whether a court, I am not taking any judge, a court can pass any order which is not, my lord, which is absolutely beyond the pleading and prayers. My lord, to that, my lord, I will cite two judgments for your lordship's consideration. One is 2014 5 Supreme Court cases. 312. 2014 5 SCC 312. Kindly come to paragraph 15. What I am saying, my lord, this is settled law. This court has consistently held that the court cannot go beyond the pleadings of the parties. The parties have to take proper pleadings and establish by adducing evidence that by a particular irregularity, illegality, the result of the election matter. Can you ignore that fact? Election has been materially affected. There can be no dispute to the settled legal proposition that as a rule, relief not founded on the pleading should not be granted. Thus, a decision of the case should not be based on ground outside the pleadings of the parties. Here, my lord, kindly take it. Parties are not only the parties has not taken this ground, the honorable judge has taken the ground. From where? My lord, don't know. It must be personal knowledge. Then, my lord, I will cite another judgment for this proposition, my lord. 2018, volume 11, Supreme Court cases 119. Two thousand 11 SCC. But kindly come to paragraph 19. 119. Ready to near seats? Ready? Oh. My lord, here, my lord, issue framed. My lord, kindly pause there for before your lordship go to the paragraph. Kindly see the in response to the issue. So issue was framed. Issue framed, one order 14. So pleading, denial, then issue framed. In spite of that, what the court is saying. In response to issue 2, we are concerned here with the customs of the adopting married sons of the community of the appellant. The only evidence the appellant has adduced is his own testimony and a word of a priest who have performed the ceremony. A general custom which the appellant intends to prove require greater proof than on the appellant adduced before the court. Moreover, there is no dispute with regard to the fact that the appellant did not plead in his written statement about existence of any custom as such. Parties to a suit are always governed by their pleadings. Any amount of evidence or proof adduced without there being proper pleading is of no consequence and will not come to the rescue of the parties. So if this proposition, which is, my lord, according to my humble submission, subject to correction by my lord, is a settled law today, the order which we are prayed for recalling of the order is liable to be recalled. There is no other option. Now, another thing my lord was observing, yes, on the last occasion when matter was going on, how you are prejudice. The only part we am prejudice is, I am showing to your lordship, that is page 45 type. No, you can finding the law. Yes, but kindly come to 49. Roman 4. All these aspects which have been indicated above, including the public speech of one Abhishek Banerjee, should also not be outside the investigation of the CBI and, if necessary, by the ED. My lord's observation was, how you are prejudice. When the problem is, I am from the civil side, so everything is coming in my mind civil. My lord knows, my lord, order 39 rule 7 and order 626 rule 9 is for investigation and local inspection. Normally, when application is filed before the court below, mechanically, when there is no other side, mechanically grant an order of investigation or commission. Point arose, how your prejudice? Only investigation, it will come to the court. But law is, my prejudice is all not the actual thing. Why the law permits you? If the court is satisfied that the ingredients of order 39 rule 7 or the 26(9) is satisfied, then even if prejudice suffered by you, it has to be sustained. But if it otherwise, it does not satisfy the tests. But I am not prejudiced. That is not the ground. Here also kindly apply the test here. The court directed my speech to be a part of the investigation. Whether this is satisfying the test of pleading, or it is within the power of the court to do something outside the pleading, bringing evidence, fishing out evidence from outside. Simple answer is, according to my humble submission, no. But I don't mind. There is a direction for inquiry is going on. While inquiry is being conducted by the ED or the CBI, CBI or ED has the material before them by which I may be called. I should go. But up till now, before my lord, there is no material either from the ED or from the CBI, at least from the pleading of the ED. There is no material that even I have been required to call for a witness. No material up till now. So in that view of the matter, it is my prejudice if I have my speech is, my lord, a subject matter of investigation by the ED. This is my prejudice. And even if I In the counter plus, I say, even if I am not prejudiced, if the order is not within the four corner of the statute, four corner of the pleadings, then my lord, this order should go. Oh, my lord, only one leave I am praying, my lord. I have concluded my submission that we come across, my lord, a speech of a political leader touching the same thing, pressurizing of the CBI. Then, my lord, this political leader also has to brought. That I want to bring you on record before your lordship. Can I give
What thing?
my lord?
What is that?
This is a speech of a leader. I have a speech.
Yes.
There is a speech of a leader of a political party that CBI is pressurized, always do pressurize to do something. Here, my lord, Kuntol, as per the Honorable Judge Kuntol, has pressurized to say my name like same thing. Whether this also could be.
Don't bring. This will complicate issues.
Has to be.
No.
Because if this is the ground, my lord, this is also to be a ground.
Very well. Don't bring.
Can I allow me to file it?
No. No filing.
No. My lord cannot
No.
give cognizance also.
No. Don't file.
I
So
want to
you are
put it on
over.
record.
No, you are over. Who comes next?
I am over.
Who comes next? I would like to hear ED.
ED.
My applications are pending.
I will hear you.
I'm-
You are
yes.
in custody.
Yes.
You are already in custody.
Yes.
So please wait.
Lordship.
I'll hear the ED first. Because it is on their application that this order has been passed.
My lord, may I have my lord's kind leave?
Yes.
My lord, it was my lord's pleasure at the very outset that my lord wanted the CBI and the ED to file a report. And since it has come by way of an argument from my learned senior friend that nothing is before my lord, implicating his client, my lord. My lord, report, my lord, we have, my lord, we can file in sealed cover as far as ED is concerned. I suppose my counterpart has also said, if my lord so directs, we may come up with a report, and that will in crystal clear manner prove that it is much ado about nothing. There are things, my lord, why, my lord, they are so apprehensive, even for a mere investigation. It's just a filing of report which was ordered by the Honorable Single Judge at that point of time, my lord. So, my lord, at the outset, my lord, if my lord so deems fit and proper, and with if my counter, we may come tomorrow with a report.
No, that is separate. But then on the basis of your application,
My
can
lord.
one,
My lord,
the order, could that order have been passed or not? This is the issue.
my lord.
No pleading. First of all, bias is upon the judge. That is different. But how do you support this application and get an order?
May I, my lord? First, at the first outset, my lord, this particular application which has been filed, that is CAN 6 and CAN 5. CAN 5 is the application where they want to be added as a party or they are intervening. Until and unless they are allowed to intervene by an order of this honorable court, they don't have any locus, first. Second branch is this, my lord. Now, if their CAN 6 is taken into consideration, it is in form of a review. Now, my lord, review, my lord, it had been argued at length in the application which was decided on last Friday by my lord, and the review was filed by the state, my lord. Now, my lord, if my lord kindly sees, I first take the technical point or point of non-maintainability of this application, because, my lord, first of all, my lord, lordship, with deepest of respect, cannot sit in review over the order passed by a coordinate bench of this honorable court.
But then this issue was
decided. My lord, may I, my lord, even at the, my lord will kindly, as far as this is concerned, my lord will kindly see, liberty was given by the Honorable Supreme Court to the state to file a review before this honorable court in that municipality case, which was decided by my lord. Now, my lord, so there was a specific amnesty given to the state to file a review, because the entire point which was taken by the state before the Honorable Supreme Court could be reiterated by way of review before my lord, and because of that leave, my lord has heard it now. Now, my lord, first at the very outset, my lord, I will take my lord to the orders of the Honorable Supreme Court, my lord. What does it say, my lord? Even at the cost of, my lord, repetition, my lord. Because, my lord, this point is first and foremost. My lord, initially, my lord will kindly come to can 6, page 51. 51. Yes, can 6, page 51.
May I interrupt for a moment, Millard? Kindly permit me to say one sentence.
Yes,
My
please.
learned friend is proceeding on an erroneous basis that my application is a review application.
It is not.
My
It's
application
recalling
is a
application.
recalling application. Therefore, Millard, my learned friend may confine his argument on the maintainability of a recalling application.
My lord, I am confining my argument to the maintainability of the recalling. Name would not change the contents.
Very well.
Nomenclature is of no consequence. This is what I am trying to impress about, my lord. Now, my lord will kindly see the order of the Honorable Supreme Court, which is at page 51, my lord. On that particular day, my lord, the pleadings and the case of the petitioner before the Honorable Supreme Court was more or less verbatim what is before my lord by way of this recalling application. Bias, so more and so forth. Now, my lord, the first day, my lord, the Honorable Supreme Court was pleased to, if my lord kindly takes up page 52, the last portion of the order, my lord, paragraph 6. There was a stay, my lord. There shall be a stay of all actions against the petitioner and pursuant to a direction contained in the impugned order of the single judge on 13th April 2023, my lord. Now, my lord, this particular order of stay, my lord, that was extended, my lord, because, my lord, it was, my lord, the prayer was, if my lord kindly sees, again, I will take my lord to page 52, my lord. It was on audio alterum partem. Now, my lord, will kindly see the next day's order, that is at page 54, my lord. That day, my lord, the transcripts were called for by the Honorable Supreme Court. And the matter went as to whether the interview was given by the Honorable Single Judge or not. And the transcript was all, and the interim order was again extended. That is on 55, my lord. Now, my lord, ultimately, when the matter was heard on merit, and all these points were put before the Honorable Supreme Court, what are before my lord? The order which came is, my lord, at 58, page 58, my lord. The transcription was taken into consideration, my lord. That is at paragraph 2, paragraph 2, third, my lord, and fourth, my lord. Having considered the transcript, we direct the acting Chief Justice of the High Court at Calcutta shall reassign the pending proceedings in the case to some other judge of the Calcutta High Court. The judge to whom the proceedings are reassigned by the acting Chief Justice would be at liberty to take all applications which may be moved in this regard. Now, my lord, so, and my lord, subsequently thereto, there was no order of stay of investigation. So, my lord, practically the order which was impugned before the Honorable Supreme Court was affirmed. The only point which was being taken here is the bias of the Honorable Single Judge. My lord will kindly allow me to say this, my lord. There, if a person comes, my lord, an order was passed, they challenge that order before the Honorable Supreme Court. And before the Honorable Supreme Court, the point was taken regarding bias and regarding one particular interview, which in my respectful submission was not with regard to, but be that as it may, my lord. So, an order, an innocuous order was passed without touching the propriety and, my lord, that order which was passed by my Lord Justice, Honorable Gangopadhyay, my lord. That is on P1, my lord. Okay, order? Passed on 13th of April 2023, my lord. So, my lord, in my respectful submission, the order which had not even been touched by the Honorable Supreme Court and no stay had been granted on the inquiry, leave apart the investigation, my lord, now cannot be challenged on verbatim on the same ground, my lord, because all these points were, it is nobody's case, it cannot be anybody's case, my lord, that this particular order and this particular was not challenged. And the pith and substance of the application before my lord was the same before the Honorable Supreme Court. So, my lord, in my respectful submission, this petition of recalling is not maintainable because all these points had already been taken before the Honorable Supreme Court, and the Supreme Court initially stayed the order, but subsequently the order which was passed, my lord, was a simpliciter transfer. Now, my lord, if I am allowed to go beyond, my lord, if someone comes and says that there is a bias, my lord, without going into the statement, whether right, wrong, indifferent, in order to avoid future complications, because each and every day such allegation may come. So, my lord, what a prudent man will do? The Honorable Supreme Court in his wisdom, just without going into this allegation, without going into the allegation true, right, indifferent, bad, negative, positive, whatever it is, my lord, just simpliciter, said, all right, let me transfer. For future, for benefit of the future proceedings, my lord, because this point will be repeated and reiterated, because this had become a devil's tool, my lord. Because my lord will kindly appreciate, no, it cannot be anybody's case that this is a case where a scam has taken place. People are involved. And it is breaking the backbone of the society, because these scams, financial scams, are to be taken into consideration very, very, very seriously, my lord. And Honorable Supreme Court has come up with various decisions. Now, my lord, so my first submission is, my lord, and my lord, again, at the cost of repetition, I come. When the state government went with regard to that particular portion of the investigation, my lord, which was with the municipality, my lord, recruitment, on the same day, with separate on the same date, my lord, review the, my lord, the leave to file a review was given to them, my lord. If this order was again to be challenged by way of a recalling or by way of a review, my lord, it should have been, that leave should have been granted or might have been granted, my lord, if the honorable judges in their wisdom of Honorable Supreme Court could have decided on this fact that this order may be challenged before this Honorable Court, my lord. So, my lord, in my respectful submission, this recalling application is not maintainable in view of the orders passed by the Honorable Supreme Court, my lord. So, my lord, in this, but therefore, my lord, I say, my lord, at the very threshold, my lord, this application should not be allowed. Because, my lord, in my respectful submission, my lord cannot recall an order of a coordinate bench of this Honorable Court with deepest of respect to my lord, and which has not even been touched by the Honorable Supreme Court, even at the cost of repetition. Now, my lord, I come to the reserving my right, my lord, to maintain that particular point of maintainability as a rock of Gibraltar, my lord. I go to the other aspect of the case, my lord, where they have pleaded, my lord. What I could gather from the submissions made by my learned senior friends, first point, my lord, which they took was of bias of the honorable judge who passed that order. Second was ulti alteram partem, my lord, that no hearing was given to the petitioner himself while passing an order. Thirdly, my lord, there was no pleading to that effect. And fourthly, my lord, which came today, my lord, was that there was nothing in the petition which specifically named the petitioner hearing. This is, my lord, what I could gather are the four corners of the submission, my lord, and those have been amplified in other alleys which are parallel in nature. Now, my lord will kindly come to the petition. That is at page 30. My lord will kindly see. My lord will kindly come to page 30. My lord, the relevant portion starts from page. The petition was, my lord, filed on 12th, my lord, and the order was passed on the 13th, my lord. And my lord, because we filed it on the 12th, we did not even have the copy of the complaint at that point of time. But we were so apprehensive, my lord, that basically on the information which we could gather, my lord, we filed this application, which was basically amplified on the day when we were making submissions before his lordship. And my lord, I would very humbly try to impress upon my lord that all the pleadings were there, my lord, which were later on amplified by us. And the honorable single judge came to the finding and specifically recorded in his order that after going through the petition and submissions made by the ED, that has been recorded, my lord. I will come to that portion later. My lord. Now, my lord will kindly see my petition. Petition starts, my lord, relevant portion starts from paragraph 5, my lord, at page 33. That Kuntal Ghosh is a judicial custody in connection with our ECIR case number so-and-so, which is pending before the learned special court, PMLA, Bankshal court. Subsequently, he was also taken into custody by CBI in RC number 6 of 2022 and is also presently further in judicial custody of CBI case pending before the learned ADJ 12th Court, Alipur. It is pertinent to mention that the CBI is investigating the predicate offense under the relevant sections of the IPC and PC Act, whereas the ED is investigating the money laundering angle under the PMLA. Both the cases are in connection with the investigation of primary teachers recruitment scam cases. That based on the media report and inputs, the ED has come to learn that on 6/4/2023, the said Kuntal Ghosh had given a complaint before the learned ADJ 12th Court, Alipur, wherein several false, frivolous, baseless allegations against the officers of Enforcement Directorate had been made. No copy of the said complaint had, however, been given to the Enforcement Directorate or even filed before the learned Special Court, PMLA, Bankshal Court. Aspersions have been cast upon the investigation of the ED in the media and elsewhere. This is nothing but a desperate attempt to thwart the investigation of the Enforcement Directorate. That further, based on the inputs of the applicant, ED has come to learn that Kuntal Ghosh has lodged a complaint with Hastings Police Station against ED through the Superintendent of Presidency Correctional Home. That the aforesaid facts have been brought to the knowledge of Honorable Justice Abhijit Gangopadhyay today morning, wherein liberty has been given to the applicant ED to bring the submissions made in the Honorable Court by way of an application. Hence, this application is being filed. That subsequently, it is also came to the knowledge of the applicant that Kuntal Ghosh and other politically exposed persons. Milord, I pause here for a moment. Milord, so now amplification will come. As far as I will amplify on this particular argument as to how we amplified this argument by way of submission before the Honorable Judge. And summing up the petition as well as the submissions which we made and putting 2 and 2 together, Milord, the Honorable Judge came to this finding. So, Milord, it cannot be said, Milord, that there was no pleading whatsoever, Milord. Naming specifically a person, I may amplify, Milord. So, be that as it may. And, Milord, we didn't even have the copy of the complaint. My Lord will kindly make a note of this. At that point of time when we had filed this on the 12th, Milord, we did not have, and we have specifically stated that in this paragraph, Milord, the paragraph which I have read prior to that. So, Milord, had there been the complaint, then we would have brought the name. But
is the name appearing in the complaint?
Yes, Milord, I have got the entire compilation. I'll come one, Milord. I will keep no stone unturned, Milord. And therefore, Milord, at the very outset, Milord, we were saying that we can bring a report in a sealed cover for my Lord. But, Milord, since my Lord told me to make my arguments today, Milord, now, Milord, so we said, Milord, politically exposed person. We did not have a copy of the complaint. Now, Milord, what happened is, are trying to lodge several complaints against the Office of the Enforcement Directorate through other police authorities as well. So, Milord, we know because several people are involved politically, Milord, the politically exposed persons are there, Milord, and it has become a devil's tool in their hand, and they are going to make complaints in order to deter. And Milord, this has happened in the past. And that has also been recorded in the order. When the Honorable Single Judge asked this, the learned counsel appearing for the CBI as well as ED, who is now assisting me, Milord, made these submissions. But that is not the point, Milord. What I'm trying to impress upon my Lord is this particular paragraph where we said, Milord, that politically exposed persons are trying to. Now, Milord, after that, Milord, the Honorable Justice Abhijit Gangopadhyay has already passed an order today directing no action can be taken on the purported complaint of Kuntal Ghosh by the learned CBI court and by the police authorities till such time that the matter is being heard by this honorable court. Now, Milord, we come to that prayer, Milord. In circumstances, your applicant humbly prays that your lordship may graciously be pleased to pass appropriate orders in this regard and or to pass such other further orders on. Now, Milord, my prayer is, my pleading is in support of my prayer. That's what we want. Now, Milord, if my Lord kindly comes to the order, which is recalling whereof has been sought before my Lord. That is at page 38, Milord, starts at page 38, Milord. Now, Milord, will kindly come to page 39, Milord, the first paragraph. Yesterday, one complaint was made before this court at the time of mentioning on behalf of the Enforcement Directorate, that one person arrested by ED, namely Kuntal Ghosh, according to ED, who is involved in primary teachers recruitment scam, have made certain complaints through Superintendent of Presidency Correctional Home to the Hastings Police Station, making some allegations which are criminal in nature against the officers of ED, and the police has received the complaint. It was also submitted on behalf of the ED that the allegations were also made before the CBI against the ED officers, contents whereof is not known to the ED. This is very important. The contents of both the complaints was not known to us. Therefore, the question of naming that particular gentleman who is the petitioner before my lord does not and cannot arise. Had we got the piece of the complaint, my lord, we would have done it. ED was apprehending coercive action by police authority against officers of ED in respect of the complainant and the said Kuntal Ghosh, and any adverse order or remark by the CBI court in respect of ED officers. Considering the gravity of the situation, I initially directed, after hearing mentioning that no effect to those two letters indicated above could be given either by the police authority or by the CBI, and further directed the Commissioner of Police and the district judge of the concerned district judge court before 24 Pagana South at Alipur to produce the letters written to them at 3 p.m. So, my lord, even the honorable judge did not know it. My lord, what were the contents? I also directed ED to come up with an application immediately. Now, this is our Can 1 million, which the honorable judge gave us liberty to file. At 3 p.m., police authority produced the letters written by Kuntal Ghosh, which was sent to Hastings Police Station, and district judge produced the letter which was written to the said person and filed with the learned judge of the CBI court. At the same time, on behalf of ED, one application has been made before the court praying leave to move the application forthwith, but I granted them leave to file the same and move the application today and accordingly. The ED has filed the application for hearing and of the said application today. Now, my lord, will kindly see para 6, my lord. Then the letters came before the honorable single judge, and
Next day, we have.
Yeah.
That's why we submitted on the
My lord, next day we also were privy to the copies of those letters. Now, my lord, what happened is we started then amplifying our submissions on the basis of those complaints, which were very specific, and my lord, the petitioner centric.
So at the time of hearing, that is on the 13th, you had the letter.
Yes, my lord. Because my lord will kindly see what I've read, my lord,
Yes,
that the letters were called for more, and this. So, my lord, as far as that application is concerned, my lord, therefore I am saying, my lord, we had mentioned specifically that certain powerful people are involved. We could not mention the petitioner's name because we were not privy to that particular letter of complaint, where specifically his name has been mentioned by Kuntal. Compilation niye jabo sir ite aage because they ordered nahi ato ekdam sir. Now, my lord, will kindly see the chronological of events which had taken place, how these two things, my lord, are in nexus will come, my lord, because this came by way of our submission. Complaint एक बार पढ़ के सुना, पहले complaint पढ़ दें उसके बाद सुना कि क्या करो. My lord, we'll come to the complaint later, my lord. I was just going with the list of dates which have been cited by the honorable single judge. Now, my lord, paragraph 6. Today, the application was taken up for hearing, and the learned advocate for the CBI supporting the said application also made their submission. Now, my lord, on behalf of ED, some dates were mentioned before this court, which are as follows. So, my lord, we amplified on our 2021-1-2023 search was made at Kuntal's house. 21st January 2023 search and seizure at Kuntal's house continued. Then 21st January, Kuntal was arrested. 21st January 20, Kuntal was produced before the court and he was sent to custody of ED for 14 days. Now, Miller will kindly appreciate Kuntal was in custody for 14 days only with us. And all these allegations in his complaint of that. The doctor could have, if it was physical torture, then it could have come to the knowledge of the doctor. The report could have been filed. Nothing was there, neither by Kuntal nor by the doctor in the report. Now, my lord, after that, my lord, then, my lord, 3 to 3rd of February 2023, my lord. This is the day, my lord, where the period of police custody with the ED ended, my lord. And, my lord, we will show this order, my lord, on this particular fateful day, that is our 3rd of February 2023. The Honorable Judge of the ED Court, PMLA Court, asked Kuntal Ghosh that whether he has any problem regarding torturing, so more and so forth. He said nothing. He said, no, I am fine. No problem is there, nothing. And that was recorded by way of an order. And that in our compilation, we also have that, which we are going to hand over to my lord. Now, my lord, after that, on 17/2/23, 3/3/23 and 17/3/23, Kuntal Ghosh was produced from jail custody, and he prayed for bail, which was not granted. All these days, my lord, there was no allegation regarding torture, regarding putting word in his mouth, for making allegations against someone, so more and so forth. Then, my lord, 21st, my lord, we file our complaint under 44 and 45 before the learned court below, my lord. Now, my lord, on 30th of March 2023, Kuntal Ghosh gets a copy of that complaint, which we had filed before the PMLA court. My lord will kindly mark the date. Now, my lord, there we had not mentioned specifically the name of the petitioner, my lord, but we have said, my lord, that people are involved with who are holding high positions. Now, my lord, on 31st of March 2023, Kuntal made complaints and filed it before the CBI court and against ED and CBI. And again, on 1st of April, complaint of Kuntal Ghosh was made to the Hastings police station through the superintendent of the correctional home. So, my lord, there was a delay when he was in police custody till 3rd of February 2023. He did not make any such complaint. And it was an afterthought which happened due to happening of a particular event. This could be gathered from this list of. Now, my lord, we will take, my lord, to the compilation of the complaint of Kuntal Ghosh and, my lord, the public speech, so more and so forth. My lord. Now, my lord, the first is the speech, my lord. Since, my lord, we are all accustomed and we know, my lord, Bengali, my lord, I'm going to read it in Bengali, my lord, because then on that particular day, my lord, it was with regard to whether the translation. So, my lord, I'm not going to read the translated version. My lord, the first page, my lord, kindly takes up. Page 1, my lord. The speech of Sri Abhishek Banerjee. May I read, my lord?
Is it required to be read?
My lord, relevancy is there, my lord. A little bit, my lord, just for my satisfaction, my lord. কথায় কথায় বলতো না, ভাইপো এই করেছে, ভাইপো তাই করেছে। 3 বছর হয়ে গেল, এখনো মুখ দিয়ে অভিষেক বেরোয়নি। কি জ্বালা, কি ভয়। আমি তো 3 বছর আগেই বলেছিলাম, আজ ও তাই বলছি। যবে থেকে সারদা হয়েছিল, আক্রমণ ছিল আমার দিকে। এই মদন মিত্র বসে আছে। কুণাল ঘোষ দীর্ঘদিন কাস্টাডিতে ছিল। কি বলছে জানান এদেরকে, বলছে অভিষেকের নাম নাও, ছেড়ে দেব। কি বলছিল না, সারদা থেকে শুরু করে নারদা, তারপরে হলো গৌরু, কয়লা, SCC। আমি যত ইনভেস্টিগেশন CBI এর চলছে, আমি বুক ঠুকে বলে যাচ্ছি, সবার জন্য আইন আলাদা হলেও আমার জন্য আলাদা রাখার দরকার নেই। সবাই যদি দুর্নীতি যুক্ত থাকে, তার বিরুদ্ধে ED CBI লাগিয়ে দেওয়া হোক। আর বর্তমানে যত কেন্দ্রীয় সংস্থা তদন্ত করছে, ইডি হোক বা সিবিআই, আমার যদি কোথাও যোগ সাধক থাকে এবং প্রমাণ করতে পারে যে আমি যুক্ত, আমার পেছনে ইডি সিবিআই লাগাতে হবে না। যে সারদা হোক, নারদা হোক, টিইটি হোক, এসসিসি হোক, কয়লা হোক, গরু হোক, এই শহীদ মিনারের মঞ্চে আমি মৃত্যু বরণ করব, ফাঁসির মঞ্চে উঠে কথা দিয়ে গেলাম। So my lord, what I'm trying to impress is that এই মদন মিত্র বসে আছেন, কুণাল ঘোষ দীর্ঘদিন কাস্টাডিতে ছিলেন, কি বলছে জানান এদেরকে, বলছে অভিষেকের নাম নাও, ছেড়ে দেব। Now my lord, this is what was the speech. Now my lord, this particular speech, how it gave inspiration to Mr. Kuntal Ghosh has also been there on the media. Now the Bangla, if my lord, that statement before the which was this? The next day, Millard, when he came out, when he was being Millard, produced before the PMLA court, Millard, he gave this media bite. Kuntal Ghosh, that is at page 2, Millard. Millard, we also have a video, Millard. If Millard can allow, Millard, we can play it, Millard. Millard will kindly bear me. অবশ্যই অভিষেক ব্যানার্জি বলে দেয়া মানে আমাদের বুক চওড়া করা। কারণ হচ্ছে বারবার একটা কথা বলি যে এজেন্সিরা বিভিন্নভাবে ভয় দেখায় আমাদের কাছ থেকে, নেতাদের নাম বের করার চেষ্টা করছে, কিন্তু আমরা মাটি মানুষের আদর্শর দলের লোক, কিন্তু ওই ধরনের ভয়কে আমরা পাত্তা দিই না। আমরা বুক সিনা করে চলি। অভিষেক বন্দ্যোপাধ্যায়, it has been written in that fashion. Millard, I have certain Millard,
No,
but
it's all
Millard, I have learned Bengali, Millard.
Very well, continue.
Bengali was my third language, Millard, but I have learned it through. অভিষেক বন্দ্যোপাধ্যায় যখন বলে দিয়েছেন, একটা কথা বলতে পারি, সেন্ট্রাল এজেন্সি যেভাবে আমাদের হেনস্থা করছে এবং আমাদের নাম বলানোর চেষ্টা করছে, আমাদের দিয়ে আমাদের যত নেতা আছে সবার নাম বলানোর চেষ্টা করছে, তার জন্য বলপূর্বক চেষ্টা করছে। Now Millard, he has, here lies the next, Millard. 29th, the speech was given by the petitioner. 30th, this gentleman, because he has got that paper from the court where specific names were not given, Millard, but it was said he's privy to that. And Millard, he is also privy to this particular speech of the petitioner on the 29th, because he is specifically stating that he has been, and he has named Abhishek Banerjee twice, Millard. So, Millard, this came before the Honorable Single Judge, Millard, where he could, by way of our statement and by way of this, Millard, and now, Millard, I will take my lord to the complaints.
These documents were produced before the learned judge.
My lord, the statement of my lord, what I have placed before my lord was there, the two speeches.
It was there.
Yes, my lord, that my lord, I'm coming. That's crystal clear from the order, my lord. Therefore, my lord, that speech. My lord, 30th March statement was not there, because that was something which we are
Collected later on.
My lord, that was collected later on. But my lord, what we tried to impress upon, my lord, by way of amplifying our submission, which was there in the petition, in a manner which, my lord, will kindly see, since my learned senior friend was relying too much on the civil procedure code, my lord, plaints, what we have been taught, because I also belong to that branch of the bar, my lord. My lord, plaints are always 2 pages. It is amplification of those plaints by way of evidence, by way of document, which comes later. And ad interim orders are always passed on prima facie case. It is not after the investigation review. And what the Honorable Single Judge did wrong, my lord? I asked the question to myself, my lord. I will say, my lord, nothing, my lord. Now, my lord. And then buyers, so more and so forth, my lord. So such hard words were being used, my lord. Where, my lord? Just from the cuff, from the bar. The Honorable Supreme Court, when this was placed before the Honorable Supreme Court, the buyers, so more and so forth, my lord. In unequivocal terms and very harsh words, my lord, the Honorable Supreme Court did not do anything. The Honorable Supreme Court could have set aside that order and could have even given a similar relief of review. It was not given. It was just a mere transfer before my lord, and for that purpose, if all these points of bias, so on and so forth is taken, my lord, it's very unfortunate. Now, my lord, what are the compilation? It's a complaint. Now, my lord, will kindly take up the complaint, my lord. My lord, may I take my leave, my lord's leave, to allow my junior to read out that complaint, my lord, in Bengali, my lord, because it's in handwritten, my lord.
Yes.
So, my lord, I may have problem. The compilation.
Is it at page 4?
Page 4, Lordship.
Yes.
In the learned court of CBI Alipur Kolkata through Superintendent Presidency Correctional Home Kolkata. স্যার আমি 21/1/2023 সালে আমার ফ্ল্যাটে উজ্জ্বলা লাক্সারি অ্যাপার্টমেন্ট ফ্ল্যাট নাম্বার 903 টাওয়ার 1 অপোজিট অফ সিটি সেন্টার 2 ইডির হাতে গ্রেফতার হই। এই সময় ইডির রেড ডি কন্ডাক্ট করছিলেন ইডির অফিসার বিজয় কুমার। 21/1/2023 সকাল থেকে আমার ফ্ল্যাটে রেড চলছিল। ইডি কোনো রিকভারি দেখাতে পারেনি। আমার নিজের একটি প্রাইভেট বিএড ডিএলএড কলেজ আছে, সেটিতে ভর্তির জন্য আমার স্টুডেন্টদের ডকুমেন্টগুলি ওরা সিজ করে এবং রেড চলাকালীন প্রথমেই বিজয় কুমার আমাকে লাঠি মারেন এবং বলেন सच एंड सच बोल অভিষেক ব্যানার্জি কো কিতনা পয়সা দিয়া। আমি বললাম 1 টাকাও না। উনি তখন বললেন বল না হলে তোকে এবং তোর বউকে অ্যারেস্ট করব। Then Lordship at page 6. আমি বললাম আমি মিথ্যে কথা বলতে পারবো না, আরো গালাগালি খেলাম। আমার মাকে অপমান করলো। 21/1/2023 রাত 7টার পর বিজয়ের ফোনে বারবার কে যেন ফোন করে বারবার বলছিল আমি অভিষেক ব্যানার্জির নাম বলেছি কিনা। কিছুক্ষণ পর ইডি টিমের একজন বাঙালি সিপাহী ছিল বিশ্বজিৎ নামে, সে আমাকে বলল শুভেন্দু অধিকারী ফোন করেছে এবং পরে সেই কথা রাতে বিজয় কুমারও আমাকে বলেছিল। এরপর অ্যারেস্ট হয়ে আমি ইডিতে এলাম। 14 দিন পিসির মধ্যে 13 দিন আমাকে রাত জাগিয়ে ইন্টারোগেশন করা হয়েছে। ইডির ডেপুটি ডিরেক্টর রামধীন ডাগার আমাকে সবসময় আমার স্ত্রীকে ফাঁসাবে, 21 বছর জেল খাটাবে, আমার বাচ্চারা বড় হওয়ার পর তাদের মুখ দেখবে না, দেখবো আমি, ইত্যাদি ইত্যাদি। রামদিন ডাগার অভিষেক বন্দ্যোপাধ্যায়ের নাম না বলে বলতো আকা, বলতো আমার আকার নাম বলো, তাহলে 3 মাসের মধ্যে তোমাকে রাত সাক্ষী করে বাইরে বার করে দেব। এতেও যখন কাজ হচ্ছে না তখন শুরু হলো শারীরিক অত্যাচার। আমার পেটের চামড়া বারবার টেনে ধরা হতো, তার ফল আমি এখনো ভোগ করছি। রোজ আমার পেটে যন্ত্রণা হয়। ইডিতে আমি যে স্টেটমেন্ট দিতাম ওরা সেটা লিখতো না। বিজয় কুমার নিজের ইচ্ছা মতো স্টেটমেন্ট লিখে আমাকে দিয়ে সই করাতো। আমাকে এক প্রকার জোর করিয়ে স্টেটমেন্ট লেখানো হতো। আমি সেগুলো বলতে চাইতাম না, সেগুলো লেখানো হতো আমার সম্পূর্ণ অনিচ্ছাতে। সাইন such and such. Then Lordship, page 10. This is also addressed to in the learned court of CBI Alipur Kolkata through the Superintendent Presidency Correctional Home Kolkata CBI. স্যার আমাকে কাস্টাডিতে নেয় 21/2/2023-এ। সিবিআই আমাকে কাস্টাডি নেয় 21/2/2023-এ আলিপুর কোর্ট থেকে। 4 দিনের পিসি ছিল আমার। সেখানে একই ইডির মতো কথা,
কিন্তু এখানে আইও ওয়াসিম আকরাম খান কিন্তু আমার ওপর অনেকটা সহানুভূতি এবং ভালোবাসা দেখিয়েছে। উনি সেরকম অত্যাচার আমার ওপর করেননি, কিন্তু ডিআইজি যিনি ছিলেন তিনি বারবার আমার সাচানসাচ চেপে ধরতেন এবং বলতেন, অভিষেক ব্যানার্জিকে কত টাকা দিয়েছিস বল, না হলে শেষ করে দেব। যত অত্যাচার করত আমি হাসতাম। এক সময় উনি ক্লান্ত হয়ে পড়লেন। ওয়াসিম আকরাম একটা কথাই বলতো, সুজয় ভদ্রকে কত টাকা দিয়েছি। দেন পেজ 12, আমি বলেছি উনি আমার কাছে টাকা পান, ধার নিয়েছে। Thereafter, there's translated copies there, Lordship.
Order of that. And this is illegible. This you can read the translated copies. The complaint that was given to Hastings Place.
There's an illegible copy, Miller, and the translation of that copy which was given to the Hastings PS, Miller, is there, Miller.
Page 31.
Well, I will kindly take up page 31, Miller.
Improved upon.
Now, Millard, if my lord kindly goes to this complaint, Millard, there has been improvement from the other day's complaint which have been read. I, Kuntal Ghosh, son of, Millard has got page 31. Millard. I, Kuntal Ghosh, son of Swapun Kumar Ghosh, post so and so. I was fully conscious, without fear, in healthy brain. I'm writing my statement before you, that so far as I could disclose, that on my mind, due to fear of ED, I could not disclose the previous matter because ED Deputy Director Ramdeen Dagar kept me in fear, and that if I disclose to others, then they, ED, would again take me in PC by roping me in the false case and would beat me dangerously and imprison me for 21 years. Also, they would arrest my wife and prison her. I was arrested on 21st of March 2023 by ED from my flat at Ujjwal apartment so-and-so. Raid was conducted by Officer Vijay Kumar from the morning of January 20, 2023. ED could not show any recovery. I have my own private B.Ed DL ED college. They seized the documents relating to the students from their admission in the said college, and during the raid, firstly, Vijay Kumar kicked me and told me so-and-so. I told that I would not tell a lie. They used abusive language. Even they insulted my mother after 7 p.m. on 2023. Someone was calling on the phone of Vijay Kumar again and again, and they wanted to know whether I have disclosed the name of Abhishek Banerjee. After some time, the Bengali sepoy, namely Bishwajit, one of the team members of the ED, said that so-and-so was calling, and later on in the night, Vijay Kumar also disclosed the same to me, that I came to ED on arrest. I have been interrogated by keeping me awake for 13 nights and 14 days. PC, ED Deputy Director, Ramdeen Dagar, always used to tell me that my wife would also be framed and imprisoned for 21 years. My kids will not see my face once they grow up, etc., etc., without naming Abhishek Banerjee. Dagar used to say, Tera Aka ka naam bol. तुझे मैं गवर्नमेंट अप्रूवल बना के 3 months के अंदर बाहर ले आऊंगा और बीजेपी में तेरा अच्छा जगह भी बना दूंगा. Despite this offer, when they failed to take false statement, then they started physical torture. They pulled the skin of my abdomen again, as a result of which I am suffering till now and suffering from the pain of abdomen, and which is known to the SMO also. The statements which I wanted to record with ED is not recorded. Vijay Kumar recorded the statement on his own will and asked me to put signature. CCTV camera was running during interrogation in the room of Vijay Kumar. So he used to scare me with his eyes so that I know that would happen with me after leaving the camera room. So again, my own will, fear and assuming harm to my family, I agreed to do as per their will and wrote. But despite of thousands of torture, they failed to take out any false statement in the name of Abhishek Banerjee. Hereinafter, now, Millard, the CCTV aspect is not there in that complaint. Because, Millard, whatever interrogation is taking place, Millard, we are doing it under strict surveillance of CCTV camera, Millard. So, Millard, this has been a departure, or my lord, that has been an add-on. Now, my lord, next part, my lord. Hereafter, I am giving an important information that Tapas Kumar Mondal had given huge money to ED, and Tapas made a commitment that he would help to reach up to Abhishek Banerjee. Tapas was a broker of ED. Now, my lord, this has been incorporated as an afterthought, my lord. Now, because Tapas Kumar Mandal is another person, my lord, which we may come with a report before my lord, only for my lord's thing, my lord. Now, my lord, whatever he is improving, my lord, from there, my lord, the next is good. I have understood, my lord, that in order to thwart the investigation and put us, deter the investigation, these things are happening. Now, my lord, despite, now, my lord, after the CBI took me in their custody on 22/2023 from Alipur court, they also asked me same thing. DIG, CBI tortured me by holding so and so speaker. Now, my lord, so my lord, what I'm trying to humbly impress by this particular complaint which was made to Hastings, on which, my lord, the investigation as far as Kuntal is wanting the other petition which was not moved today, my lord, where he is wanting to investigation to begin. Now, my lord, this has been again crafted in an afterthought, my lord. So, my lord, now, my lord, as far as he is concerned, so this is crystal clear from these letters, my lord, of complaint, that he is not reporting anything happening to him after that custody period of 14 days. Whatever happened in those times, while he was in custody of the Enforcement Directorate. Now, my lord, will kindly see. Now, my lord, will kindly come to page 33. My lord, I had read that media bite of Kuntal Ghosh, which was at page 2 of the compilation. Now, my lord, this is the same day when he was before the PMLA court. On 30th, my lord, will kindly see page 33, my lord. Here, my lord, I am reading the order, my lord. Today is fixed for production of accused Kuntal Ghosh. Accused Kuntal Ghosh is produced in JC. Copy of the supplementary complaint dated 21/3/2023 is served upon him from the learned advocate. Learned special PPED so-and-so are present. They undertook to supply copies of the related documents on the next date. No bail prayer is made today. Hence, Kuntal Ghosh is remanded to JC till so-and-so, the date of production of supply. Now, my lord, here, my lord, there was nothing. A person who goes out to the media and gives the media bite, stating so many things, my lord. He says nothing. He says nothing. First complaint. Now, my lord, the next day he lodges a complaint, my lord. But on the 30th, my lord, he gives the media bite, my lord. And on 30th itself, he does not go to the court and say this, that this is happening and this has happened. I was afraid, so more and so forth, nothing. And then, my lord, on the 31st, he makes this complaint to the CBI court. So, my lord, now, my lord, I would, the chronological dates which had been recorded by the Honorable Single Judge in the order which I had said, that on 3rd of February 2023, the ED, the custody with the ED of Kuntal Ghosh was over. On that day, what was the order of the PMLA court? Will kindly see. That day, whatever he has said in his petition, in his complaints, says this on those 14 days, he was terrorized, he was tortured, so more and so forth, my lord. And that was the last date, my lord, when he was going to be out of the custody, my lord. So he then did not have any fear in my respectful submission, my lord. Then, my lord, and he was going for jail custody, my lord. Now here, if I may read, my lord. My lord, first two paragraphs are important, my lord. Accused Kuntal Ghosh is produced from ED custody along with medical report. On being asked by me, the accused did not complain anything about his health conditions. And this question was put to him specifically by the learned judge. So, my lord, here on 30th, there is no complaint, nothing, my lord. Whatever has been stated later on. Now, my lord, will kindly see. Wait. Now, my lord, will kindly come to the order once again, my lord. The order which recalling whereof has been short from, my lord. I stopped, my lord, at page 42, where the list of dates were there, my lord. Because I wanted to show my lord vis-a-vis what actually the complaint was and what was the order of the PMLA court and so more and so forth. Now, my lord, will kindly see. So this proportion of the order, my lord, which I have shown, my lord, that on Fund 1/4/2023, Kuntal Ghosh was made a. So, my lord, there was a direct nexus which was before his lordship by way of letter of complaint, by way of the media bites, both the petitioner as well as Kuntal Ghosh and the complaints, and the chronology of events which we had submitted before his lordship. So, my lord, from this chronology, and my petition also said that Kuntal Ghosh has lost this complaint because so many politically influential people are involved in it. And if, my lord, this is allowed to happen, it will be opening up Pandora's box, and the last thing would be hope for VED officer or any officer who is investigating it. Because every now and then, every person who is an accused, whoever is roped in, will come up with a complaint, and that will stall the investigation, my lord, to such an extent that nothing will proceed. Again, coming on the civil side, my lord, which my learned friend was, my senior friend was saying, my lord, what happens if frivolous applications are filed, my lord? The suit will never proceed. So, my lord, if these complaints are going on, being filed by each and every accused, my lord, as an afterthought, and which gives rise to FIR being lodged against the officers who are undertaking this job, it will be a never-ending process, my lord. Now, my lord, will kindly see the order then, my lord. Now, my lord, here I take note of one public meeting held by one Abhishek Banerjee on 29/3/2023. My lord, I'm last line, my lord, where he urged some persons to support him by saying that when those persons were in custody, police or interrogating agencies pressurized them to name said Abhishek Banerjee. The complaint of Kuntal Ghosh was made in close proximity with the said public speech of the said Abhishek Banerjee on 29th March 2023, as Kuntal made the first complaint on 31/3/2023 before the CBI court and on 1/4/2023 before the Hastings police station. It is a matter to be inquired and investigated whether Kuntal Ghosh took the cue from the public speech of said Abhishek Banerjee, for which both of them can be interrogated both by ED and CBI, and such interrogation should be made soon. Terrorizing the investigating officers of the investigating agencies by complaint before the police authority by wholly unwarranted, and such endeavors are to be stopped forthwith. Otherwise, the officers of the investigating agencies will not be able to act in fearless mind, and in view of such oversmart action which is rising in the state, the court should give immunity to the officers. Keeping this in mind, I hold that such interrogation should be made in such a situation. Now, my lord, submissions. Now, my lord, will kindly come to page 44, paragraph 10, my lord. Here, my lord, we also put before his lordship that order which we have shown of the PMLA court, my lord, where it has been amplified here from, rather recorded, my lord, from paragraph 10. From one order produced before me in ML case number 13 of 2022 on behalf of the ED today, being order number 32 dated 3/2/2023, I find that the judge of the special CBI court, so-and-so PMLA court, personally asked said Kuntal, and the accused Kuntal did not complain anything about the health condition, though in his letter he has said that because of some pinching by the interrogating officer of ED in his abdomen, he is still suffering. It is to be noted that the custody of ED came to an end on 3/2/2023. Other allegations of Kuntal are that the investigating agencies are trying to force him in the name of Abhishek Banerjee. The same tune was heard from Abhishek Banerjee in the public meeting on 29/3/2023. The matching tune raises a serious doubt in my mind as to the tacit understanding between them, as when this Kuntal was selling school teachers' job, both Kuntal and Abhishek were in the same political party. Now, my lord, not going into that aspect, my lord, what was before his lordship was clear as crystal, my lord. On technicality, my lord, an order which is not affecting anybody adversely, my lord. And my lord will kindly appreciate, a particular case was lodged, my lord. Investigation is already going on. It is not that we have been given a special power by this particular order to investigate into the deeds of one particular person. Even if this 29th, if I take an argument even further, even if the 29th speech is not allowed, was not directed to be looked into by the honorable judge, we would have gone it, and nobody could deter us from doing that, my lord. Under the law, we have the power. My lord, we have the power because investigation is going on. Now, my lord, so my lord, what wrong? A question I'm asking myself, my lord, the honorable single judge did, for which these submissions of bias, so on and so forth is coming, my lord. Now, my lord, will kindly come to para 17, my lord. My lord, may I come at 2 minutes or tomorrow, whatever is my lord's?
No, I want to finish it up. Because the vacation.
My lord, CBI is also there, my lord. আমার লাগবে এখন না তুমি এসো না আমার চলছে
I will not take more than 20 to 25 minutes. I will not.
Yes, please do. And Mr. Bhattacharya will also take some time.
My observation that lordship's time is wasted. Because in special petition, all these grounds were taken in detail, word by word, verbatim. Special petition has been disposed of.
Yes.
In fact, dismissed only direction to change of the assignment. And the order which was passed has reached its finality. Therefore, I will not take more than the 7 minutes.
Then we'll finish it up today itself.
My lord, I have no issue. My lord, that was my first point, what my learned senior friend is saying. That is my first point.
Mr. Basu's reply also today. Because we do not have much time before the vacation.
Hear me today.
My lord, what I'm hearing now, Mr. Trivedi was arguing on Kuntal mainly.
My matter he is arguing. He's asking for quashing before your lordship.
But
No,
probably he was
quashing.
replying my submission.
Yes, yes.
Half of the argument is that state would like to assist me.
Yes.
Commitment will get
He was placing his application also. Thing is this, he was placing his application also, what prompted the judge to pass this order.
So to that, my lord, his main submission is Kuntal. I am not Kuntal.
No, this I have.
Coming to him also, my lord, I will leave no stone unturned. My argument is not yet complete, my lord.
You'll come in the meantime. Very well. Yes, yes.
Hear us also today.
Yeah, let us see, if possible, yes.
আবার অন্য মামলা এই রে
Who is your other side?
ধরে নিয়ে স্টে হয়ে গেছে যা
Bring your other side. Had the other side been here, I could have taken it here and now.
ধরে নিয়ে দূরের সময় চলে আয়
Then
খোঁজ না খুঁজলেই পেয়ে যাবি
this matter will be over thereafter.
ততক্ষণে ভেঙে দেবে
In the meantime, very well. If you come, let us see.
Point को लेके बैठ जाओ।
order, Lordship was pleased to, my lord, relegate us to the appellate forum.
Yes.
Page 14, in view of the above, the petitioners are granted liberty to appeal the provisions of section 403 of the Act before the appellate forum. In the event the petitioners are unable to obtain any order setting aside stay modifying the impugned order under section such and such within 28/4/2023, then it will be open for the main agents of the corporation to take necessary steps in the matter in accordance with law. This order of your lordships is on 30th March. Next page, my lord, 30th March itself, my lord, we file the appeal, which is at page 15. At page 16, my lord, on 4th, we prefer the stay application. It is recorded. Kindly comes to the next paragraph. The stay petition is filed, I think, fixed 26/4/2023 for hearing of the stay petition. Appellant is directed to serve fresh notice upon the respondents acknowledging the date of hearing of the stay such and such for SR fixed 26/4/2023 for SRAD, and service is satisfactory. Stay shall be kept on. Stay shall be heard. Now, my lord, next date is page next 17th is 26/4/2023, my lord. Today is fixed for SRAD. Learned advocate for KMC is present. Learned advocate for the appellant is also present. Steps in the meantime. Steps taken in the meantime, my lord, fixed for 18/5/2023 for SRAD. So therefore, this, in view of the fact that the private respondent didn't appear, we couldn't press the stay application.
Why?
Because it was again fixed for SRAD.
No, but
Until
then,
the service is complete.
who prevented you from pressing the stay?
No, my lord,
There is
the
nothing.
tribunal didn't took it, fixed a date for SRAD. So, my lord, we have, our endeavor is there on 20 till 23rd, your lordship was pleased to order. Now, my lord, we have taken steps. In the meantime, a show cause was issued prior to, my lord, 28/4/2023. Next page. Kindly sees the date fixed before the tribunal was 26th. The show cause has been issued on 25th. And, my lord, thereafter I give a reply to the show cause. And, my lord, this impugned notice has been issued. My lord, today is the date fixed. My lord, page 25 is the notice, my lord. I hope a legible copy of this has been given to your lordship. But today they have already gone to the local, my lord, with police, my lord. But we have taken steps, my lord. We have gone to the appellate authority at the first instance, my lord. We are pressing. It is not that there is a latches on our part, my lord. We have effected service, my lord. They didn't appear. Lordship, may kindly, my lord, these are 2 stories of building, my lord, which the allegation is that I have constructed two-story additional floors. My lord, if they demolish, my lord, the entire process will become, my lord, infructuous. Only, my lord, some days until my stay petition is heard out, my lord,
Pursuant to your lordship's order, my lord, only 28 April 2023.
Please go. The notice issued under sections 544 and 546 of the KMC Act 1980, dated 3rd May 2024, is impugned in the present writ petition. Stop. The petitioner is already facing an order of demolition. For raising unauthorized construction at premises number 3/1 PK Chatterjee Road, Ward number 67, Borough 7 of the Kolkata Municipal Corporation. Stop. Challenging the order of demolition, the petitioner preferred a writ petition before this court, being WPO 734 of 2023. Stop. The court, by order dated 30th March 2023, was pleased to dispose of the writ petition by granting liberty to the petitioners to avail the benefit under section 400 within bracket 3 of the Act before the appellate forum. Stop. The court directed that in the event the petitioners are unable to obtain any order setting aside / staying / modifying the impugned order under section 400 within bracket 1 of the KMC Act 1980 within 28th April 2023, then it will be open for the men and agents of the corporation to take necessary steps in the matter in accordance with law. Stop. Next. It appears that the petitioner preferred the appeal before the appellate forum, being BT Appeal number 83 of 2023 on 30th March 2023. Stop. Date was fixed on 2nd May 2023 for service return and AD.
That is the main appeal.
The petitioner thereafter filed a put-up petition on 4th April 2023, which was perused by the learned tribunal and the matter was fixed on 26th of April 2023 for SR and AD. Stop. On 26th April 2023, learned advocate for the petitioner, being the appellant before the tribunal, and the learned advocate representing the corporation were present. Stop. Learned advocate representing the petitioner submits that as the private respondent remain unrepresented, the court was pleased to adjourn the matter till 18th of May 2023 for service return and AD. Stop. Next. Paragraph. The corporation, as per the direction passed by this court on 30th March 2023, issued the impugned notice on 3rd May 2023, as the petitioner herein admittedly failed to obtain any order either staying or setting aside or modifying the order of demolition passed under section 400 within bracket 1 of the KMC Act. Stop. Next. Paragraph. The petitioner submits that in the event the structure in question is demolished, then the appeal itself will be rendered infructuous. Stop. It has been submitted that the petitioner, after the order was passed by this court on the 30th of March 2023, immediately preferred the appeal and thereafter took steps for hearing of the stay petition. Stop. The petitioner left no stone unturned to get the stay application heard, but the learned tribunal fixed the matter on 18th of May 2023. Stop. Next. paragraph. Learned advocate representing the corporation submits that the representative of the corporation acted in strict accordance with the direction passed by this court. Stop. Next. After hearing the submissions made on behalf of both the parties and upon perusal of the materials on record, it appears that the petitioners were vigilant enough to get the stay petition heard by the learned tribunal. Stop. The learned tribunal, despite noticing that the High Court had granted stay of the order till 28th of April 2023, ought to have taken steps for passing necessary order in connection with the demolition order.
Next it is.
Stop. The tribunal ought not to have fixed the matter on 26th April 2023, just 2 days prior to the expiry of the interim protection given to the petitioner. Stop. Even assuming that the tribunal fixed the matter on 26th April 2023, the necessary order ought to have been passed on the stay petition filed by the petitioner. Stop. The stay petition ought not to have adjourned without passing any interim protection in favor of the petitioner till the 15th of May 2023. Now, till the 18th of May. Because by that time, the interim protection granted by the Honorable High Court would have lapsed. Stop. Next. It goes without saying that the tribunal ought to have appreciated the principle that no person ought to be prejudiced by any order passed by the court. Stop. Next. In the present case, though the petitioners took steps before the appellate forum in due time, but despite effort, the petitioners were unable to obtain an order of stay. Stop. Next. It was for the tribunal to pass interim order or at least ad interim order upon consideration of the stay petition filed by the petitioner, and ought not to have mechanically adjourned the matter till 18th of May 2023. Stop. Next. As the court is convinced that there was no delay or laches on the part of the petitioner in acting in accordance with the direction passed by the court, and in spite of best effort, the petitioners could not get the stay petition heard by the learned tribunal. Accordingly, the assistant engineer from a building department, Borough 7, KMC, who issued the impugned notice under sections 544 and 546 of the KMC Act 1980, is directed to be kept in abeyance for the time being. Stop. Next. The tribunal is directed to take steps. Now, is directed to consider the petition for stay filed by the petitioner and pass necessary order on 18th May 2023. Stop. Next. In the event the private respondent remains unrepresented on 18th May 2023, the tribunal shall pass order after hearing the petitioner, the learned advocate representing the KMC, and upon perusal of the materials already on record. Stop. Next.
There is no private respondent, I think, because
India.
my lord, even in the that is order of the tribunal, there is nothing because the file is there. You will just kindly direct the tribunal to hear out the issue on merit, either rejecting or allowing. That is the thing.
Yes. But then this is the submission that the private respondent is there.
Visually Industries, Vijay Enterprise, it is there.
I don't know whether the private respondent is a
Yes,
party
it
or
is.
not.
Yes, yes, been implicated as party. They have been implicated as party in the tribunal.
কি বললাম? কি বললাম? Materials on record. Stop. The executive engineer within brackets civil/building/borough 7 is directed to immediately transmit all records in connection with the instant case before the tribunal so that the matter can be effective, so that the stay petition filed by the petitioner can be effectively dealt with by the tribunal on
Already there, I am sorry.
18th May 2023. Stop. Next. The writ petition stands disposed of.
Deprivileged.
Record has already been transmitted.
Then that is good.
Lordship. My lord, till there is interim order kept in amnesty.
Let the tribunal take a decision.
Lordship.
Because if the court passes the time and the tribunal fails to comply with it, then again he has to come. And your officers will also be troubled.
In trouble. They are there. I actually stay there.
Yes. Yes.
No, my lord, since before your lordship had risen for the recess, my learned senior friend for the petitioner had come and said that I am arguing only on the aspect of Kuntol. And my lord came to my rescue saying that I was trying to amplify whatever was there in petition. Now, my lord, therefore, I will now take up my argument from that particular angle, will address that particular question of my learned senior friend. Now, my lord, why I am here, my lord? What this application? This application is a very cleverly drafted application where they have come so-called with an innocuous prayer that there is only one speech. I am a public leader. I can go on air and I can make certain comments. And why such a lot of ruckus because of that speech, and why I am being dragged into an investigation where there is prima facie nothing against me, no allegation, nothing under the sun, and I've just been dragged. The Honorable Single Judge has just picked up one particular speech, which I am very much within my right to make. And it was something which has nothing to do with this Kuntol or any person who is still now under the ambit of investigation. And therefore, I had said something which was with regard to other leaders, so more and so forth. And therefore, why my speech? Because this is a devil's tool which the Honorable Judge, because of his bias, have picked up this, and he is now trying to implicate me in that particular investigation from that particular angle, which is absurd and not at all arbitrary, and it is sheer bias of the Honorable Judge. This is what they are wanting to say. Now, my lord, why? Because now I am trying to amplify on that aspect. What is the prayer, my lord, will kindly come? Very innocuous prayer. He is not also wanting the recalling of the entire order. My lord, we kindly come to page 25 of the petition, can 6. And my lord, at the very onset, I am reserving my right, my lord. This application is not maintainable. And more so because intervening application has not been allowed. So he does not have any locus. I am surely going with the submission what my learned senior friend made, that this is not maintainable, my lord. But just because my lord told me that I should also delve into the factual aspect, therefore I'm going. Now, my lord will kindly see. Recall that part of the order. It's not the recalling of the entire order. Recall that part of the order dated 13th April 2023, passed by the Honorable Justice Abhijit Gangopadhyay and so, to the extent that CBI and ED have been directed to investigate all aspects of the public speech of the applicant herein and to inquire and investigate whether Kuntol Ghosh took cue from the public speech of the applicant herein to file the complaint against ED and CBI. And then secondly, expunging of the following observation contained in the order dated 13th April 2023, passed by the Honorable Justice Abhijit Gangopadhyay in so. Here I take note of one public meeting held by one Abhishek Banerjee on 29/3/2023, wherein he has urged some person to support him by saying that when those persons were in custody, police or in interrogation agencies pressurized them to name the said Abhishek Banerjee. And then, Millard, the interim order is again replica of that. Now, Millard, what happened, Millard? What we did, what wrong the Honorable Judge did. If now, my Lord, again I come to the order. There was, I wanted to place this argument last, but now I have put it before, Millard. What happened, Millard? The chronology of dates which have been made part of the order, and which I, by way of my compilation, also said the sum and substance, what was there in complaint. Millard, all these things, all these complaints could have been made in the same manner which it had been done on the 30th, 31st and 1st of, it could have been done. But it was very significantly done on the 31st and 1st. That was after 29th when that speech was made. Now, Millard, nothing would have come. If that speech was not referred to, though not directly, but indirectly by this gentleman who made this. He said, my Lord, again at the cost of repetition, my Lord will go through that, his statement before the media, which he does not even go before the court and say that this is in my mind. He has got bolstered and he refers to that speech. Twice he has named the petitioner that Uni bole diye chen. Uni bole chen. He has got inspiration and he has stated that. So the Honorable Judge did not because of any bias. You know, there's a saying in Sanskrit, pratyaksham kim pramanam. That was apparent on the record that the person 29th speech has been made, my Lord, he refers to that speech. And then he gets bolstered. 30th, he says nothing before the court. 31st, he goes, and then there is an embellishment on the 1st, which goes to the local police station. Before the CBI, am I right? Before the CBI, the complaint, he does not bring in name of other co-accused persons who he knows after reading that particular letter which he has got from the court, where he has gone through the statements. And then there's an embellishment, he tries to get them also. So, my Lord, all these things, my Lord, when the Honorable Single Judge was told that was the triggering point was that 29th date. Therefore, now what the Honorable Judge has said, my Lord, again, once again, I come to the order, my Lord. So now I am taking the angle of the petitioner. And now, first I will come, then again I will come that why innocuous this prayer, how it is going to help him. He has couched this particular prayer in such a manner, in this particular way, so that it will have a more everlasting effect on this investigation, where no coercive action will be taken against him while he will be showing this order. That is it. Now, my Lord, will kindly come to the order. What went wrong, my Lord? I ask the question again and again to myself. What wrong the Honorable Single Judge has? Now, my Lord, will kindly come to paragraph 16, my Lord. That is at page 47. My Lord has got it?
Yes.
My Lord, may I read? After reading those two letters and after hearing the parties, I find that the contents of the letter are foolishly concocted, and there are real exaggeration and embellishment of the letter dated 1/4/2023 written to the officer in charge, Hastings Police Station, where the allegations are similar to the letter filed before the court on 31st March 2023. Now, Millard, then Millard, paragraph 17, Millard, these things have also happened in the past, which was actually submitted by the learned advocates appearing for the respective agencies, Millard. The court wanted to know from Mr. Biledul Bhattacharya, learned advocate representing CBI, and Mr. Shomrat Goswami, learned advocate representing the ED, whether in investigating officers in respect of other scams in the state are also facing same situation. Complaint to the police by some persons against the officers, and the police is investigating those complaints and interrogating the officers. Mr. Bhattacharya gave me 3 names referring to the coal scam, and the names are Mr. Kapil Raj, Joint Director of ED, Mr. Umesh Kumar, SP of CBI, and in respect of the custodial death of Lalan Sheikh in Boktoi case, one officer not at all even remotely connected with the investigation, namely Mr. Shushant Bhattacharya of CBI. Now, Millard, now I come to the order. What is, Millard, the problem with the order, which has been actually, when they went before the Honorable Supreme Court, they said, Millard, they are affected by 2 portions of the order, Millard. 19, Roman 3, subclause Roman 3, and subclause Roman 4. This has also been said in the order of the Honorable Supreme Court's order as well. The first order, Millard, if my lord kindly see, that is on the next page only, page 51. 52, Millard, to be more specific. Page 52, Millard, will kindly see paragraph 3. So, Millard, they had made this submission that they are affected by 19 subparagraph 3 and 19 subparagraph 4. What are these, Millard? My lord will kindly see. 3 is ED and CBI are directed to file report of their investigation into the matter, if necessary, with the video recording before the court on 20th April 2023, when this matter will be taken up on up at 12 noon. All the aspects which have been indicated above, including the public speech of one Abhishek Banerjee, should also not be outside the investigation of CBI and if necessary by the ED. Now, Millard, I come to the first portion of how the order started. First, again, I come back to that particular submission of bias, and that court monitored investigation. Investigation cannot be monitored. It cannot be. What was the order? My lord will kindly see page 48, paragraph 19(1) of the order. The Honorable Single Judge said, I'm reading, Millard, 19(1). From today, no police station shall lodge any FIR against any complaint made to it in respect of any officer of CBI and ED who is investigating the educational recruitment scam, both in West Bengal School Service Commission and West Bengal Board of Primary Education, without the leave of this court. Now, Millard, under the fact and circumstances, and after going through the entire gamut of what is happening, which was clearly there, prima facie, before the Honorable Judge. So the Honorable Judge came to this conclusion that in order to not, because this has been in order to deter the officers, Millard, these frivolous applications and frivolous complaints will be filed, and FIRs are being registered. If they are arrested, they will be suspended. If they are suspended, investigation will be stalled. And if an FIR is registered, he is a public servant, he will deter, he will go on the back foot. So ultimately, the investigation process will be affected. So it was no blanket order, a blanket immunity given to any officer. It was with the leave of the Honorable Court. Why so much apprehension? Just because an investigation is going on. Why apprehension? Now, Millard will come, kindly come, and then Millard to subparagraph 3. ED and CBI are directed to file a report. My lord, again, at the cost of repetition, I am impressing upon my lord, investigation was going on. It was not that this particular order has triggered off a fresh investigation. Direction for a fresh investigation that this person should be given hearing, that person should be given hearing. That was not the case. Here, the Honorable Single Judge has said specifically ED and CBI are directed to file report of their investigation into this matter. And that the Honorable Judge has already said before that, if I'm not mistaken, my lord, my learned friend will also be akin to me, that reports have been filed from time to time. अरे भाई इसमें नहीं हुआ है, रिपोर्ट तो और भी चीजों में मांगा गया है, और इसीलिए बोल रहा हूँ मैं, बाकी में तो रिपोर्ट not in this case, my lord, I'm not vouching for the cause that in this case we have filed, but my lord, the order, plain reading of the order. ED and CBI are directed to file a report of their investigation into this matter, if necessary, with the video recording before this court on 20th April 2023, when this matter will be taken up at 12 noon. So, my lord, only a report is to be filed with regard to investigation. Then, my lord, all aspects which have been indicated above, including the public speech of one Abhishek Banerjee, should also be taken in, should also not be outside the investigation. Why, my lord? Which I told, my lord. Because the entire thing has been triggered off on that particular date. And nothing is there to show, which is cogent in nature, as to what prevented this Kuntal Ghosh from making all these complaints prior to 29th. Nothing. But only one thing which stands, that is the speech. And that also because it has been referred to by him in his statement before the media, which is online. Everybody knows it. So it cannot be anybody's case that he did not know, because it fell on the other day from your lordship that whether televisions are there in the, my lord, that has crossed that level, because he himself has come and confessed, and he has named this gentleman twice, that he has given, I have been inspired from him. So therefore, the links are matched, and I am not prima facie. So, my lord, the Honorable Single Judge said, all right, because you all are saying that everything has got triggered off from that particular speech, you may also take it into consideration. A person who's giving a speech saying that I will hang myself without any investigation, why he's shying an investigation, why he's shying his speech coming into the ambit of investigation. He has gone on record saying that I'll hang myself. So why he's shying, and what wrong has the Honorable Judge done? He has said all aspects of which has been indicated above, including the public speech of one Abhishek Banerjee, should also not be outside the investigation. So why this apprehension, my lord? Why this apprehension? My lord, I remember, my lord, saying in Bengali, I should not go online with that, my lord. Apprehension when I say that something has been, who was there in the house, and I come and say that I did not eat that. So, my lord, this is what I'm trying to say, my lord. Now, my lord, for this, in order to now, so therefore, my lord, now, if today my investigation is stalled by an order, what will happen? An order will be passed by this honorable court saying that no coercive steps to be taken, nothing to be done, and that order will stand as salvation of the petitioner to deter me from taking my investigation of. If at all the person is, and it is not that I cannot investigate on him, because when I'm investigating, anybody and everybody can come under my scanner. Why this speech? Even for going to that level, that even if this speech is not taken into consideration, my lord, I don't need, in my respectful submission, even if the honorable judge had not ordered this, then also I could have gone into that. Nobody could have stopped me, my lord. So, my lord, why this application? What they are wanting? Why this expunging? Which was within my ambit, within my power. So the honorable judge did nothing wrong to the detriment of the petitioner.
Very well.
And not beyond him. And of course, there was no bias. And, my lord, the order which has been upheld by the Honorable Supreme Court, in my respect, deepest of respect, my lord, cannot be reviewed, or, my lord, recalling cannot be done by this honorable court. And, my lord, when I will be, my lord, I have got the statements which had been given to Mr. Kuntal in the court, the statements, why this embellishment took place. It is in a sealed cover. And, my lord, while I will be dealing with the argument made by the learned counsel for Kuntal Ghosh and the other, my lord, we will, because as far as the petitioner is concerned, my lord, since he has asked for only expunging of this account, and therefore I am before my lord, why I wanted, because 29th is the triggering of date. My lord, I partly rest my submissions as far as this
Yes.
application is concerned, my lord, and reserving my right, my lord, that this application is not maintainable per
Yes.
se.
Permitted to speak before him or Mamla Dhuri. Because the division bench will, that is very short point. The question is the order which has reached its finality. Can it be, my lord, recalled by the Honorable High Court, superseding the order of the Honorable Supreme Court? May I just place the orders passed by the Honorable Supreme Court, which you also gone into? I am not troubling, my lord. Let us see what was the special petition. Which are the grounds on which the special petition was made, and what are the aberments and the grounds taken out in the recalling application. This is a recalling application at the best. The kindly take.
I'll be back within 2 minutes, my lord.
Takes up, my lord, the special petition. I just show you the grounds on which. Kindly come to page 18. Questions of law. First is whether the learned single judge, by implicating the petitioner in an ongoing investigation by CBI and ED, has acted in violation of principles of natural justice and law laid down by the Honorable Supreme Court in such and such. This point has been repeatedly asked, probably only 1.5 days are put on this point. Then kindly, next ground, whether the learned single judge has erred while passing directions for the investigation of the petitioner. When, kindly note, my lord, for the investigation of the petitioner, when neither of the investigating agencies prayed for conducting an investigation against the petitioner herein. This is the point argued here in detail. Whether learned single judge, by implicating the petitioner, basis the public meeting held on 29th March, has acted in violation of the fundamental rights bestowed upon the petitioner under Article 19(1). So this was the level of argument we sought to advance to the Supreme Court, even to the extent of fundamental right. Then whether the learned single judge, merely based on his surmises and conjectures and close proximity of the public meeting held by the petitioner with the letters issued by Mr. Kuntal Ghosh, has embroiled the petitioner herein a full-blown criminal investigation. Whether the learned single judge, by directing investigation against the petitioner and non-party, has exceeded jurisdiction under Article 226. These are the points of law, and kindly see what are the grounds. Next, page 20. Much of time has been consumed here on the question of pleading. Because the ground A, the V-Day impugned order herein, the Honorable High Court has in utter disregard to the principles of natural justice, has, while exercising writ jurisdiction, has expanded the scope of the writ petition before it, used his personal knowledge, which is also the point of attack here, which was neither pleaded through any pleadings before it, nor argued by any of the parties to arrive at a conclusion about a third party, that is the petitioner herein, in a completely cavalier and patently illegal manner. Such overreaching attempt in the impugned order is not only detrimental to the petitioner, but also unheard of in judicial principles. And on this ground alone, the impugned order deserves to be set aside. But this was the main prayer also. Then because the petitioner here is a member of the parliament from Diamond Harbour constituency, so has been dragged into an impugned order in writ filed by the candidates. That 2014 malpractices where prayers for investigation by an independent agency and direction for furnishing information relating to the said examination was sought. While hearing an application on a complaint made by one accused, mainly Kuntal Ghosh, against the officers of ED-CBI for allegedly coercing him to name the petitioner in the ongoing investigation relating to malpractices in primary education recruitment, which has been initiated by the order dated 13th of June 2020. Because to the utter shock and surprise of the petitioner here in a completely unrelated incident, which was the public speech delivered by the petitioner on 29th of March, which was within the personal knowledge of the Honorable Court. We'll kindly underline this attribution to the Honorable Court, has been made the basis
of forming an erroneous opinion that it is connected to the complaint filed by the Kuntal Ghosh without adverting to the merits or otherwise of the complaint, which again was not the subject matter of the Honorable High Court. Because it is most respectfully submitted that merely because the High Court is exercising writ jurisdiction roster for a specific case, he subsumes the criminal roster for any and all ancillary proceedings, devotes the governing rules, and in utter disregard to the practice and procedures set out herein. Well, I don't take my lord's time to waste any further. Then the repetition of the same grounds. Now, my lord, one important thing, my lord, so far everybody, my lord, who is having the experience of appeal, my lord, in the Supreme Court decision, SLP petition was either rejected or taken up. This petition was taken up for 3 days. There was the Supreme Court, my lord, had deliberate, conscious knowledge of the entire thing. And then let us see how the Supreme Court will dispose of this petition, which the orders are annexed. Kindly turn to, my lord, page 50. I will read line by line to show that these applications are not even entertainable. The page 51, the first day order, which was on mentioning ex parte. Dr. Singhi, senior counsel for the petitioner, mentioned the special petition for early listing. Kindly come to paragraph 3. Dr. Singhi has adverted to the observations contained in para 10 of the impugned order of the single judge, as well as the directions in paragraph 19, 3 and 4, by which the Enforcement Directorate and Central Bureau of Investigation have been directed to file a report of the investigation respecting public speech stated to have been made by the petitioner. But this was the crux and the fundamental ground of attack on mentioning. Then the Honorable Court was pleased to not pass an interim order till next date of hearing. Then page 53. Now, I do not read page 53, but these are all relates to the, if I may see, similar parrot chanting of bias and bias. The Honorable Court goes into that and then finally passes order without page 57. Well, permission to file SLP is granted. Well, this has a great significance. Therefore, the SLP was admitted. Therefore, the court was in full knowledge and control of the whole proceedings and pleading. Then the court says, pursuant to the order of this court, now that I again skip over that, but these are all relating to a particular attribution to the learned judge. Then paragraph 3, having considered the transcript, we direct the acting Chief Justice of the High Court shall reassign the pending proceedings in the case to some other judge, Calcutta High Court. The judge to whom the proceedings are reassigned by the acting Chief Justice would be at liberty to take up all applications which may be moved in that regard. These are all the prospective to the passing of the order by the Supreme Court. And that's very clear. And but if I may make this comment that the Honorable Supreme Court here really exercised jurisdiction under Article 142. Otherwise, the High Court is also a constitutional court, not subordinate to the Supreme Court, except 142 and 141. Therefore, this reassignment direction was under Article 142. And then the next one is a judicial direction upon the reassigned judge to hear all applications which may be moved. Now kindly come to this. Pending application, if it is can disposed of, the interim order which was initially passed is consciously not extended. Thereby, the order which was passed by the Honorable Judge has reached its finality. Now, they have the right to come up before this court in the application, any sequences consequent to the said order. But no one has any right under the law to ask Honorable High Court, you recall the order which was passed by the Supreme Court. The Supreme Court has closed the chapter by not extending interim order. When these grounds were before the Supreme Court, all these grounds, I think nobody will come and say the Honorable Supreme Court did not see this petition. It was done on a blink of an eye, no. And this has reached its finality and finality. Inviting this court to not interfere with that order would be inviting this court to violate the Supreme Court's order, and which my lord is quite aware and conscious of, therefore, my lord, reject this application. If they have anything to say after this, something has developed, therefore, if you want to move, move. But you do not have legal right to call off this application. And all these pleadings and other things doesn't have any application. So for the criminal cases are concerned. I will conclude, my lord, with this point. When an FIR is lodged, just an information. FIR is not an encyclopedia of everything. Investigation starts, we do not know when during the investigation who will be found to be involved in the rope. And then they will again be investigated, interrogated. That's a part of the investigation. Here, the honorable judge, when approached by a particular agency saying that there are allegations against us, the honorable judge permitted them to carry on the investigation. And anyone and everyone, it so happen tomorrow, myself or my junior or Mr. Bilal Bhattacharya also call for the common for investigation. If you are a responsible citizen, your primary duty under the law is to help and support the investigation. And this order in Muhammad Sallallahu, this application for recalling of the order which has got the seal of the Supreme Court is a dangerous, adventurous step. May I take leave?
Yes.
May I have your lordship's kind leave, my lord, on behalf of the Central Bureau of Investigation, my lord. And I'll just place the case, my lord, in a different perspective. My learned friend, Mr. Trivedi, has already, my lord, delved into the factual aspect of the matter. Mr. Bhattacharya has also made his argument, my lord. My lord, what I intend to say is, my lord, there are certain points of law, my lord, that I'll be taking, my lord, I'll be referring to, and I'll be arguing, my lord, that the petition on the face of it is not maintainable. Now, first of all, my lord, enough has been submitted vis-a-vis, my lord, the recalling application, but nothing as such has been submitted in support of, my lord, their other application, which precedes the recalling application, that is the application seeking intervention. Now, unless and until, my lord, it is demonstrated that he is qualified, the applicant herein is qualified to intervene, and no recalling will lie. But I'll refer to, my lord, the law as it stands today.
What is the main prayer in the writ petition?
But the writ petition pertain to CBI investigation. Can 70. No, my lord, I'll invite your lordship, my lord, to just take up a few of the averments as contained in CAN 6, my lord, CAN 6, my lord, of the application made by the applicant herein.
CAN 6 is recalling.
Recalling, yes.
5 is intervention.
Yes. I'll, my lord, take up both are being argued together.
Right.
Now, if my lord kindly takes page 6, paragraph 2, this will be very relevant. In fact, my lord, this has strengthened, this has bolstered the order of which, my lord, recalling has been sought for. Because if I remember correctly, Mr. Goswami was there, Mr. Bhattacharya was there. While this matter was being argued, a reference to a speech by this gentleman, who is the applicant herein, now that was made. And upon hearing that reference, his lordship inquired from Mr. Goswami, am I right? Regarding the date, if the date of the speech can be found out. So Mr. Goswami searched for the speech possibly on his phone and gave the date. So it is not that the personal knowledge of the honorable judge was imposed in this particular order. Am I right, Mr. Goswami?
Yes, the thing came up during the hearing.
It was pointed out by one of the parties arguing. I did not do that. It was either by, sir, I am making my arguments. Please, you will get your turn. Now, his lordship referred to this particular speech. Now, nothing remains thereafter in view of the admission made by the applicant herein in paragraph 2, page 6. So I'll just read, my lord. He has given the Bengali transcription of his own speech and thereafter an English translation. Kothay kothay bolto na, this was a speech which he delivered on the 29th of March 2023 at Shohid Minar, Kolkata. Kothay kothay bolto na, bhaipo ei koreche, bhaipo ঠিক কি করেছে ঠিক করেছে 3 বছর হয়ে গেল এখনো মুখ দিয়ে অভিষেক বেরোয়নি। কি জ্বালা কি ভয়, আমি তো 3 বছর আগেই যা বলেছিলাম আজও তাই বলছি। জবে থেকে সারদা হয়েছিল
Yes, this
আক্রমণ।
has been read.
Oh, no,
Leave
my
that.
lord, there are certain, my lord, angles, my lord. Why, my lord? I want to demonstrate, my lord. My lord, my lord, a paranoia, my lord, cannot be a basis to file an application and waste the valuable judicial time. My lord, kindly permit me, my lord, to place this. I'll not take much time, my lord. কি ভয়, আমি তো 3 বছর আগেই যা বলেছিলাম আজও তাই বলছি। জবে থেকে সারদা হয়েছিল আক্রমণ ছিল আমার দিকে। এই মদন মিত্র বসে আছে, কুণাল ঘোষ দীর্ঘদিন কাস্টাডিতে ছিল। কি বলেছে জানেন এদেরকে? বলেছে অভিষেকের নাম নাও, ছেড়ে দেব। কি বলেছিল না? সারদা থেকে শুরু করে নারদা থেকে নারদা, তারপর হলো গরু, কয়লা, এসএসসি। আমি যতই ইনভেস্টিগেশন সিবিআই এর চলছে, আমি বুক ঠুকে বলে যাচ্ছি, সবার জন্য আইন আলাদা হলো, আমার জন্য আলাদা রাখার দরকার নেই। সবাই যদি দুর্নীতিতে যুক্ত থাকে তার বিরুদ্ধে ইডি সিবিআই লাগিয়ে দেওয়া হোক। আর বর্তমানে যত কেন্দ্রীয় সংস্থা তদন্ত করছে, ইডি হোক বা সিবিআই, আমার যদি কোথাও যোগসাযোগ থাকে এবং প্রমাণ করতে পারে যে আমি যুক্ত, আমার পেছনে ইডি সিবিআই লাগাতে হবে না। সে সারদা হোক, নারদা হোক, টেট হোক, এসসিসি হোক, এসএসসি হোক, কয়লা হোক, গরু হোক, এই শহীদ মিনারের মঞ্চে আমি মৃত্যুবরণ করব, ফাঁসির মঞ্চে উঠে কথা দিয়ে গেলাম। তোমাদের the contention in a nutshell is that if anyone can prove any connection or any involvement pertaining to any of these scams that he is referring to in his speech, he does not require, my lord, a trial. He will set up a podium and he'll hang himself to death. But this indicates, my lord, of a perceived paranoia from which the applicant herein is suffering, which is prompting him to make these applications, the frivolous applications before the honorable court of law, and my lord, waste the valuable judicial time, my lord. So, my lord, there is no doubt now that there was a speech delivered which has been admitted, my lord. This is an admission. And it was delivered at Shohid Minar on that fateful day, my lord. It is not the case now that there was no speech delivered or there was something else which was stated, which was described by the honorable single judge to be a speech. So, my lord, this is first of all, my lord, an admission. Now, thereafter, a case has been made out that it is a quorum non judice because the honorable judge, on the date of passing this particular order, he did not have the determination / jurisdiction, as it has been pleaded, to pass this order, because he was only having the jurisdiction pertaining to group 2. So group 9 jurisdiction he was not having. Now, my lord, I'll say, my lord, it is a conscious attempt made to mislead the honorable court by way of filing this application, because, my lord, fresh investigation was never directed. My lord, may kindly take note of the fact, a court-directed, court-monitored investigation, which was continuing under, my lord, the approval of the Honorable Supreme Court of India, my lord. This Honorable Supreme Court of India, video order dated 18th of October 2022, permitted continuation of the investigation, which is still continuing. It is Manik Bhattacharya order. My lord, kindly takes page 3 of the order. Page 3.
Yes.
The directions issued in these matters in paragraph 16 are as follows. Para 16, we accordingly direct the CBI under the SIT shall continue their investigation as directed by the single judge and file a comprehensive report before this court within a period of 4 weeks as regards progress of the investigation. So, my lord, a court-ordered, court-monitored investigation as ordered by our High Court, and which is still continuing, my lord, under, my lord, the orders passed by the Honorable Supreme Court. These matters are pending, my lord. I have documents to show, my lord, that, my lord, these matters are still being heard and orders are being passed, my lord. So, this is one aspect, my lord, but the case is made out that no, it is a case of fresh investigation. Kindly takes para 9, page 9, paragraph 4 once, my lord. They have set out the relevant portion of the order. So I'll just place from, my lord, the second paragraph of the order, my lord. Here I take note of one public meeting held by one Abhishek Banerjee on 29/3/2023, where he asked some persons to support him by saying that when those persons were in custody, police or the interrogating agencies pressurized him to name said Abhishek Banerjee. complaint of Kuntal Ghosh was made in close proximity with the said public speech of the said Abhishek Banerjee on 29th March 2023, as Kuntal made the first complaint on 31st March 2023 before the CBI court and on 1st of April 2023 before the Hastings police station. It is a matter to be inquired and investigated whether Kuntal took the cue from the public speech of the said Abhishek Banerjee, for which both of them can be interrogated, both by ED and by CBI, and such interrogation should be made soon. Now, what prompted the Honorable Judge to pass this order? Because it is a court-monitored investigation where the Honorable Judge has got a flavor that attempts are being made to interrupt that particular investigation. Terrorizing the investigating officers of the investigating agency by complaint before the police office authority is wholly unwarranted, and such endeavors are to be stopped forthwith. Otherwise, the officers of the investigating agencies will not be able to act in a fearless mind, and in view of such oversmart action, which is rising in the state, the court should give some immunity to the officers. Keeping this in mind, I hold that such interrogation should be made in such a situation. So therefore, my lord, there were instances cited by me as well as by Mr. Goswami, my lord, who was being led by Mr. Trivedi, that, my lord, it is a trend that whenever the central agencies are at a juncture where they are about to make a breakthrough, but these are, my lord, the standards, my lord. Complaints are made by a person who has been interrogated, who has been issued a notice, similar nature. In fact, my lord, we had produced an order passed by the Honorable Supreme Court of India, my lord, pertaining to, my lord, one of the joint directors of the Enforcement Directorate, my lord, Mr. Kapil Raj, whose name has been also, my lord, finds place in the my lord, order of which recalling has been sought for. But there, the state government had given an undertaking before the Honorable Supreme Court of India to the effect that no, the ED will be permitted to continue. They were investigating the coal scam, and there will be no coercive measures taken, and the police will not take any measure which has the impact of interfering with the investigation which is undertaken. So these were the instances. My lord, Kapil Raj's instance was cited. Thereafter, Umesh Kumar's instance was cited. A gentleman from Bishnupur who was called for interrogation. He came out from the CBI office. He took his own time to think. Thereafter, he went back to his place in Bishnupur and lodged a complaint that the CBI officers have pressurized me to take certain names. Thereafter, the case of another, my lord, gentleman, another officer, additional SP, Mr. Shushanto Bhattacharya, my lord, that was also, that inference was, that indication was also given that he was not even remotely connected with the Boktui case. He is investigating the cattle scam insofar as the CBI is concerned. But in the Boktui case, regarding an alleged custodial death, now a complaint was also made in his name. So these instances were cited, of which, my lord, the Honorable Court, my lord, took note of. So now, my lord, kindly appreciates, my lord, there was no direction to register any fresh FIR. It is a court-monitored investigation. The Honorable Judge basically directed the agencies to look into this angle, that whether this is an attempt to interfere with the course of investigation which is being monitored by the Honorable Court. So completely, my lord, wrong submission has been made pertaining to the determination of the Honorable Judge that as on the date of passing the order, the Honorable Judge did not have the determination to pass this order. And this was conscious, my lord. Why, I will say, because much has been said, but my lord, when people's representative, my lord, when they are before the Honorable Court of Law, but the standard of fairness is expected to be much higher than the ordinary persons, my lord. But why this attempt was a conscious attempt, my lord, I'll tell your lordship. It was conscious because, my lord, one thing has not been revealed before your lordship. After passing of this order, there was a notice issued by the CBI under section 160 of the CRPC. Now, a notice under 160 is a notice to a witness. A case has been made out that he is being trying to be implicated. There are attempts to implicate him in some new case. Now, my lord, if my lord kindly takes note of this particular notice, my lord will see, my lord, this particular notice was issued in connection with RC number 6, my lord. RC number 6 dated 9/6/2022.
Where is this RC
My
mentioned?
lord will find it, my lord. I'll just place the notice. You are hereby directed to appear before me on 18/4/2023 at 11 hours at the office of the Head of Branch, Central Bureau of Investigation, CBI, ACB, Nizam Palace such and such for the purpose of examination in compliance of order dated 13th of April 2023 passed by the Honorable High Court at Calcutta in Somen Nandi versus State of West Bengal and others in connection with case that is FIR number RC such and such 006
All right.
dated 9/6/2022 under sections 120B, 420, 467, 468, 471, 34 and 77A and 8 of the Prevention of Corruption Act. But this was, my lord, I'll say, my lord, this is a conscious and deliberate suppression, my lord, to mislead the Honorable Court, my lord, by a people's representative, my lord. And because, my lord, had this been produced,
Was this served upon him?
yes, this was served upon him, and
There
this
is
was
no mention of this in
no, they
petition,
did not
nothing.
mention it consciously. They did not mention it consciously, my lord. I have gone through it, my lord, in its entirety. I have spent my entire day yesterday, my lord, doing this research.
But then at the same time, this was not brought to the knowledge of the Supreme Court either.
No, my lord, this was served upon him. Thereafter, it came to the knowledge of the CBI that the Honorable Supreme Court has passed an order of stay. In view of such particular order, immediately another notice was served that in view of the pendency before the Honorable Supreme Court of India, this particular notice is kept in abeyance.
When was this served?
My lord, this was served on, I'll just tell your lordship, my lord. My lord, kindly give me a moment, my lord.
My lord, may I interject, my lord, once, my lord?
Mr. Dotto, you will be
Can
happy.
we-
Mr. Dotto,
I'll
please did
hear
not
you
interrupt.
reply.
No, only one thing, Mr. Bhattacharya may not have been in court when I made this submission.
I am
In
on
fact,
the aberments that are there.
I
Yes.
will hear you.
Very well.
It was served on the 17th of April, possibly. Or Twitter টা যাও না, আমি তো Twitter থেকে তো বার করলাম, টুইটারে যাও না, এটা তো ওনারই ওখান থেকে বার করেছে। না, সেটা আমি দেখেছিলাম একটা, তারপরেই আমি ওটাকে করেছিলাম।
Very well.
So, my lord, this was consciously
Hmm.
not brought to the notice of, my lord, the Honorable Court, my lord, with the sole intention of misleading the Honorable Court that a fresh FIR has been directed to be registered. So, my lord, I say, my lord, for this, my lord, the Honorable Court should, my lord, ought to take notice of this fact, my lord, and pass necessary orders, my lord, because, my lord, whenever it comes to, my lord, public representatives or when political parties are before the Honorable Court of Law, my lord, the courts are very, very strict, my lord, and take very, very strict and severe exception to any conduct, my lord. But I'll just cite, my lord, one judgment. It's reported in 2016, 1 Calcutta Law Journal, page 556. Now, this was, my lord, dealing with, my lord, the case of one particular political party. Now, my lord, there was some suppression. Now, this is what the Honorable, this is by a coordinate bench, my lord. Paragraph 13, my lord, I'll just place. To err is human, but it has to be remembered that this is not a writ petition at the instance of a stranger or a busybody attempting to get cheap popularity by espousing a pretended public cause. It is inter alia at the instance of a political party which in parliamentary elections last conducted in the country was successful in emerging as a party having maximum number of representatives in the Lok Sabha and is also a part of the ruling dispensation at the center. Invocation of extraordinary writ jurisdiction of a high court by a political party of a stature of the first petition and not being unmindful of the influence that it wields on the common people pertaining to a sensitive issue in such a disorganized manner and with such a casual approach not only merits to be deprecated, but the time is now ripe when the courts in India are faced with a deluge of litigation from aggrieved persons seeking justice, and the courts are hard-pressed in listening to the grievance of each of them to send a strong signal that the courts are not the place for settling political scores and that wastage of judicial time, though normal in measure, would not be tolerated. This bench has no hesitation to hold that not only should this writ petition be not entertained in view of developments post the decision in Biplab Kumar Chaudhary, but the petitioners ought to suffer exemplary cost so as to remind the first petitioner that howsoever strong and mighty it is in the political scene, it must respect the laws of the country while seeking to invoke the extraordinary jurisdiction of the court and not suppress facts or produce a tampered document to suit its end. The writ petition accordingly stands dismissed. The petitioners shall pay costs assessed at ₹5 lakh each to the West Bengal Legislative Services Authority and the Calcutta High Court Legal Services Committee within a month from date, failing which the state shall be entitled to recover the cost from the petitioners in the manner mandated by law. So, my lord, this should be the standard, my lord, when it comes to, my lord, public representatives knocking the doors of justice, my lord, by holding back relevant documents, which has, my lord, the impact, my lord, of altering, my lord, the entire conspectus of the particular case. Now, my lord, the petitioner peculiarly, my lord, may kindly take note of the fact, para 11, page, I'm sorry, my lord, ওটা কোথায় লিখলো যে I have no interest? ওটা বোধহয় ওর এটাতে লিখলো না? এটা বার করো। But the petitioner says, my lord, the petitioner pleads that, my lord, he has no interest in adjudication. It is there in the petition, my lord. I'll give you the, your lordship, the relevant paragraph. Yes. My lord, kindly takes page 11, paragraph 6. Now he says, it is not out of place to mention that the applicant is not a party in the writ proceedings and the application which was being heard by this honorable court and has no interest and or role whatsoever in the adjudication of the writ petition or the application. But in view of this, my lord, it has to be rejected, my lord, in limine, on the face of it. On the face of it, he is saying he is neither a necessary party nor a proper party, my lord. But these are from his own pleadings, my lord. I'll come to the, my lord, the question of law, my lord. My lord, insofar as, my lord, the next allegation, my lord, that the honorable judge had no determination, my lord, to direct CBI to initiate investigation. That has been dealt with already, my lord, as I indicated, my lord. There was no direction for fresh investigation, my lord. That is there in para 8, my lord. That is their ground. Now, but the SLP was disposed of on the 28th of April. Para 14, they have contended. 28th of April, the SLP stood disposed of. There was a liberty granted, my lord, to, my lord, move applications before the honorable judge to whom these cases are being reassigned. There was no specific liberty, my lord, granted to the petitioners. My lord kindly takes up, my lord, the order passed in SLP. Nothing has been said that the applicants will be at liberty. The Honorable Supreme Court of India has directed, basically, has given liberty to take out applications, but not any specific direction on the applicants to take out applications, my lord. But that is another. Now, but the most, my lord, what to say, my lord, with time, with the submissions made on behalf of the applicant, my lord, the question of, my lord, the question or the justification of questioning the applicant, but that is becoming more German. But may kindly, my lord, recall when the matter was being argued, my lord, Mr. Basu said that Mr. Basu does not know about the letter issued by Kuntal Ghosh. That was the case, that I do not have the letter. But kindly take page 16, para 19. Now, these are suspicious circumstances. These are to be looked into now. What he says. Applicant states that there is no link between his speech and the two complaints of Kuntal Ghosh. I'll just read it out. It is submitted that there was no material before the Honorable Justice Abhijit Gangobadhyay, as shall be reflected from the order dated 13th of April 2023, which depicts any linkage between the speech delivered by the applicant in his public speech on 29/3/23 and the allegations of Kuntal Ghosh against the investigating agencies in his two complaints made through Superintendent of Presidency Correctional Home to the Hastings Police Station and before CBI Court. But this, my lord, gives rise to, my lord, more suspicious circumstances, my lord, justifying the questioning. Now, my lord, the other point is, my lord, the ground of bias of the honorable judge. Now, my lord, the applicant rightly knew, my lord, that the question of bias of one coordinate bench cannot be raised before another coordinate bench, my lord, and he has to go in appeal. He was well aware of the principles, my lord, contained in Ramkishan Fauji's case, that intra-court appeal will not lie. So, my lord, the Honorable Supreme Court of India was approached, my lord. And may kindly appreciate, my lord, much was said, my lord, regarding, my lord, the Code of Civil Procedure being the Gita, sections 24, section 25. But I'll add to it, my lord, definitely the CPC is considered to be the Gita by all of us, my lord, but the Constitution of India reigns supreme. It is the, my lord, the Vishwarup Darshan of Sri Krishna himself, my lord. Article 139A is also there, my lord, justifying transfer of cases. The Supreme Court has that power in exercise of powers under Article 139A of the Constitution of India. Now, my lord, kindly takes note of the fact, now this particular application filed by the applicant before the Honorable Supreme Court of India, my lord, neither was that, my lord, an application under section 24 or 25 of the Code of Civil Procedure, nor was it an application, my lord, under Article 139A. It was simply, my lord, a special leave to appeal under Article 136 of the Constitution of India, my lord, going into challenging the merits of the case, questioning the bias, the alleged bias, my lord, of an honorable judge. And bias in any event, my lord, an order being bad in law owing to bias of one particular honorable judge cannot be raised before a coordinate bench, my lord. Now, in any event, my lord, if we see, my lord, now what are the ingredients contained in the pleading to demonstrate bias of the honorable judge, my lord? Now, his case of bias, my lord, is at basically para 30, page 20, para 30 of the application, my lord. Now, he has referred to some live interview given by the honorable judge in some private news channel. Now, this has been, my lord, holistically relied upon on the basis of some translation made, my lord. It is no official translation. On the previous day, my lord, there were attempts made to, my lord, convince the honorable court that these are the officially translated versions, but it cannot be the officially translated version because, my lord, as I indicated, the report was not shared, my lord. Now, my lord, the news channel has not been made a party, my lord. But I am the CBI, I am an agency. Mr. Trivedi is another agency, the ED, my lord. We are not supposed to know, my lord, or not supposed to see any private news channel. And the news channel is not here before your lordship, my lord, to say that, yes, what they are saying is correct. This is what was telecasted. So first is, my lord, the news channel is not made a party. But neither a link nor the footage, my lord. They have not been neither referred to nor annexed, my lord. Whereas, my lord, in so far as the speech at Shohid Minar is concerned, my lord, he has craved leave to produce the entire video clip of the speech at Shohid Minar. Now here, my lord, a simple reference, my lord, to the link of that particular, my lord, alleged broadcast, that is not there, my lord. No clip annexed, nothing craved leave for. There is no certificate also, my lord, under under section 65B, my lord, of the Evidence Act. Because unless and until, my lord, an electronic record, unless and until, my lord, it is preceded, my lord, by a certificate issued under section 65B, my lord, it cannot be taken into, considered to be an evidence, my lord. My lord, as such, my lord, going by the petition, my lord, allegations pertaining to bias has to be very, very specific, my lord. Wild allegations pertaining to bias cannot be made. That too, my lord, in light of the fact or in teeth of the Honorable Supreme Court's order, where the order was not even interfered with. There was a request passed which was passed in exercise of the administrative capacity or under Article 142. So, my lord, this question of bias, in fact, the petition, if taken as a whole, my lord, there is no allegation of bias because, as I indicated, my lord, there is nothing on record, my lord. A simple interpretation, my lord, as per, it might be as per his own will, my lord, that interpretation has been made, my lord. Now, my lord, what does the Honorable Supreme Court say, my lord, when it comes to, my lord, pleadings pertaining to, my lord, writ petitions, my lord, unlike civil cases, unlike blends? I'll be referring to, my lord, Bharat Singh's case, judgment to copy reported in 1988, volume 4, Supreme Court cases, page 534. The relevant paragraph will be para 13. I'll just place the paragraph, my lord. It states that page 542, my lord, at the bottom. As has been already noticed, although the point as to profiteering by the state was pleaded in the writ petitions before the High Court, as an abstract point of law, there was no reference to any material in support thereof, nor was the point argued at the hearing of the writ petitions. Before us also, no particulars and no facts have been given in the special leave petitions or in the writ petitions or in any affidavit. But the point has been sought to be substantiated at the time of hearing by referring to certain facts stated in the said application by HSIDC. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded or the evidence in support of such facts is not annexed to the writ petition or to the counter affidavit, as the case may be, the court will not entertain the point in this context. In this context, it will not be out of place to point out that in this regard, there is a distinction between a pleading under the Code of Civil Procedure and a writ petition or a counter affidavit. While in a pleading, that is a plaint or a written statement, the facts and not the evidence are required to be pleaded. In a writ petition or in the counter affidavit, not only the facts but also the evidence in proof of such facts have to be pleaded and annexed to it. So the point has been raised by us, before us by the appellants, is not entertainable. So, my lord, there is nothing on record, my lord, to demonstrate bias, my lord. So, my lord, there is no question of bias, but the aspect of bias, my lord, to be gone into by the honorable court, my lord. Now, my lord, I'll come to my strongest point now. I thought of taking this point, my lord, before concluding, my lord. This will be the sheet anchor, my lord, of my submissions. Well, there are two applications, one by an accused, another by, my lord, a gentleman who is neither an accused. And at this stage, my lord, without questioning him, without interrogating him, I cannot even say that he is a proposed accused. They seek intervention, crying hoarse that I was referring to my lord Ramesh Chandra Singh's order, my lord. Constitutional courts always have the power of directing CBI investigation. So, my lord, I'll be relying on two judgments. My lord, first is, my lord, I'll rely upon my lord's order passed in the review application. All the citations are there. Showman known this case. Municipality review it. What only we? And my lord has referred to all the judgments, my lord, including, my lord, the unreported judgments of the honorable, my lord, coordinate benches, my lord. My lord, I'll refer to, my lord, now 2014 volume 4 Supreme Court cases, page 626. So, the relevant paragraphs will be paragraphs 50 and 53. But this is, my lord, in support of my contention that, my lord, accused or a proposed accused, they do not have any right to be heard, my lord, during the investigation, my lord. I'll just place, my lord, very briefly I'll run through para 50 and 53, my lord. And in this case, in fact, para 50 even goes on to say about the proposed accused also. Yes. Para 50, my lord, will find at page 644. I just place the paragraphs. In WN Chadha, the High Court had quashed and set aside the order passed by the special judge in charge of CBI matters, issuing the order rogatory on the application of a named accused in the FIR. Mr. WN Chadha, FIR, Mr. WN Chadha. The High Court held that the order issuing letter rogatory was passed in breach of principles of natural justice. In appeal, this court held as follows. Applying the above principle, it may be held that when the investigating officer is not deciding any matter except collecting the materials for ascertaining whether a prima facie case is made out or not, and a full inquiry in case of filing a report under section 173(2) follows in a trial before the court or tribunal pursuant to filing of the report, it cannot be said that at that stage rule of audi alteram partem superimposes an obligation to issue a prior notice and hear the accused, which the statute does not expressly recognize. The question is not whether audi alteram partem is implicit, but whether the occasion for its attraction exists at all. More so, the accused has no right to have any say as regards the manner and method of investigation, save under certain exceptions under the entire scheme of the code. The accused has no participation as a matter of right during the course of investigation of a case instituted on a police report till the investigation culminates in filing of a final report under section 173(2) of the code, or in a proceeding instituted otherwise than on a police report till the process is issued under section 204 of the code, as the case may be. Even in cases where cognizance of an offence is taken on a complaint, notwithstanding that the said offence is triable by a magistrate or triable exclusively by the Court of Sessions, the accused has no right to have participation till the process is issued. In the case the issue of process is postponed as contemplated under section 202 of the code, the accused may attend the subsequent inquiry but cannot participate. There are various judicial pronouncements to this effect, but we feel it is not necessary to recapitulate those decisions. At the same time, we would like to point out that there are certain provisions under the code empowering the magistrate to give an opportunity of being heard under certain specified circumstances. If prior notice and an opportunity of hearing are to be given to an accused in every criminal case before taking any action against him, such a procedure would frustrate the proceedings, obstruct the taking of prompt action as law demands, defeat the ends of justice, and make the provisions of law relating to investigation lifeless, absurd, and self-defeating. Further, the scheme of the relevant statutory provisions relating to the procedure of investigation does not attract such a course in the absence of any statutory obligation to the contrary. Now, these observations make it abundantly clear, this will be very relevant, my lord, that it would not be necessary to give an opportunity of hearing to the proposed accused as a matter of course. So, not even a proposed accused, proposed accused, no right of hearing. The court cautioned that if prior notice and an opportunity of hearing have to be given in every criminal case before taking an action against the accused person, it would frustrate the entire objective of an effective investigation. In the present case, the appellant was not even an accused at the time when the impugned order was passed by the High Court. Finger of suspicion has been pointed at the appellant by independent witnesses as well as by the aggrieved father of the victim. So, my lord, this para 50, my lord, will be, as I said, my lord, very, very relevant, my lord. My lord, for dismissing, my lord, their application seeking intervention. In light of this particular observation, the law laid down by the Honorable Supreme Court of India, my lord, their applications have no leg to stand upon, my lord. And unless and until, my lord, this application is not allowed, my lord, recalling cannot be prayed for. And even if, my lord, goes into the question of recalling, my lord, the recalling ought to fail, my lord, on the ground of, my lord, the principles enunciated in Bharat Singh's case, my lord, suppression, the principles, my lord, as also laid down, my lord, in my lord's order passed in review. And my lord, in view of the fact, my lord, that there is nothing on record, my lord, to substantiate bias, my lord. My lord, para 53, my lord, will also be relevant, my lord, of this particular judgment, my lord. It is again a reiteration, my lord, of, my lord, what has been there in para 50. My lord, may kindly take note of it. There is another judgment, my lord, which has followed, my lord, this particular judgment. Now, that is referred to, that is reported in 2018, volume 7 Supreme Court cases, page 365. The relevant paragraphs are, my lord, paragraphs 10 and 11. Insofar as, my lord, the accused or proposed accused not having any right of audience is concerned, my lord. And thereafter, my lord, may kindly also take note of, my lord, paragraph 13 and 14, my lord. 13 and 14, my lord, they have referred to Dharampal's case. And my lord, the Honorable Supreme Court has again reiterated the principle that the constitutional courts have ample power to direct CBI investigation. So, my lord, in a nutshell, my lord, these are, my lord, my humble submissions, my lord. And I'll be praying for, my lord, dismissal of the petitions, my lord, in limine, my lord, with heavy and exemplary cost, my lord. But I understand, my lord, these judgments, my lord, will also govern, my lord, the case of the other applicant, Mr.
Please wait.
Yes.
Let the petitioner in that matter place
Yes,
the case,
yes,
then I'll hear.
Oh, my lord, I will just, my lord, distinguish, my lord, the judgment cited by Mr. Basu, my lord, once, my lord. No, sorry. My lord, Mr. Basu had relied on 2008-3 Supreme Court cases, page 659. Relevant paragraph was paragraph 23. Now, paragraph 23 was dealing with, my lord, sections 24 and 25 of the Code of Civil Procedure. This is not a case, my lord, where, my lord, powers were exercised by the Honorable Supreme Court of India under, my lord, section 24 and 25 of the CPC, or, my lord, under Article 139A of the Constitution of India, my lord. As I said, my lord, I reiterate, my lord, they went up, my lord, under Article 136 of the Constitution of India, my lord, to the correct forum, my lord, where, my lord, the question of bias was raised, despite which, my lord, the order, my lord, was not even tinkered upon by the Honorable Supreme Court of India. Now, the other judgment that Mr. Basu has relied upon is 2018-11 Supreme Court cases, page 119. The relevant paragraph is paragraph 19. My lord, this was arising out of, my lord, the family and my lord, the Hindu law, my lord. Paragraph 19 was, my lord, it flowed down from framing of issues in a civil suit, my lord. So, my lord, as I indicated, my lord, the principles enunciated in Bharat Singh's case, my lord, that I just relied upon, that is 1988 4 SCC, page 534. It carves out a clear distinction, my lord, my lord, between a civil suit and writ proceedings, my lord. But the other decision that has been cited by Mr. Basu is 2014 volume 5 Supreme Court cases, page 312. The relevant paragraph is paragraph 14. Now, that is arising out of, my lord, an election petition, which is regulated under the Representation of People's Act, my lord. And there, my lord, the Representation of People's Act, the rules, my lord, the act, the provisions make it very, very clear, my lord, that, my lord, it's a very, very technical, a hyper-technical subject, my lord. And my lord, the standard is not at par, my lord, with proceedings under Article 226 of the Constitution of India. But the two judgments that I referred to, my lord, 2018-7 SCC, page 365, and 14-4 SCC, page 626, my lord. It also says, my lord, that right to hearing will flow, my lord, in case of civil cases, my lord, where there can be civil consequences. But insofar as matters writ proceedings, my lord, having a criminal flavor, my lord, criminal flavor, as in, my lord, as I indicated on that day, my lord, regarding, my lord, Ramkishan Fauji's case, the seed of germination, what it will lead to, what it can lead to, my lord. But there cannot be any violation of, my lord, the principles of natural justice, or, my lord, a right of hearing, my lord. These are my submissions, my lord.
State.
Yes, my lord, no, my lord, thing is that, my lord, I gather that your lordships will be hearing the two applications separately. Because, my lord, the position
Right
of...
now, 5 and 6.
Yes. So, my lord, the position is that, my lord, as far as the state is concerned, my lord, our submission is more or less, my lord, with regard to the three directions, that is 19 Roman 1 and 19 Roman 2. That is, from today, no police station shall lodge FIR against any complaint made to it in respect of any officer of ED-CBI, and the letters written by Kuntal Ghosh shall not be given effect to. Now, that being the position, now, as it so happened that the order was one order. Now, the causes have been bifurcated because two sets of applications have been filed. Otherwise, the order is single. So, Malad, the submissions of the...
Which order?
Malad, the order from which both the recalling applications have been filed.
All right.
That is a single order. It was Malad, defended as a single order when the order was passed. Now, because of the two sets of applications, now the cause has bifurcated. So, Malad, as far as the state is concerned, the major or primary submissions are with regard to Mr. Roy's application.
So here you do not have much to say.
But, Malad, only thing, one point which I would have taken up in Mr. Roy's application, Malad, in my understanding, that point is common if the both applications are taken together. Now, as far as Mr. Dotto's client is concerned, Malad, that point is applicable, though I don't have anything separately to say. But, Malad, I think that I should bring the point to your lordship's notice because lordship is hearing it separately. Now, Malad, your lordships will find, Malad, in effect, this application was filed by the ED, that is at starting from page 30 of Can 6. Now, Malad, your lordships will find the cause which was agitated since morning before before the application was filed, is, my lord, kindly takes paragraph 8, 9 and 10 of the application. The paragraph 6 says that based on media report, they come to know that a complaint has been lodged by the Kuntal Ghosh before the Hastings PS, whom I represent.
Milord, I will not interrupt, Milord, but the learned advocate general on the first day had said that state has
No, I
nothing
made
to
it
say.
clear. I made it.
State has nothing to say
Milord,
as far as
See, but the
application
order
is
is
concerned.
common. No. Milord, I make it
Milord,
clear.
that submission after that state is coming and changing the stand.
Yes, I have heard it.
Milord, this
Absolutely.
ganging up will not really help, but the point is
I
very
just
clear.
pointed it out before.
This
That was what was submitted by the learned.
That's the point. No wrong in hearing a point.
Yes, please.
Yes, Milord. I repeat, Milord, for my learned friends' understanding, probably have not understood when I said this the first time, that this point is primarily, I would have, if both the applications were taken together, I would have argued in Mr. Roy's point. But I find that this point is common in both because the application is common in both. Now, my lord, your lordships will kindly see that paragraph 8, that the aforesaid facts had been brought to the knowledge of the Honorable Justice today morning, wherein liberty has been given to the applicant ED to bring in the submissions made in the Honorable Court by way of an application. Hence, the application is being filed. That subsequently it has also come to the knowledge of the applicant ED that Kuntal Ghosh and or other politically exposed persons are trying to lodge similar complaints against officers of the Enforcement Directorate through other police authorities as well. That the Honorable Justice has already passed an order today. This is prior to the application being filed, my lord, directing no action can be taken on the purported letter of complaint of Kuntal Ghosh by the police authority till such time that the matter is being heard by this Honorable Court. The veracity of the complaint may kindly be verified by the Honorable Court by passing appropriate directions. Now, this, in the morning, upon mentioning, my lord, this issue was raised before the Honorable Single Judge, my lord. And my lord, upon mentioning, I received a letter. In fact, my lord, the learned government pleader received a letter from Mr. Goswami, appearing for the ED, that the Honorable Court had inter alia been pleased to direct by passing an order today on 12th of April 2023. Then the directions are same as contained in the order. So, my lord, the ED's apprehension was that on the basis of Kuntal's complaint, one complaint may be registered, FIR may be registered by the state police, and other PEPs may file similar complaints to lodge a complaint to start register an FIR against the ED personnel. Now, your lordships will kindly take page 30 onwards. Your lordships will not find in the array of parties ED being a party as far as my lord 7907 and Showman Nandi and Ramesh Mollik is concerned. So, my lord, it ends with the CBI, which is Mr. Bhattacharya's client. So, my lord, this non-party approaches the Honorable Court. Now, my lord, whether a non-party or assuming that he is also a respondent. So, a respondent approaches the Honorable Court seeking an interim direction upon another respondent, that is the state. That is the position of affairs, my lord, as far as the 13th April order is concerned. My lord, this point is similar to the application of Mr. Roy and the application of Mr. Banerjee. I would have pointed out while arguing Mr. Roy's application, in Mr. Roy's application, but it happens that, my lord, now, in my eyes, my lord, this order cannot be bifurcated. Because, why I say that? Kindly take this example that later, after hearing Mr. Roy, if it commences to your lordship that the application is to be allowed, then the directions again, directions as far as 19 Roman 1, Roman 2 will not remain because if the application is allowed, then whatever is preceding those directions, whatever Mr. Datta's client is aggrieved by, will also be redundant. So, my lord, this actually, it has both has to, my lord, survive or be defeated on the same cause.
Very.
And, my lord, my lord, kindly takes a different example. The point I am trying to argue is that, my lord, there has been several accused persons in this investigation. But time to time, they have been brought to the knowledge of the Honorable Single Judge, and time to time, several directions have been passed. Now, my lord, kindly takes a situation where a person feels that I am not involved in it. Any person, my lord, of the commission or of the board, whoever was involved, because several directions were passed that this person should be brought for interrogation at 3 p.m. or at 4 p.m. or so and so. Now, my lord, that person, if he is aggrieved by this investigation, of CBI or by the ED, that person had to make an application before another court, that is under group 9. The person had to approach and saying that kindly quash these proceedings against me. Now what is happening is that in this proceeding, a respondent whose officers are custodial torture is being alleged against the officers of the agencies, both the agencies. Now they come up in a pending writ petition, and this respondent is seeking a direction upon another respondent that I should not take any steps against them. This procedure is unknown to law. They should have come up in a substantive application if at all they were aggrieved by it. Because the difficulty is that if your lot, though all these recalling has been filed in 9979 of 2022, actually it's a both matters were taken analogously. That is 7907, that is Mr. Banerjee's writ petition and Mr. Shamim's writ petition, both. Now, if your lordship, I am reading from Can 7 only for your lordship's convenience. The prayers in the writ petition are that a writ of mandamus directing the respondent authorities to cancel the illegal appointments of the private respondents, a writ of mandamus directing the respondent authorities to publish the result of 2014 of the petitioners and take consequential steps thereto. And prayer C was directing the respondent authorities to conduct an impartial investigation by CBI regarding recruitment of primary teachers in state of West Bengal pursuant to advertisement dated 26 September. This is quoted in Can 7. Now, the point I am trying to make is that prayer C has already been granted and the court is monitoring the investigation. Now, this application brings about a new dynamics in the prayers, which says that each and every officer of the ED and CBI is to be protected to the extent that a leave has to be sought from this honorable court before registering any complaint against them. And if your lordship kindly takes the nature of the decision, is a blanket stay. From today, no police station, page 48 of Can 6, from today, no police station shall lodge any FIR against any complaint made to it in respect of any officer of CBI and ED who are investigating the education recruitment scam, both in West Bengal Central School Service Commission and the West Bengal Board of Primary Education without the leave of this court. Now, this is a separate cause. This cause is not part of the cause which is being agitated by the petitioners.
But then you did not prefer any appeal against
No, my lord, we
this
did
order.
not.
Then
We did not.
I would like to hear Mr. Dotto in reply so that I can finish with this 5 and 6. Why release? Still some time to go. Keep somebody here, keep an eye on the board. Yes, Mr. Dotto.
Yes. Now, my lord, so far as Mr. Trivedi's arguments are concerned, my lord, it prima facie proceeds on the basis that there were some foundation in his application or ED's application, which was amplified in course of argument. This is his submission. Now, to that, my lord, in the absence of any pleadings, my lord, we need to look into this order of his lordship once more. Just few lines. I will not trouble you with the entire order. To actually whether this honorable court can assume that any submissions were made or not. Kindly have a look to the order of which, my lord, we are seeking recall. Please skip over the first paragraph, second, third, fourth. Kindly now take the fifth paragraph. On perusal of the letters written by so-and-so, then, my lord, the court considers it. Please turn the page, para 6. Today an application was taken up for, today the application was taken up for hearing
and the learned advocate of the CBI supporting the said application also made this submission. On behalf of ED, some dates were mentioned. Then please skip over, my lord, that page. Please take page 5 of the judgment, last 2 lines after the list of dates. Here I take note of one public meeting, so and so. Now please turn the page, para 7. Mr. Bikash Ranjan Bhattacharya, learned senior advocate for the writ petitioners, read out the letters written by Kuntal Ghosh, etc. Then please take paragraph 8. I hold that so and so. I have read those, I will not trouble you. Then please take para 9. It is a matter to be noted that when Kunal was in CBI custody, so and so happened. Para 10, nothing of that sort. Para 11. Here I must say that from the submissions made before this court and from the reports filed by the investigating agency, I find that if the whole scam is considered as a human body, nothing to do, my lord, on the merits of their application. This is the Honorable Court, considering whatever submissions have been made, feels that an investigation should be compared with a human body. This is what is said, my lord, in paragraph 11. Please turn the page. It is submitted on behalf of the petitioner, must be Mr. Bhattacharya, while reading the contents of the letter that during the investigation, one particular ED officer terrorized, etc. Then para 13, learned advocate for the ED has submitted that what was written in the letter of Kuntal on 31st March has been embellished and exaggerated in the letter dated such and such. Then Mr. Bandopadhyay's submission at paragraph 15. Then at paragraph 16, my lord, again, the Honorable Judge refers to the letters. After reading those 2 letters and after hearing the parties, I find so and so. Then, my lord, the inquiry by the court at paragraph 17 from Mr. Billodal Bhattacharya. Then paragraph 18, my lord, this is the finding of the court, and finally, my lord, the concluding directions by the court. Therefore, my lord, my first submission in response to Mr. Dhiraj Trivedi's contention is that whatever he has said, who have been told to the Honorable Judge hearing the matter then, but is not found out from the order itself. But we go by the order, we don't find, unless my learned friend says that he made the submission, court did not record, that's a different thing, he did not say so. He said that he had amplified the averments made in the application in course of argument. But to that matter, I very respectfully submit, nothing appears from the order. My lord, we have to consider, my lord, that, my lord, we are before this court, my lord, with an allegation of bias. Therefore, what submission my learned friend has made has to be proved to the hilt. We do not find any amplification of the application in course of hearing from the order, my lord, of which, my lord, we are seeking recall. This is my first submission. Therefore, my lord, the contentions of Mr. Trivedi as to his submissions made in my very respectful submission, my lord, requires no consideration by this Honorable Court.
Yes.
My lord, the submission has been made in unison by Mr. Trivedi and both Mr. Bhattacharya that the Supreme Court did not grant leave to my client to make this application. My lord, we must recall the first principles on the subject. The first principle on the subject of an allegation of bias is that bias has to be first agitated before the court or the authority against whom you are alleging bias. This is the first principle. An appeal court, my lord, cannot first adjudicate an allegation of bias. But these are the first principles. I don't think, my lord, judgments are required on this. Therefore, my lord, I have to come back or go back to the court against, or the honorable judge against whom I am alleging bias, that I apprehend bias. My lord, the situational circumstances today is that your lordship is sitting in the chair of the other learned judge. Therefore, my lord, my allegations of bias has to be adjudicated by reason of the Supreme Court's directive by your lordship. Because I have no scope to go back to the honorable judge, because the Supreme Court felt it necessary that the honorable judge should not hear these matters. So, my lord, going by the first principle and, my lord, in view of the changed situation, my lord, this is the court before whom I can come and allege bias. This is number 2. And of course, my lord, your lordship has to consider this, and whatever your lordship feels would appropriate, your lordship would rule. Then, my lord, the question is again, my lord, the third aspect which has been argued in unison is that Supreme Court has virtually rejected my prayer. Mr. Bhattacharya, senior Mr. Bhattacharya has taken a lordship through some of the pleadings in the SLP or the grounds to make a submission that the Supreme Court has, even on the same allegations, the Supreme Court did not consider it necessary to adjudicate them, relegated the matter back, and therefore, it in all respects, the Supreme Court has rejected my allegations. Without assuming the same to be correct, assuming that my SLP has been dismissed, again, my lord, we have to go back to the first principles. There is no merger. Therefore, my lord, like a review, a recalling application is also maintainable after dismissal of an SLP. Now, take the worst situation against me, that my SLP has been dismissed because it was not converted into a civil appeal. SLP has been dismissed, as my learned friends have argued, for the time being, assume that to be correct. Then also, my lord, dismissal of an SLP is not a fetter to the filing of either a review or a recall. Therefore, my lord, the application is maintainable irrespective of, my lord, whether this Honorable Supreme Court has granted me this leave or not, because this is a right available to me under the law. A right which is available to me under the law, my lord, requires no leave. Because no submission has been made before the court that post dismissal of an SLP, a review or a recalling, because mine application is a recalling application, is not maintainable. Where my next submission is, yes, my next submission is in response to what has been submitted by Mr. Trivedi as well as Mr. Bhattacharya, senior Mr. Bhattacharya, that Supreme Court has practically affirmed the order of the learned single judge, my lord, of which, my lord, I am praying for recall. My lord, there is no concept of practically, my lord, affirming an order. Either it is adjudicated this way or that way. But I felt, subject to correction, that this submission was in the lines of an issue of res judicata. If these are in the lines of the issue of res judicata, as your lordship knows, what is res judicata? Res judicata is res is a thing, judicata is decided. Therefore, res judicata is a thing decided. If they say that the Supreme Court has practically affirmed the order of the Honorable Coordinate Bench, the Supreme Court has to reach to a conclusion, has to reach to a finding. But your lordship will not find any finding, my lord, in regard to the correctness or soundness of the order of which, my lord, I am seeking recall. My lord, on this, please come back to, my lord, page 58, 2 paragraphs. At page 58 of my application, recall application. What is the Supreme Court considering, my lord? Please take paragraphs 2 and 3. In paragraph 2, the Supreme Court says we have considered the note prepared by the Honorable Judge and have also perused the transcript of the interview. The transcript has been authenticated by the interpreting officer of the original side, etc. Then para 3, having considered the transcript, we direct the acting Chief Justice so and so. So, my lord, there was no consideration of the case of the matter on its merit. The Supreme Court looked into transcript and the note and felt that the matter should be reassigned to some other honorable judge. Therefore, my lord, nothing considered on the merits of the matter and nothing decided this way or that way.
You must be over by
Therefore,
now.
my lord, the question. I'm sorry, my lord.
Do you have anything more to submit?
One or two more points, but I'll not detain your lordship, my lord, because your lordship has been tested enough, my lord, with this matter.
I'll be taking up the other matter also today.
Very well. Now, my lord, fundamentally, on my allegation of bias, my lord, nothing has been submitted. My lord, no submission has been made that the judgment which I have cited, that is 1987 volume 4 Supreme Court cases, page 611, as to what is to be done or what should the judge do when an allegation of bias is made against him. He is not supposed to consider whether I am biased or not. He has to look into the face of the person who is alleging it. Therefore, on the basic principle of bias, no submission has been made that this principle would not apply in the facts of this case. Therefore, my allegations of bias has gone uncontroverted by the 3 learned advocates, who are opposing this application. Then, Mr. Billodal Bhattacharjee, refers to the judgments, more particularly Bharat Singh's judgment, to contend that I do not know why Mr. Bhattacharjee has relied that judgment. I would have expected Mr. Trivedi to rely on that judgment. Because the same judgment, the same principles are applicable to Mr. Trivedi's client's application also, number 1. And number 2, these principles are never made applicable in a case of bias. That the concept that the parties must be made confined to their pleadings are not applicable, my lord, in a case of bias.
Nothing further,
But-
Mr. Doctor. Enough has been submitted.
Yes, may I only say this, why I'm saying this? But if I allege bias, I will go straight before the court and make an oral submission that you are biased. I will make an oral submission, recuse the matter. There are no pleadings in my very respectful submissions are required in this matter, in
Very
this
good.
regard.
Only
And
one-
whatever principles
That-
he has
only one thing to add regarding learned senior advocate Mr. Dotto submitted that res judicata not applicable, issue not decided, finally no issue decided. Explanation 5, my lord, may I read for your
No, please don't.
Section 11.
Another reply by Mr. Basu over here.
Very well, my lord. Mr. Basu may conclude, my lord. I'll not trouble your lordship.
বলবি কি আমি কিছু বলবো একটুখানি বলবো
বলে দাও।
এরকম করে তাকালে বলা যায়
Fast, please.
My submission is, my lord, this is not a criminal proceeding where, my lord, natural justice is required to be heard because the person is accused. He has no, because it is a process, whether he will be accused or not, he is in the process of investigation. But it is a writ petition. It the interlocutory application in connection with the writ petition. So, my lord, all norms required for the purpose of hearing a matter has to be considered. My lord, one thing is my application for additional party is there.
No,
Yes.
no.
That, my lord, termed as intervention. This is original side practice. So we don't know. Intervention is to be treated as an additional party application. And this, kindly consider, this is confined only to one paragraph which I have shown to your lordship, recalling of that part only, not the entire order. Some impression has been given to my lord that my client is want to recall the entire order. No.
No, he has submitted. It has read only that part. You were not there.
I was arguing.
You were not there.
So it is not that I am asking for.
Yes.
Now the point raised by Mr. Trivedi that he was amplifying the petition. His own submission is that on the day the document was not there when they filed the petition. So if the documents which are not there,
But on the day of the hearing, the documents were there.
that my lord not find place in the judgment.
Very well. I have.
Then even if your lordship look to the complaints,
Hmm.
my lord did not find anything touching my so-called speech. It is not touching any speech of mine, even if
Yes,
those
yes,
documents are before the court.
It's over. Get the other application, please.
I am grateful to my lord.
3 and 4. Yes.
My lord, can't keep that only. I will refer to those pages only. I have taken down the page numbers.
So I can continue with 5 and 6.
Yes.
Very nice.
My lord,
Yes, it is actually independent.
5 plus 6.
যেটা ইচ্ছে নেই না আমাদের তো কোনো কাগজ নেই
My lord, firstly, the writ application WPA 9979 of
Tell me one thing, your client is in custody.
Lordship.
What orders can be passed over here now?
Your lordship will dismiss the application filed by the enforcement directorate being not in form and not in the proper jurisdiction.
Not in the proper jurisdiction.
Proper form and jurisdiction.
Form. All right.
My lord, the writ application WPA 9979 of 2022 was moved for some commission or omission on behalf of certain individuals, maybe government servants attached to the various educational institutions, I mean the government institutions obviously, and some individuals, private individuals. There a seat has been formed which is investigating by the CBI. Thereafter the ED also have started investigating the self-same case. Now My lord, that investigation was being monitored by Justice Ganguly. I do not know, my lord, so far as the writ petition which I have got from Samarth says that the ED was not a party. I am assuming ED is a party, although Mr. Bandopadhyay said ED is not a party. The ED files an application. Your lordship has gone through the application many a times. My lord, the reference has been made in page 34, paragraph 6 and 7. My lord, it says about my complaint being lodged with the district judge, my lord, the designated court or the CBI court, and subsequent my complaint with the Hastings police station. My lord has been shown the letters. My lord has gone through the letters. In my respectful submission,
I have not seen the letter.
my lord, in his
Letter is,
compilation,
I
it
have
was
produced-
annexed.
It's in the file, my lord.
My lord, he has, Mr. Trivedi has given your lordships a compilation which contains this letter.
In the compilation, the letter
Yes,
is
he has
there.
referred to.
I had referred.
Bengali,
All
Mr.
right.
Goswami read out, and the English.
Yes. To the judge, yes.
Lordship, one to the judge and another to the, he wanted to say in the Hastings, I had made certain exaggerations or I've developed my case. But in my respectful submissions, both the letters speaks of a commission of a cognizable offense of custodial torture, whether it is belated, as an afterthought, malicious. These are to be taken recourse to, or this forensic postmortem of my allegation has to be done. Lalita Kumari. Subsequently, if a cognizable offense has been spelled out, my lord, the police is under a bounden duty to register a case. My lord, in this context, I will be referring to a judgment reported in 2014, volume 2, SCC, page 1. I will not trouble your lordship. It's a very bulky judgment. Your lordship will kindly come to the last page. Lalita Kumari. Your client will be amused that you don't know the judgment.
I don't know the citation, I know the name.
My lord, page 120, page 61, paragraph 120.
Yes.
121, 120.1. The registration of FIR is mandatory under section 154 of the code if the information discloses commission of a cognizable offense and no preliminary inquiry in such is permissible in such a situation. If the information received does not disclose a cognizable offense but indicates the necessity for an inquiry, a preliminary inquiry may be conducted only to ascertain whether cognizable offense is disclosed or not. If the inquiry discloses the commission of a cognizable offense, the FIR must be registered. In case where preliminary inquiry ends in closing the complaint, a copy of the entry of such closure must be supplied to the first information forthwith and not later than 1 week. It must disclose reasons in brief for closing the complaint and not proceeding further. The police officer cannot avoid the duty of registering offense. If cognizable offense is disclosed, action must be taken against the erring officers who do not register the FIR if information received by him discloses a cognizable offense. My lord, the paragraph 5 in my respectful submission was with regard to non-cognizable offense, but there is a judgment of Justice Chandra. If the clauses mentioned in 125.6 is made out, the clauses matrimonial offense, medical negligence case, a preliminary inquiry has to be made, whereas Justice Vivek Chaudhary has had, if non-cog offense is made out, then only this preliminary inquiry. I am not going into that. My case is a cognizable offense was made out. It was submitted before a court. The court now can take cognizance. Court can direct inquiry under 202, whatever court can do. So far as the police is concerned, police had to register a case. Now what has
But
happened?
then do you not think that the provisions of PMLA is a bar?
Pardon your lordships, no.
No.
No. Custodial interrogation is a different thing which was not within the jurisdiction of the either the CID officers or the ED personnel to do. As of now, you are looking at a petition of complaint, a first information report. Your lordship can quash it on the ground of mala fide. Your lordship can
quash it, it is beyond the preponderance of probability or beyond the sense of a man of reasonable prudence that such things can have happened, and I did not lodge it with the magistrate concerned. I have given an explanation in my application also for the delay in lodging the complaint. But whatever it is, and that forensic examination of my complaint can be done only after hearing me. This principle was not followed for 14 days. The first is my last letter with the police authorities. 31st is my letter of complaint with the... Now, what the learned judge does, my lord, I will tell your lordships, my lord would kindly consider his lordship was dealing with an application of an accused, not proposed or so-called would be. As per my complaint, I have named certain officers. They have not moved the court. Enforcement Directorate have taken the cajole on his shoulder to come forward for protection of his officers. They have not approached the court. My lord, whether an accused person can move a court for seeking for a direction, although the prayers are very innocuous. In fact, my lord, I will be adopting the submissions both of Mr. Trivedi as well as Mr. Bhattacharya.
Especially this one.
Judgment of my lord, he has referred to a judgment. My lord, I will refer to a division bench judgment of this honorable court in the case of Kushal Agarwal versus Mahendra Kumar Jain. My lord, a lot of judgments were cited at the behest of the parties. Your lordship will kindly straight away come to paragraph 10. Honorable Supreme Court in the matter of W.N. Chadda in paragraph 92 has held that the accused has no right to have any say as regards the manner and method of investigation, and also has no participation as a matter of right during the course of investigation of a case instituted on a police report till the investigation culminates in final report under section 173, 2 of the SIP code. In the matter of Romila Thapa, the position of the law that the accused has no right with reference to manner of investigation has been reiterated as under. Again, in Sanjeev Rajendra Bhatt, Union of India, the court restated that the accused had no right with reference to the manner of investigation or mode of prosecution. The accused has no right with reference to the manner of investigation or mode of prosecution. Similar is the law dealt out by this court in the case of such and such. Recently, a 3-judge bench of this court in E. Sivkumar, while dealing with the appeal preferred by the accused, challenging the order of the High Court, as regards the second ground urged by the petitioner, we find that even this aspect has been duly considered in the impugned judgment. In para 129 of the impugned judgment, reliance has been placed on Dinu Bhai, Bhoga Bhai, Solanki versus State of Gujarat, wherein it has been held in a writ petition seeking impartial investigation. The accused was not entitled to opportunity of hearing as a matter of course. Reliance has also been placed on such and such, in particular paragraph 11 of the reported decision, wherein the court observed that it is well settled that the accused has no right to be heard at the stage of investigation. By entrusting the investigation to CBI, which as aforesaid was imperative in the peculiar facts of the present case, the fact that the petitioner was not impleaded as a party in the writ petition, or for that matter was not heard, in our opinion, will be of no avail. That per se cannot be the basis to label the impugned judgment as a nullity. My lord, the accused moved the court and has obtained this order. With deepest of the respect to my lord, we'll kindly come to the order once more. My lord, your lordship will get it at, it starts from page 38. If your lordship kindly comes from paragraph 18.
Yes. Hmm.
Therefore, it has become a sinister design of some person to make allegation against the investigating officers of different scams to terrorize them by using the police force, which have now come to light in the state. And I see this letter of Kuntal Ghosh is also an attempt to terrorize the officers of ED and CBI and to throttle the investigation process. And I term it as very smart action, which cannot be allowed for a fair investigation and for the ends of justice. So the learned judge, honorable judge, was speaking of commission of a separate distinct offense. Mr. Bhattacharya has placed the summons, which was issued in the name of a particular individual in connection with RC6. RC6 speaks about cheating, forgery, and prevention of corruption. It does not say about threatening a public servant in discharging his official duty. The judge was speaking about a separate offense whose investigation the judge has referred to. Maybe the CBI has not registered the case, but in fact, the honorable judge directed commission of an offense, more particularly 186 of the IPC. It is a distinct offense. A separate case had to be registered by the CBI or the ED. Well, what the learned honorable judge has done, I had lodged a complaint to the local police station. The local police station, whatever may be the reason, maybe what they say, because my allegations were so absurd, they chose not to act on it. Malad, if they choose not to act on it, as per the judgment of the Honorable Supreme Court, they had to inform me. In that event, I have two more options. Either approach his superior officers or move the court under section of praying for a direction under 156(3). Because of the order of the honorable judge, that avenue has been foreclosed. I was not heard, but my rights have been infringed upon. Now, a distinct and separate offense had directed to be investigated, which had got nothing to do with the so-called seat of the ED, whatever they are investigating for that education scam or whatever it is. Well, so far as one is concerned, I am least bothered. My lord will kindly take note in the application filed by the ED, no bias either against the local police station or for that matter before the learned judge special court CBI had been made. I had lodged a complaint. The learned judge can also act on it. He can treat that as a letter of complaint and ask me to produce my evidence. The letter has been, your lordship sees, the letter shall not be given effect to. Both filed before the court as well also before the Hastings police station. Well, neither the ED or the CBI had perhaps have any bias against this presiding officer of this special court. My avenues both before the police as also before the court has been stalled by this subclause 2. Now, a single offense, Malad, it is not PMLA. There is a predicate offense. The PMLA is being investigated by
But
the.
then he is there in the PMLA also.
No, I am saying what the learned judge has directed is an offense under 186 for terrorizing the investigating officer.
But the entire thing arises out of PMLA.
Maybe that's a distinct offense. My lord, out of a case of 324, slapping my learned friend, thereafter an altercation ensues and I murder him, or he murders me, your lordship will tag all the cases together. This is a distinct offense. I have said that I have been tortured in custody. This has got nothing to do with that education scam investigated by CBI or ED, nor the inquiry which has been directed by the learned honorable judge. Honorable judge has directed that by writing that letter, I have tried to divert the course of justice by threatening the investigating officers. That's a separate and distinct offense. That cannot be tagged with the offense of cheating, forgery, and Prevention of Corruption Act.
Very well.
And what Mr. Dotto has argued, the learned judge did not have the jurisdiction. This is, Mr. Trivedi's client definitely could have moved Article 226 or for that matter 482 CRPC for quashing. No, what was he apprehending? After Arnesh Kumar and until, I do not know what was his apprehension. What they are saying, what is the apprehension in the other matter? Both Mr. Bhattacharya and Mr. Trivedi argued. I said, I am adopting both their submission. What is the apprehension of the other gentlemen? What is the apprehension of the ED officers and the CBI officer? An inquiry would be done by the learned judge, special court before whom they are regularly appearing, or an FIR would be registered at Hastings police station. They cannot be arrested. If they are arrested or remanded to custody, either the investigating officer or the judicial officer who are remanding them goes, as per the judgment of the Honorable Apex Court. Only a notice would have been issued, just like Mr. Bhattacharya's client has issued. What was the apprehension? And very innocuous, passed any order. What was the order she was seeking for? This protection could have been given by this court only, definitely, if the application was in other form. The application filed by the ED, I am saying with deepest of the humility, was not maintainable. The learned judge ought not to have entertained it at the first place. Yes, the learned judge, perhaps if the prayers were modified and the proper parties were made to appear before him, would have relegated to either a 482 bench or a court taking residuary matters. So far as this stalling of the complaint filed by me, I am taking objection to that. Yes, definitely. I could not have, these orders could not have been passed behind my back. This is not the judgments of what Mr. Bhattacharya is relying on. Bhattacharya is relying on judgments where during the course of investigation, the accused has no right of hearing. Here I am talking about, before your lordships, the right of an accused, the complainant, who has set the ball in motion. The ball was not at all set in motion when they approached the court. Neither FIR was registered nor the learned judge has taken any steps. Before that only they came. He was referring to some Bengali Bengali phrase in English. But because of live streaming, he could not say Thakur ghore kere ami to kola khaini. Before the child is born, he has come for admission in the school.
Yes.
No, the accused, the de facto complainant, even if your lordship knows, I need not say your lordship, it was not there. It was first time came from the, we say it as a judgment law, that the de facto complaint has to be heard at the time when the court is taking a view contrary to the prayers of the de facto complaint, whether the police files an FRT. Here he is giving a total stop to the so-called inquiry by the learned designated court, as also if in the alternative by the police.
Petition affected person had to have big picture. De facto complaint. Affected person has
Well, who will decide this, that my complaint is baseless, totally out of falsehood to take revenge? Well, the writ, I'm so-called, I am also a trespasser to your lordship's jurisdiction. I am told in a writ petition, your lordships cannot pass any order without hearing the affected party.
We need not.
So you compare this with the PMLA.
Doesn't give a separate criteria. No,
Very well.
Mr. PMLA,
Trivedi-
I am telling your lordships, we are speaking about two independent penal code offences.
Yes.
One I am alleging against the CBI officers and the ED is saying I am trying to threaten the investigating officers so that the course of investigation is altered to my sweet will or to the interest of somebody else. These are two distinct offenses which has got nothing to do with the.
Yes, I get it. I would like to hear Mr. Dwivedi.
My lord, not today, my lord, because my lord.
I'll finish it up today, please.
My lord, as far as this application is concerned, my lord,
Possibly the arguments,
first application, my lord.
the
we
arguments
have-
that
we
you
have-
made
we
in
have-
the other matter will apply here also.
No, my lord, there are certain technicalities which have been raised, my lord, which needs to be dealt with, my lord, because I have got factual answers, my lord. But my learned senior friend is now
Very well.
technically,
Very well, I'll hear you.
he is on a technical issue.
You want it
He is not
tomorrow?
on facts. He is
You
on.
want it tomorrow or?
My lord, tomorrow, yes, my lord.
Tomorrow I have some
Mm.
difficulties. my lord,
You
because
can continue with your submission today. What you have got to say?
my lord, the last submission made by my learned friend,
Yes.
dear friend, that in the writ proceedings, who is the essential party? What's my writ, my lord? Is the Abhishek Banerjee or Kuntal Ghosh is the essential party in my writ? Then, my lord, the writ petition filed by me, my lord. Then, my lord, they have to admit that they are involved in the corruption.
By the way,
Especially
ED
in
is
the
not a
corruption.
party here.
ED in a pursuance of a order passed by Honorable Justice Abhijit Gangobadhyay, my lord. Sorry, pardon me, my lord. Pardon me, my lord. In a Setabuddin matter, my lord, every matter, my lord, in connection with education scam, ED is the party added.
Is it?
14, yes, my lord.
Where
14
is that
December,
order?
14 December order, my lord, passed in Setabuddin matter, WPA number 13700
Get
2020.
me a copy,
Yes,
please.
I will supply
Very
the
well.
copy, my lord. So, my lord, my first limb of my submission is that, my lord, the writ petition, in my writ petition, neither Abhishek Banerjee nor the Kuntal Ghosh is the essential party. Because, my lord, why, my lord? In a writ proceedings, my lord, first, my lord, they ought to satisfy the court, the cause of action arose.
Very well, that I.
So, cause of
understand they are
action not yet
essential
arose.
parties.
Number one.
Mhm.
Number two is that, my lord, they are not the essential party in my writ proceedings, because without them, the writ proceedings is not finally adjudicated. That is not the case. So they are not neither the essential parties nor the cause of action arose. Now, my lord, the CBI, my lord, issued the notice under section 160 of CRPC. What is the 160 of CRPC? A police officer can
But
call.
that was issued in respect of the other matter. In this matter, what you've got
No,
to
no,
say?
my lord. Somen Nondi matter in connection of the.
Oh,
CBI.
there are two applications over here. One is 3, 4 and 5, 6.
3,
We are-
4, 3, 4 regarding Kuntal Ghosh.
We are hearing this.
I am doing the writ petition.
Yes.
Somen Nondi, I am.
Yes. But the
This-
notice that was issued was
In
respect
connection
of-
with Somen Nondi.
Oh, but then in favor of somebody else. Maybe in connection with this writ petition, but in favor of somebody else, not in favor of the applicant here.
Malal Abhishek Banerjee. I'm answering both. In Abhishek Banerjee 5 and 6 and 3 and 4.
But Mr. Bhattacharya has already answered.
Yes, yes. But my learned friend says that I'm the essential party.
Separate from, this is separate.
Yes. I conjointly answer the both parties submission. The Abhishek
Other
Banerjee as well as
already
Kuntal
answered.
Ghosh matter.
Other already answered. It is only here. Other already answered. It is your submission over here.
My submission is that, my lord, neither the Kuntal Ghosh
They are
nor
not
the
essential parties.
essential party cause of action not arose
Yes.
regarding Abhishek Banerjee, because 160
Yes, yes,
CRP.
very good.
So that's my respectful submission, my lord. So they are not the essential parties. So kindly cancel all.
Very well. Anything further? Already is there.
No, insofar as my lord Abhishek Banerjee is concerned, I had indicated that notice was issued under RC case number 6. Now, insofar as this Kuntal Ghosh is concerned, now the CBI filed a petition on 17th of April 2023 before the learned judge CBI court number 1 to accord permission and for interrogating Kuntal Ghosh at the premises of the Presidency Connection home. This was also in connection with the same RC case. Now, accordingly, my lord, we went there to interrogate on the 19th of April 2023 at Presidency. But he told that he has also filed a special leave petition against the order passed by the Honorable Justice Gangobadhyay. And
he said that he has heard from the news that it has been stayed. So we had to come back. So insofar as this gentleman is also concerned, in his case also interrogation efforts to interrogate him were in connection with the same RC case.
And you will issue, possibly you will issue fresh notice?
Notice we have to again approach the court to interrogate, go and interrogate him. Now, he also filed a special leave to appeal.
So that is also disposed of?
That is also disposed of. So essentially, my lord, I understand, as I understand, my lord, there is no fresh registration of FIR. He is an accused in connection with which his interrogation has been undertaken. As such, in view of the judgments as cited by me, my lord, in the previous application, my lord, the same will be applicable.
Yes.
They are all, my lord, connected with the same, my lord, RC case, my lord.
So it is only Mr. Divedi remaining tomorrow?
Yes, my lord, my lord, only with.
You have finished.
So, my lord, as I said, my lord, all my submissions are with regard to Mr. Roy's application, my lord.
No, but then you submitted something.
Only, my lord, the point which was common to can 5 and 6.
So
Only
you
the
want-
point.
Yes.
I'll take a bit of time.
How
I'll-
much?
My lord,
Start today?
my lord, I can finish today.
Oh, then that's good, please.
Then,
Yes.
my lord, Mr. Trivedi, if he wants, he can reply to it also.
No, it's a technical point. I'm a capper. I have to take instruction of the component.
So, my lord, the lordship kindly takes the order of which recall is being sought. Now, my lord, your lordship has seen that at internal page 9, my submissions are recorded, but my lord, kindly do not take me amiss, but it's only briefly recorded. My lord, my submissions with regard to this was that, my lord, my case here is very simple, my lord. I have received a complaint by an under trial prisoner. Now, my lord, in my submission, there is no reason why this complaint should be thwarted and I should not be allowed to investigate into the complaint which has been received by the Hastings PS. Now, my lord, proceeding to my submissions which has been recorded, my lord, your lordships will find that this entire order. Now, my lord, certain submissions have been recorded and certain observations have been made, which, my lord, all my learned senior colleagues have already placed, that they are beyond the pleadings in the can, beyond the writ petition, and some are even beyond the submissions which have been made before the court preceding to that paragraph being recorded. Now, my lord, for example, my lord, taking cognizance of certain things, like, my lord, I believe, my lord, if my memory serves it right, my lord, at internal page 7, at paragraph 8, I think, my lord, yesterday Mr. Dotto was placing this paragraph, but I am only pointing it out that how extraneous considerations have come in. My lord, taking a part of the complaint, my lord, the entire complaint has been placed before your lordship, my lord. Now, my lord, I'll only briefly take your lordship through the complaint, which I have also gone through and my officers have also gone through. Now, my lord, this paragraph 8 is completely extraneous to the topic. My lord, whether someone can laugh or not laugh, whether a medical expert is required or not required, my lord, this particular thing is completely extraneous to the consideration. My lord, then page 8. The concluding part of paragraph 10. This matching tune raises serious doubt. This part, I am again reading, not reading it out. This, as far as the complaint which I have received, I am not on the larger aspect of 7907 and 9979, which is before the entire writ petition, because this application is not about the entire writ petition. The issue is that an under trial prisoner has alleged custodial torture. To that extent, this concluding part of paragraph 10 is completely extraneous. Then, my lord, page 9, paragraph 14. This exaggeration and embellishments I hold are also matters to be taken note of for further investigation by the investigating agencies. My lord, this, my lord, in my humble submission, my lord, this is a travesty of justice, because
My lord, no one can be the judge of their own cause. My lord, a complaint is being made against an investigating agency for custodial torture, and the honorable judge, my lord, direct that same investigating agency to cause an inquiry onto that complaint and furnish a report along with video recordings. My lord, allegation against me, I will come on the next day, and it is presumed that I will say, yes, I have committed that. If I knew that I have committed that, I would have lost that complaint myself. But I cannot understand, how a person against whom an allegation has been made, whatever may be the allegation, that person can investigate into that offense at all.
But with the deepest of humility, I have not been served with the state's recalling application. I understand.
I have not filed it, but it does not mean that when, for example, when an appeal is filed before the division bench, my lord, all the parties have a right to make submissions. But on that day, I need these similar submissions, and Mr. Bhattacharya will remember that I also made the submissions that if this superintendent of the jail is being directed to bring the CCTV recordings of the prison, the investigating agency against whom the allegation has been made, they should also bring the CCTV footage. That complaint was, that submission was made by me, but it is not gone down in the order.
Which submission?
My lord, your lordships will find two parts with regard to video. One is, my lord, internal, the page 12, 19 Roman 3. 19 Roman 3 speaks of ED and CBI are directed to file report of their investigation into this matter. This is my first part, that no one can be the judge of their own cause. Next is that if necessary with video recordings, that is video recordings of investigation into this matter. This matter is the complaint of Kuntal Ghosh. Then Roman 5. The CCTV footage of the Presidency Correctional Home shall be preserved for the period from 21st March to 6th of April, that is so and so, and the register of the visitors in original is to be produced by the Superintendent of Presidency Correctional Home for the above period before this court on 20th April 2023. But here my submission before the Honorable Judge was that I will bring the CCTV. I am not agreed by this part. But the similar CCTV of the interrogation of the CBI should also be brought, and the ED should also be brought, because the allegation is that during interrogation, these things have happened. If your lordship kindly takes the compilation of Mr. Trivedi, which I do not have the copy of, my lord. But I have the complaint separately, which I had produced before the Honorable Court, and I believe that it's part of the compilation. Your
complaint?
No, my lord, I had produced the complaint of Mr. Ghosh before the Honorable Court.
Right.
That on that day, the Honorable Court directed that complaint to be circulated to all the parties. But that today has been filed by Mr. Trivedi by way of a compilation.
Yes. Yes.
Complaint of Mr. Kuntal Ghosh. Page 4 of the compilation.
Yes.
আচ্ছা তো compilation থেকে এক জায়গা থেকে দেখলে সুবিধা হবে.
Yes, yes.
Yes, my lord, kindly, my lord, I am sure, my lord, it has been placed, but only some parts, if I may only place, my lord. আমি so and so, but after the struck off portion, আমি এতদিন ইডির ভয়ে আমি আমার মনের সামথিং কথা কাউকে বলতে পারিনি, কারণ ইডি ডেপুটি ডিরেক্টর রামদিন ডাগার আমাকে ভয় দেখিয়ে রেখেছিলেন যে আমি বাইরে কাউকে যদি বলি তাহলে তারা ইডি আবার আমাকে মিথ্যে মামলায় ফাঁসিয়ে আবার পিসি নেবে এবং তখন ভয়ঙ্কর ভাবে মারবে এবং 21 বছর জেল খাটাবে, ও আমার স্ত্রীকেও গ্রেফতার করবে ও জেল খাটাবে। আমি 21/3/2023 তারিখে ইডির হাতে গ্রেফতার হই। দেন so and so recovery, so and so এবং বলেন so and so অভিষেককে কিতনা পয়সা দিয়া, আমি বললাম 1 টাকাও দিইনি। উনি তখন বলেন যে বল না হলে তোকে ও তোর বউকে অ্যারেস্ট করব। আমি বললাম মিথ্যে কথা বলতে পারবো না, আরো গালাগালি খেলাম, আবার আমার মাকেও অপমান করলো। 20th January 23 রাত 7টার পর বিজয় কুমারকে ফোন করার যে কোনো কেউ একটা ফোন করে বারবার বলছিলেন আমি অভিষেক ব্যানার্জির নাম বলছি কিনা। কিছুক্ষণ পর ইডির টিমের একজন বাঙালি সিপাই ছিল বিশ্বজিৎ নামে, সে আমাকে বলল শুভেন্দু অধিকারী ফোন করেছে, এবং পরে সেই কথা রাতে বিজয় কুমারকেও আমাকে বলেছিলেন। Then my lord kindly takes কোনটা দাগ দিলাম রে? Yes. Then my lord, the next page, which is internal page 4, my lord, handwritten 4 is there at the top. No, my lord, all the pages have a date at the top and a handwritten page number also. আমাকে একটু তোমার কম্পিটিশনটা একবার লিখলে খুবই আমি জাস্ট পেজ নাম্বার
This is a complaint lodged before whom?
My lord, this is a complaint before the Hastings PS, my lord.
Hastings PS.
My lord, your lord, in the compilation, your lordships will kindly take page 23. Page 23, my lord.
23 is absolutely illegible.
My lord, may I read, my lord? My lord, from
What do you want to show? You please tell me.
yes, my lord, what I want to show is that this page, along with some other pages, my lord, makes specific allegations of custodial torture and torture during investigation, along with pinching, my lord, this, my lord, পেটের চামড়া বারবার টেনে ধরা হতো, etc. my lord. And my lord, there's other allegations which I'm sure my lord others have already indicated to lordship, and honorable judge has also made note in his lordship's order. But the point I'm trying to make is that, my lord, when I received the complaint at the Hastings PS, my lord, when these complaints, I asked this question to myself, my lord, are so outrageous, my lord, so unbelievable that it can never happen. And it has never happened, it may never happen, and in this case also it has not happened, that I should be debarred from investigating into the complaint. That is the point I'm trying to make, my lord. This complaint, my lord, in my humble submissions are not
Very well. This is
that
not
outrageous.
arranged by you. So why will all these things be taken into consideration?
My lord, it is, my lord, my investigation which is being thwarted here.
Challenge the order.
Very well, my lord.
Anyway, Mr. Dwivedi, tomorrow.
I am beseeching your lordship because you know there is factual aspect, but the submission of my learned senior friend is on the technical aspect. What he's trying to impress upon my lord, that the jurisdiction was different. Two offenses have been claimed. If we come, whether in a writ petition, ED can come for salvation of their officers. First point made. Secondly, two offenses. If we have come that they have alleged certain things, that is a cognizable offense. Then he's coming into it that what he has alleged is also a cognizable offense. Now he is saying that it would have been governed by 41A, which is not there because what has been alleged is more than 10 years because extortion of. So, my lord, all these aspects need to be gone into in details because I want to submit it before my lord, not in piecemeal within 5 minutes. I don't want to hurry with my argument because this, my lord, I want to put a death nail on that particular argument which has been forwarded by my learned friend on technical ground itself, my lord. So unprepared, my lord, I don't want to address my lord. My lord will kindly give me 1 more day's light to see, my lord, and I shall rest my argument.
1 more days means
Light, yes, my lord, I will rest my argument tomorrow because that is the only aspect which I am going to argue upon, my lord. Others, I have.
Otherwise, everybody is over.
Yes.
Reply them over.
আবার reply কিসে?
আমরা reply দেবো না after you say.
No, Mr. Rai's submissions was essentially in reply to what we had submitted in the previous petition, my lord. Both are being heard together. Otherwise,
I don't have any.
Nothing more to reply also. Possibly you have made your arguments very clear.
বলুক আগে তারপর।
my lord, the submissions of the CBI will be, my lord, same, my lord, in both the cases.
Heard detailed submissions made on behalf of all the parties. Learned advocate representing the Enforcement Directorate. seeks time to conclude the matter tomorrow. Conclude argument tomorrow. Stop. Fix tomorrow.
My lord, in so far as the status report, my lord, has it fallen from your lordship in
Yes,
the morning?
please.
No, my lord, as I was indicating, my lord, I have now revealed already, my lord, what the status is. My lord,
Yes.
notice was issued. Notice was issued that has been kept in abeyance. Insofar as, my lord, the previous applicant is concerned, and insofar as this present applicant is concerned, we had taken order from the obtained order
I
from.
want to get a status report so I can keep it on record.
Very
Both
well.
of you, as to how the proceeding has proceeded from 28th of April when the matter was disposed of by the Honorable Supreme Court till today, whether you all have progressed anything or not.
Whatever progress I already indicated, my lord, that
So that is no progress at all.
I know.
It's
No,
in a
no,
very
thereafter, my lord,
snail's
the SLP.
pace.
SLP was filed, my lord.
SLP was over on 28th of April. Why will you all not take any steps?
No, thereafter, my lord, we were waiting for the assignment and there was a lot of complication, my lord.
Assignment, does it have anything to do with your interrogation or?
No, these applications, initial one, we were waiting
Very
for.
well,
the
you
order.
did not do it, I follow. Acha, fix tomorrow, right? One more sentence. The appearances recorded in respect of the learned advocates appearing for the petitioners in the order dated 12th May 2023 has gone down erroneously. Stop. The correct appearance for the petitioners in WPA 9979 of 2020 shall be, please give, already given. Very well. The department is directed to make the necessary corrections. Rest of the order remains unaltered. Very well, please. Complied. Where is the petitioner? Where is the petitioner? Let me see how you have complied with PPO issued.
May I take your lordship's leave, my lord?
My lord's leave.
Which item number is it?
My lord, I'm the petitioner, my lord.
Oh, very nice. You could have mentioned this matter in the morning or in the afternoon. I could have released your officers.
Yeah, lordship, item number 3 is going on, so I am not.
No, so what? I took up at one matter at 2 o'clock.
Then lordship, kindly see the lordship.
In the morning, had you mentioned, I could have heard it and I could have released your officer.
Your lordship, I am for the municipality. There was a direction of the chairman to be present. He is present, your lordship. But here, lordship directed. Here, let's kindly see the order, lords.
Yes.
Second paragraph, lordship, here the municipally fund, the dues of the petitioner could not be clear. The father of the petitioner was an employee of the Bahrampur municipality who died in December 18, 2011. The mother of the petitioner predeceased his father. The municipality admitted the due of the petitioner as regard area debt family pension. Enough time was granted to the municipality for payment of the due. The same has not been paid till. Of the employee. In the present case, the employee expired nearly 12 years back. The petitioner, being in the hairs of the deceased employee, is yet to receive the terminal benefit. The conduct of the respondent cannot be supported in either total municipality. But here, lordship directed in view of the above chairman, Bahrampur municipality and director of the pension and provident fund to be remain personally present. I am not violation. No order has been given to the me, lordship. Thereafter, 2013 lordship. PPO
What is the due? What is the due right now?
Today, the gratuity and others benefit not disbursed in my favor, my lord. Kindly see, my lord.
2013.
1 minute. What is the gratuity amount here? 1,46,944.
Lordship.
Has this money been paid?
Lordship, kindly see the lordship. PPO has been issued.
No. Only issuance of PPO does not mean that the money has been paid.
Lordship, 2013, not for here.
This is only the PPO, where is the payment?
Your lordship, I'm for the Brahmanpur municipality.
Yes.
Your lordship,
The money you have not received.
your lordship is,
Your lordship, my duty is lordship issue the PPO and gratuity.
I
Amount
understand.
has been paid by the treasury. I
I am aware of it. You issued the PPO in 2013, even in 2023, this money has not been disbursed.
Who lordship?
I will see from whom to recover it.
yes, your lordship, as your lordship is aware that there was an appeal pending because the municipality was shortage of fund. For near about 500 employees were not being paid the gratuity. So then appeal was pending before the division bench. On the last occasion, as it has fallen from the Honorable Learned Advocate General, a solution was given that how much is the due of the municipality taxes from the government offices. It came near about 11 crores and odd. So it was directed to pay that amount by the government so that we can pay off the gratuity. On the last occasion, this is the order, your lordship, where we have been instructed by the division bench to give the dues to the district magistrate, and the district magistrate is supposed to pay off the dues of near about 11.5 crores due to the property tax by the state government, and we are supposed to pay it off to this person. He is one of them. There are more than 500 persons, your lordship.
How much is the due of the petitioner in your accounts?
Your lordship is 1,46,940.
That was on 2013.
Yes, that is without
April 2013 when the PPO was issued.
your lordship. That is the PPO because there is no provision. If your lordship decides to pay the interest, that's a different issue. But as per our record, that 1,46,000 is pending, your lordship. Kindly have a look on this. Your lordship, your lordship,
Your issuance of PPO does not end the matter.
your lordship, the difficulty was,
Money has to reach the employee.
your lordship, the difficulty was that in the writ petition also it has been stated that PPO has not been supplied, and there is not a copy of the PPO attached to the writ petition. That's why lordship has asked that direction, because the petition has failed to put the PPO in the writ petition. Because initially, if your lordship sees the prayer A, it says an issuance of the PPO. Lordship, kindly have a look at this.
Has this money been transferred by the state?
No, your lordship.
Not yet.
The direction was to give submit to the concerned district magistrate. The communication has been given to the district magistrate. There is some exemption. The district magistrate said that some of the properties the government is not supposed to pay tax. That process is on. Kindly give us some time because this order clarifies that part.
Nothing. Not even a day will be given to the municipality.
Your lordship,
Not even a day.
Your lordship, the appeal, kindly have a look at this order once, your lordship.
Whatever is the order,
The
let it
district,
remain.
the direction of the division bench is clear. We have to submit the bills to the district magistrate, and the district is supposed to pay off the dues. And once the dues comes, your lordship, because the dues of the municipality to the gratuities, they are about 10 crores, 10 crores, and the after vacation.
Pay the petitioner.
Your lordship, we don't have, that's the entire difficulty. That's why the more than 100 appeals are pending with the division bench. I'm only paying your lordship to accommodate one accommodation after vacation. Kindly accommodate me. In between, we have already processed the payment. The district bench is supposed to pay by the division bench order.
Was this writ petition filed in 21?
Your lordship,
21?
it's an admitted position from 2013-14. Many people have not been paid. That is short.
Think it's very creditable not to pay?
No, your lordship, your lordship, is an offense was not, because the fund was not there. Now there is a possible solution to that, your lordship. The state government has agreed to this solution. The 11 crores and odd, the property tax, they have said they will pay. We have already submitted the bill. Some exemptions have been claimed by the district magistrate.
I have heard you, but then I am not convinced with your submission.
Only your lordship, I am praying for a date after vacation. In between, we will do what is necessary to do this, your lordship. Kindly allow us this much time because of this division bench judgment. Kindly give us a date after vacation, your lordship.
Are you feed the petitioner?
Your lordship,
Are you going to feed him? No.
the municipality is not in a position to pay. That's why not being able to pay. But there's a possible solution. So I'm only praying your lordship for an accommodation on the opening date of vacation. Let that matter be kept, your lordship.
That much accommodation I'm praying so that this problem will solve, not only for the petitioner. There are more than 450, 500 odd person who's facing the same problem.
Maybe 400 or 4,000. I am concerned with one right now in front of me.
I bow to your lordship.
Several where
I am
you are
only,
defending.
I am only praying for an accommodation, your lordship. Let on the reopening that this matter be kept.
This is what the court is objecting to. Why will it be accommodated? It is there, the person, he has died in 2011. PPO issued in 13.
2013.
Even in 23, you seek time. Why will this leverage be shown to you?
Your lordship, the only difficulty is this fund is a state government fund. Now, in the detailed matter, that if we could have paid your lordship,
Type of obtaining the service from the petitioner or his predecessor in interest, it was not within your knowledge that you have to pay. You are surely
your lordship,
aware of
that is a legal obligation. I'm not disputing that. And I cannot dispute that as well, as it has fallen from your lordship. But I'm only praying for an accommodation because this issue can be resolved, your lordship, because the process is already on. If your lordship have kindly look on the last order passed by a division bench,
pay cost to the petitioner 10,000 rupees. Today itself. Please come.
Lordship, I have one question, Lordship, only for submit before his Lordship. Lordship, director to the Lordship, director of the pension and provision is not available for joint director.
Why is he not available?
But he is not here, Lordship.
Where is he?
Yeah, out of station, Lordship.
Where?
Where, Lordship, in the Bardhaman or where, Lordship, he goes.
Bardhaman or something? Did he not know that there is an order for his personal presence? No, but then the court did not direct the joint director.
He is not available, so Lordship, joint director.
What is not available? There is a court's order.
Court's order, but he is not available here, Lordship. So, Lordship.
Why will he not be available to answer the query of the court?
So, Lordship, I am praying before his Lordship. There are fairly submission before his Lordship. That Lordship, otherwise, Lordship, I am saying that Lordship join. I am praying before his Lordship.
I am taking very serious note of what he has done today.
Submitted before his Lordship.
It's not a matter of fairness, Mr. Boisho. Thing is, there is a court's order. Ignoring the court's order, he goes somewhere else.
But here, Lordship, no, Lordship, he Lordship received that order is there Saturday or 40.
No, 12, my lord. Nobody appear on behalf of state. That's why I am communicating this order, my lord.
But I am not only for
24th of April, this order was passed.
Lordship. I am received for the Lordship 12.
When did you communicate this order?
My lord, 12.
12 the communication.
Why did you wait for so long?
12 received, my lord.
12
I'm
received, Lord.
6 of May, my lord.
12 May I received.
Kindly see my track report, my lord.
Whatever, I am taking serious note of his action. And the court is not accepting the apology.
But Lordship, I am here submitted before his Lordship.
You could not have shied away either, because I would have seen
I am not fairly submitted before his Lordship.
the director of pension, provident fund and group insurance, and the chairman, Behrampur municipality. Where is the chairman? Give his name.
Narugopal Mukherjee, your lordship.
Put it down in a piece of paper and hand it over. Chairman Behrampur municipality were directed to remain personally present in court today, along with a compliance report in support of the payment made to the petitioner. Stop. Learned advocate representing the director submits that the director is not available, and accordingly the joint director is present in court. Stop. It has been submitted that the director is not available in the town. Stop. The conduct of the director cannot be accepted by the court. Stop. The director was bound to comply the direction passed by the court and ought to have appeared before the court in compliance of the direction passed. Stop. The director failed to appreciate the priority of judicial proceedings and left for some other work by ignoring the order passed by the court. Stop. The court accordingly directs the director, director of pension, provident fund and group insurance to remain personally present in court on the adjourned date. Stop. Next. The Learned advocate representing, next paragraph, learned advocate representing the chairman Behrampur municipality submits that due to paucity of funds, the payment could not be made. It has been admitted that a sum of rupees 1,46,940 is due and payable to the petitioner on account of death cum retiring gratuity. Stop. Next. The PPO has been placed before this court. Stop. It appears therefrom that the same was issued on 12th April 2013. Stop. Even in May 2023, the petitioner is yet to receive the gratuity amount as indicated in the PPO. Stop. The fund crunch is the primary issue that has been raised. Stop. The municipality relies upon an order, please show me.
Yes.
Passed by the Honorable Division Bench of this court on 27th April 2023 in MAT 763 of 2021 with IA Can 1 of 2021 and IA Can 2 of 2021. In the said order, it has been recorded that an amount of rupees 11.14 crore is due to the municipality on account of area tax in respect of the state government properties. Stop. The municipality was directed to prepare bills department-wise and to be made over to the District Magistrate Murshidabad. Stop. The bills are to be verified, and after following the due process, the bills will be paid to the extent they are payable under the law. Stop. Next. The municipality submitted that all bills shall be made over to the District Magistrate Murshidabad within 2 weeks. Stop. Next. The municipality has submitted that till the money is supplied by the state government, the municipality will not be in a position to disburse the dues of the petitioner. Stop. Next. Time has been sought for to post the matter after the vacation so that the payment can be made in the meantime. Stop. Next. Though the court is not convinced with the submission made on behalf of the municipality regarding non-payment of the legal dues of the petitioner, but for ends of justice and in view of the order passed by the Honorable Division Bench, the court adjourns the matter till 15th of June 2023. Stop. The dues of the petitioner shall positively be cleared by the said date. Stop. Next. As the petitioner is knocking the doors of justice for quite some time, and he has been compelled to approach this court seeking payment of his legal dues. Accordingly, the municipality is directed to pay a sum of rupees 10,000 to the petitioner in the course of the day to the learned advocate appearing for the petitioner.
Your Lordship,
Or-
by tomorrow, only one.
How will you transfer? Where is the bank account of the petitioner?
My lord, 11, maybe whom, my lord?
Give the bank account number.
Lordship.
It will be forwarded to the bank account of the petitioner.
If by tomorrow it will be done, Your Lordship.
Very well, by tomorrow. Dekhi.
Just a second.
Directed to. কি বললাম? Wait. 10,000 directly in the bank account of the petitioner. This is the bank account number.
Lordship.
Are you sure? This is 2018. Possibly the account number is changed.
Yes. Earlier books, my lord, kindly similar.
When was it last updated?
Wait. My lord,
This is
kindly see, my lord,
2015.
5015240542.
That is the IFC code.
Your Lordship, on the first page,
This is in 2018. Thereafter, nothing.
It is a 2018, my lord, last payment was made, my lord. The pension, my lord.
In the savings bank account number 74201003.
Your Lordship, one difficulty is Allahabad Bank merged. So kindly ask him to write me a letter and give the details.
Number.
Yes, my lord.
Kindly ask him to give me the number.
Number 2, Mr. Das.
Fresh number.
Because the bank has merged already.
বললাম তাহলে ওই নাম্বারটা দেবেন না। To the which the learned advocate for the petitioner shall supply to Mr. Orindam Das, learned advocate representing the municipality by tomorrow. Stop. The payment shall be made within a period of 24 hours after receiving the bank account number from the learned advocate for the petitioner. Stop. Next. The chairman of the municipality shall remain personally present in court on the next date.
My lord, in the meantime, revised pension also issue, my lord. That amount also not disbursed in my favor, my lord. Revised pension also issue, my lord.
Where is that?
Lord,
Revised
Can
PPO?
you see, my lord?
Let me see.
Right now, he is my supply to Smith. Lordship, 2015, my lord. So, देख ताले वो तो order है नाले.
Revised DCRG is 2,220 only.
Lordship. That also not.
Your Lordship, kindly copy me.
Kindly.
আর একটা লাইন লিখে দিন।
With interest, my lord, kindly.
Interest, next day we will give interest to
Lordship,
check the principal. The court is not going away.
Lordship, grateful, Lordship.
Learned advocate for the petitioner has drawn attention to the revised PPO issued in favor of the petitioner under ROPA 2009. Stop.
Petitioner name is there, Lordship.
My father's name was appear, my lord. 15.
The 13
11.
issued in the.
My father was died by 11, my lord.
Yes, the 13, your wife's name is being issued.
No, Lordship, part two, my father, my mother also died.
Same thing. It is the same thing. All details.
2000 name is not there, Lordship, in 15.
Yes.
15 PPO.
He has mistake, my lord.
PPO.
What can I do? What can the petitioner do?
The name is late Ratan Hajra.
Lordship, my
Even
father.
in the revised pension also it's named late Ratan Hajra. It is the same thing. Who says it is late Ratan Hajra's name the PPO has been issued? It is the same thing.
Also.
Verify your friend. Verify.
Shantana Hajra, wife.
He also died prior to his petitioner father died, my lord. 2010,
Right.
2011 petitioner father died, my
See, even the PPO is issued in the wrong name.
lordship. His father name.
Family pension, this lady is gone.
No. Petitioner family pension is getting, my lord,
Acha.
up to 20.
আরে তো এটা
বললাম।
তো নামটা ঠিক করো না, নাম না ঠিক করে তো কিছুই হবে না। আরে নাম ঠিক করাটা
Revised PPO dated 26th of August 2015.
Verify what's in it.
Yes, the amount mentioned against death cum retiring gratuity is rupees 2,220,000 only. Stop. The petitioner submits that the said payment has also not been made in favor of the petitioner. Stop. The municipality is directed to take steps for payment of all legal dues in favor of the petitioner.
And
Take
necessary
back
correction,
this.
lordship. Necessary
Correction
correction.
we will see later on.
What's the, I am verifying the.
Please do verify.
ওই পিপিটা আমি জেরক্স করে দিচ্ছি।